If anybody knows anything, to please contact the Kaipa Police Department.
Don't hesitate, just call.
All right, I want to dig deep here on Rebecca because I'm just not sure about her. Manuel, let's talk here. We know that she had the shiner when she was, it was kind of hard to see in that video, but a black eye was visible on her when they were announcing that baby Emmanuel was taken and that she was accosted in this parking lot. There it is. Thank you to our awesome director, Matt Woolley, for popping up that. Okay, so look at that. That doesn't look fresh, right? You know, we discussed this and we're going, that looks like that might have been there before this incident when the baby was allegedly taken. Manuel, I wonder if Jake Haro was abusing Rebecca as well. When she was standing there with him, she looked terrified to me. And I wondered if she was afraid of what he may do if she speaks out here. Essentially, I'm kind of wondering, is she not the guilty party here? What do you say?
Well, it's kind of a double-sided sword. She is and she isn't. She's a victim first. She's a victim of domestic violence and a victim of, in my opinion, professionally, is Stockholm Syndrome. This man brainwashed her. She was beaten so much that she, did anything to survive for herself and lied for him. And I think this is why she hasn't admitted guilt to anything and she's still sticking to the same original lie. That's something to note right now. But those injuries, as we stated way back in the beginning of this case, Julie, and you and I were both agreeing that she is a victim of abuse and that this is what caused her to lie. And the problem is, I hope she not only gets sentenced, but I hope she really gets the help that she needs, Julie, because truly, she doesn't even fully aware of what she's still doing. Even though her husband admitted to everything, she's still sticking to the same lie that somebody stole her baby. This just shows you how mentally incapacitated this woman is.
Oh, that's a great point to end on. Manuel Gomez, thank you so much for that. I know we have to let you go. You have cases to solve. Thank you for spending time with us this morning. David's coming with us. We want you to do the same at home, please. When we come back, here's what's still to come on opening statements. We are spotlighting the hot car dad trial for defendant Christopher Scholtes. We'll talk about what the jury won't get to hear. Plus, actor Darius McCrary, remember him? He was Eddie Winslow from Family Matters. Well, he's in court representing himself. So how did he do? You got to see the video.
I'm here in special appearance.
Special appearance for who?
I'm here on special appearance.
Sir, who are you specially appearing for?
I'm specially appearing for Darius McCrary.
I'm Vinny Politan. Welcome to Closing Arguments.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
Spelling bees aren't about winning. They're about the journey and how we grow. The Believe Fund provides free enrollment for low-income schools. You can help give kids a chance to participate. If you believe in the power of words, DONATE today.
Welcome back to Opening Statements. Let's talk about what is trending. Actor Darius McCrary finds himself as a trending topic this morning, but for his courtroom antics instead of his popular role on the hit TV comedy Family Matters.
Wow, Haro, what luck. The girl of your dreams just dropped in.
Hey, baby.
Known for his role as playing Eddie Winslow on Family Matters, Darius McCrary stood before a judge earlier this week for some more serious matters. McCrary was arrested in California earlier this month, stemming from a missed court appearance in Michigan relating to his failure to pay child support. But he chose to represent himself during the hearing and even presented this motion before the court.
Based on the fact that the 50th District has completely continued to violate all of my rights, my 4th, my 5th, my 14th Amendment, my right to due process is constantly trampled, and I've figured out why, because under due process clause of the 14th Amendment, personal judgment is void if rendered by the court, which has no jurisdiction over the defendant. That's Penmore versus Neff, 95 U.S. 714, 24L, ED 565, and Michigan has no jurisdiction. Before we proceed, we need to establish jurisdiction.
All right, so let's break down the courtroom conduct, shall we? Let's get our guest's thoughts on Darius McCrary's initial statement and that motion we just saw he made before the court. Let's bring back in attorney David Bruno and welcome in entertainment commentator Holland Reed. David, I want to start with you here, please. He's not a lawyer, but he was really good spouting out, his rights and citing amendments and due process. What'd you think?
Yeah, I'm making a special appearance for David Bruno on this one. And that is, listen.
We're going to get to that.
I mean,
exactly.
that's a little odd, right? But I'll tell you what, he was hitting the points. He actually was hitting the points on extradition. Because anytime we talk about extradition, what first has to be established is the jurisdiction of the original court, that the defendant is the actual person in the complaint or warrant, and then there's a process. It's the extradition process. So there's an old adage that says, he who represents himself as a fool for a client. But Eddie here didn't do a bad job, honestly.
Yeah, I was impressed. I mean, he definitely researched the issues. I was impressed for a non-lawyer to come in there and make that argument to the judge. I thought he did a fine job. Holland Reed, we want to know what you think, please.
Julie, you're going to know what I think, because this is the case of, are you delusional or are you actually really smart? It's like, stay in your lane, play your part. You're an actor on TV, but maybe not. You might want to be careful when you're defending your life, your livelihood, and your rights. But I will say, to David's point, I agree with him. It was cringy to watch, but also very, informative, because he did know what he was talking about. I will say, though, when the judge told him to get a lawyer, I was like, yeah, maybe do that, only because he was coming off a little, not necessarily unhinged, but you just want to make sure you have the degree behind you when you're defending yourself. So, I mean, he did come with the facts. He came with the facts, but still, nobody wants to see it. It was a little cringeworthy, but not terrible.
You're right, Holland. Yeah, it was really not a bad start. That's a good way to put it. It was not terrible. Yeah. A decent start for a non-lawyer representing themselves in the courtroom. So then things changed a bit for him in the courtroom. So he had this to say while responding to the state's reply to this fugitive complaint that was filed against him. Let's watch.
So did you care to respond before the court rules on your motion?
There's no injured party, Your Honor. Oh, I'd like to also say I'm here in special appearance.
Special appearing for who?
I'm here on special appearance.
Sir, who are you specially appearing for?
I'm specially appearing for Darius McCrary. I'm here pro per special appearance.
And when you say you were here pro per and special appearance, who are you?
I'm an authorized signatory thereof of the estate and the executor of the estate.
Who's the estate?
The McCrary estate.
And your name is?
Darius. I'm the authorized signatory thereof, Darius McCrary.
And your name is?
Darius McCrary.
Oh. So we're asking, should Darius McCrary act as his own attorney? We know he's an actor. Holland Reed, you're an actress. I want you to weigh in first on this, please.
Julie, I feel like from now on, I just want to be here on a special appearance. I just want to just speak in third person. I've never heard that, and you as a prosecutor, I'm sure, like I've never heard anyone stand up and say that about themselves and speak in third person. I think that also is kind of like where Hollywood can really kind of remove you from reality. You're in a courtroom. You're not on special appearance. You are yourself representing yourself. So again, cringeworthy, not terrible, but very interesting to watch.
Yeah, definitely. You know, the first time I saw it, David Bruno, I thought, oh, he doesn't sound well here. What is going on? It's like a strong start, and then what is happening here? But then when I watched it again, I thought, is he confused thinking that he wants to put his appearance on the record? You know, like we say, you know, good morning, Julie Grant, representing the Commonwealth of Pennsylvania, Your Honor, you know, and I introduce myself. Is that what he's doing? I want to know your thoughts, David.
Oh, I'll tell you, who knows what he's doing, honestly? But this is a child support case. He's not paying his child support. And then also the prosecutor made an argument that he's a flight risk because he was arrested like at the border of Mexico. And the argument is that he's developing real estate in Mexico, and that's why he was down there. I mean, round and round and round we go. How about just pay your child support? Okay, then you can get out, and then you don't have to make special appearances, and you don't have to do all this legal work that you have no idea what you're doing.
Right. Yeah, it's really sad. I mean, so this warrant's issued, and he gets picked up on this warrant. And so that's why the challenge of, you know, the jurisdiction here. And he's going, wait a second, I'm in California. What's up with this in Michigan? And so he was right to question things. But yeah, like you said, David, if he wasn't paying, and we don't know, want to be clear on that, he needs to clear up his problems if there are some outstanding bills that he owes. Perhaps he should go back to acting. I loved him on Family Matters. I love that show. Who else was a TGIF kid growing up? Holland, David Holland? Yeah, I mean, Family Matters. We lived for that, didn't we? What'd you say, David?
Did I do that?
Did I do that, Urkel?
Did I do that? Yes.
Right? Holland, what do you think? Do you think he can get back into acting at this? No, you're fine. I mean, what do you think? We know he was a big child star. Do you think he should maybe think about going back to work?
Yeah, you know, Julie, it's funny that you said that because the first thing that came to mind was Lindsay Lohan. It's like we just wanted her to get back in her groove, and her redemption stories in Hollywood are always the best stories because when you get off kilter, when you kind of like lose your way along the way, especially coming from being a child star, it is hard to get back on the horse. But when you do, and we get to see people working their magic, we love that. We root for that. No one is looking at, you know, Eddie Winslow and saying we want him to fail. We want to root for him. So I think he needs to go back and find a job as a lawyer on television. What are the shows that are out right now? I feel like he could probably play one very well.
He should. You know what? There's a new one premiering tonight. I can't wait to watch Boston Blue, Donnie Wahlberg's show. You know, maybe he could be a lawyer on that one. That would be great. Yes. You're right, Holland. He did a fine job in that first part of the hearing. Was really good. Eddie Winslow, loved him as an actor. Darius McCrary, we hope you get things on track. That's all for this segment. Holland Reed, thank you so much for joining us this morning. We'll see you soon. David Bruno, stand by. We're going to hit a break. When we come back, here's what's next on Opening Statements. Chris Scholtes, the defendant in the hot car death trial, which is set to begin in a couple of weeks. We're talking about his case this morning because one of his big secrets is going to be safe from the jury. We'll tell you what it is on the other side of this break. And Bianca Ellis found guilty for murdering 3-year-old Julian Wood. This was the grocery store stabbing case that we covered extensively. Guess what? Her attorneys are joining us live on the show this morning. Welcome back. This morning, we're giving a voice to victims like 2-year-old Parker Scholtes, who died in a hot car last year. This is her father's preparing to causing her death. Christopher Scholtes is facing a first-degree murder charge for beautiful Parker's death. He's pleaded not guilty, and his trial is set to begin on October 27th. This week, the judge ruled that information that Scholtes was searching for porn online while little Parker was in the hot car cannot be shared with the jury. That is a significant win for the defense team. Scholtes told police officers that Parker was sleeping in the car, so he left her there.
She was sleeping in the car, and I had the car on. But it has a sensor where every 30 minutes or so it'll turn off if you haven't moved. I swore she was in the house playing with her sisters like she always does.
Now, the judge also ruled that witnesses can't mention that Scholtes searched for porn on his PlayStation. Okay, so let's talk about that right call. Let's bring back in attorney David Bruno and welcome in parenting and family relationship expert Dr. Sue Kornbluth. Good morning to you both. So, David, this search for pornography, nobody is going to know about this. Witnesses can't say it. The attorneys can't say it. Is that the right call by the court?
I'm scratching my head on this one. I mean, it is extremely probative as to what he was doing, especially such deviance on the device. With that being said, though, when we talk about appeals on these types of issues, we're talking about bad character evidence. We're talking about other acts and things like that. It's one of the most frequently issues that are reversed. So it's being sanitized. The court is not just removing it altogether. The prosecutor is still able to say that he was on his device and he was doing leisurely activities. So I think it's one of those situations where the court's probably sanitizing it to protect the record moving forward. Because this is a very, very strong case for the prosecutor in a sense that he's on his device, but there's also prior incidents involving other children where he was warned by not only his wife, but also police. So I believe I wouldn't have excluded it personally if I was on the bench for this particular issue. But with that being said, sanitizing it is a little protection for the record moving forward.
Yes, and we're going to get into those other incidents with Dr. Sue in just a moment. David, want to change the facts for you a little bit because I had this discussion with my colleagues and I think we were really getting somewhere. We noticed that the language in all of the documents says he was searching for porn. It's very distinct what police are saying, searching, not necessarily watching. Big difference. Now, if there was information that he had been watching pornography for some period of time while that beautiful little girl is in the car suffering, do you think that then the court may have said, well, this should come in because this is part of the series of events that led up to what's in question?
Yeah, I mean, there's probably a gap there as to the conduct during the searching or the, watching or whatever, right? I'm sure he didn't come out and talk about that in his statement and his interrogation. With that being said, certainly any one of those sort of hypotheticals, Julie, in my mind, is probative, extremely probative. And just because something's probative and prejudicial, at the same time, doesn't mean it gets excluded. There's a lot of things that are probative and prejudicial that come into jury trials.
Isn't that the truth? David, thank you for that. Dr. Sue, I want to turn to you about some of the previous incidents with Scholtes leaving kids in the car. Police say that an ambulance rushed little Parker to the hospital. Mom, Erica Scholtes, texted her husband, quote, "I told you to stop leaving them in the car. How many times have I told you?" Scholtes responded to her, "Babe, I'm sorry." Then Parker's mom texted, "We've lost her. She was perfect." Christopher Scholtes writes, "Babe, our family, how could I do this? I killed our baby. This can't be real." Dr. Sue, your thoughts on the family dynamics here?
Yes, good morning, David and Julie. I think what was going on in this family was what I would call abusive parenting style. And what that is, it can be physical, it can be emotional, it can be sexual. But what I think we're focused on here is neglect. And what keeps coming up for me, Julie, in this family dynamic is if the mother knew of his past history and she also knew that this was something that happened before, why leave the child with him again and again? That sets up a pattern here that he wasn't safe for her to be around. So that's one of the first questions that I would have here. The other thing is, you know, sometimes parents, they do forget that their kid is in the car because it's like habit memory. But once they get in the house and they realize they're not in there, they run out and get their child. Here, he sat down and was doing things, whether it was porn or whatever it was, his mind was not on his child. It seems that it was on himself. So I think there's a pattern here of abusive parenting. And I think that's what needs to be focused on here. We must put our children first before anything else. That is our job as a parent.
Amen. Dr. Sue, let's take a listen to Scholtes speaking with police when he's asked about just how long little Parker was in the car.
How long was she sleeping in the car out there?
I want to say it was no more than 30, 45 minutes. And I don't think her air was off that entire time. I think there was a time in between. I had checked on her last. It was still running. She was still sleeping. And then when I went back out, the car was off.
Okay, so we know it was really more like 3 hours that Parker was in that car. And we know that there were complaints made with Chris Scholtes' daughter from another female partner. And they were deemed to be unfounded by Child and Family Services. And the daughter, though, was still moved into the care of mom, even though the complaints weren't given any validation by the state. Still, the child went with mom. Dr. Sue, what does that tell you, please?
Well, right, Julie, they're allegations, and sometimes that happens in high contentious relationships that will be, filed. But what I think happened here and what we're seeing and what it tells me, there's a pattern of something going on in his parenting style. And again, it's neglect to me. It's abuse. It's things that I think they're going to use in court to prove that there's a pattern here of him being, having abusive behaviors towards his children. So when we're looking and, psychologically at these things, we're looking at patterns of behavior that can establish that possibly abuse has happened. The biggest thing, again, is that he did not go out to that car after an hour and a half. So did he just forget that he had a daughter that was sitting in the car? And to me, it's just neglect, neglect, neglect.
Yes, I think he should have taken the deal. He was offered a plea to second-degree murder to do 25 years. He rejected that. So now he's going to trial on charges of first-degree murder. We'll see how that works out for him. Big thanks to David Bruno and Dr. Sue Kornbluth, and thank you at home for being with us. We're going to hit a break. When we come back, coming up on opening statements, we have a case in Cleveland we're going to take you to. But first, we want to remember the victim, in this case in Arizona. Show you beautiful Parker Scholtes' picture. This little angel had so much life ahead of her. Everyone said she always had a smile on her face, a joyful spirit. Gone way too soon. We'll be right back.
Donna Adelson was part of a conspiracy to kill her former son-in-law, Dan Markell.
He's not going to survive.
Oh my God.
Dan saw Donna as dangerous.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific. And during the finale, don't miss an exclusive preview for the new season of Interview with a Killer. Only on Court TV.
Now for what's tipping the scales of justice this morning, we're focusing on Bianca Ellis. This woman was just convicted of murdering 3-year-old Julian Wood by stabbing the toddler to death in the parking lot of a busy grocery store in the Cleveland area. Let's take a listen to her defense attorneys, Fernando Mack and Carlos Johnson, in the courtroom.
She acknowledges through her lawyers, whether she testifies or not, that she's responsible for the murder of Julian. She acknowledges through her lawyers that she's responsible for the attempted murder of Margot. There's no running away from that. That's not what this trial is about. The evidence will show, though, that it is obvious that she was insane at the time of the offense.
This is a sad sequence of events that somehow it could have been prevented, but it wasn't. So we're stuck with what happened. And what happened was a tragedy. And it wasn't because she wanted to kill someone. It wasn't because she set out that day to kill someone. She told you, and you're gonna hear in the video, she goes, I didn't think I would throw my life away like this. I had other plans.
Now, I said it before, I'll say it again. One thing was for sure in that trial. Bianca Ellis had great counsel. I was very impressed with those attorneys, and that is why I've invited them on the program this morning. I want to welcome in now attorneys Fernando Mack and Carlos Johnson. Good morning to you both. And might I just start by commending you on a very well-tried, difficult case, and you two really shined. So thank you for coming on the program and talking to us after that verdict the other day that many of our viewers thought really could have gone either way. So I want to start with just your reactions to the verdict. Fernando, I'll begin with you, please.
Yeah, you know, Julie, first of all, thank you for having us and good morning. We respect the jury's findings in this case. We know that they worked hard. We know that it was a difficult set of facts. There's nothing more powerful in the business that we do than the death of a child. And we knew that that would be a huge obstacle. And we spent a lot of time in the beginning of the case and at the end of the case talking about that in order for them to understand, to get to the next point. But I will say this, they don't have the opportunity to understand that somebody that's found not guilty by reason of insanity, they don't just walk back out into the streets. They ultimately end up being hospitalized for a very lengthy period of time, sometimes as long as it takes for someone to be incarcerated. So that's a little bit of a disadvantage, but we respect their verdict, but at the same time, we disagree with it.
Understood, and appreciate you sharing that with us. That's something we talk about often on this program, about how jurors might think, oh gosh, if I let someone go and don't convict them, then they're going to be walking among us and present another danger. And as you noted, Fernando, just not the case. Carlos, I want to go to you. Your reaction on the verdict, please.
Well, again, we respect the process. It was a sad case all the way around. I mean, a young child died, I mean, for no reason but for her mental health. And I think the jury possibly got it wrong. I think our doctors was correct. I mean, she's a sick woman. She's been sick for a long time. And Fernando and I had an opportunity to meet her when she was at one of her worst points. And once forced medication got involved, she was a totally different person. I mean, totally articulate, a sweet young lady. You would never think she could harm a fly if you met the lady on medication.
That's interesting you say that, Carlos. A follow-up, please. As we were looking at the video there, and I made this remark on the program, she looked medicated to me when we were watching her at trial, very different than how she looked at some of the pre-trial hearings. And I believe early on, it may have been before you both were appointed to the case, very early on. I know you know the video where she was seen like kind of smirking at the camera. It went viral. It was a video that national outlets picked up, and everybody was saying, wow, is this an evil woman? And then you contrast that video with what we see here, and she looks so calm and so subdued. Carlos, can you tell us, was she medicated throughout the trial?
She was. We took breaks to make sure her medication remained on schedule. You wouldn't have noticed, but the judge synchronized breaks for the jury so she could go down into the jail to make sure she was administered her medication. And she was heavily medicated. She didn't communicate much with us, but she did communicate.
Mm-hmm. Fernando, tell us, what do you think the biggest misconception about this case was?
Yeah, I think that we live in a country still where we have to educate people about mental health. And, you know, the schizophrenia. She has been mentally ill since she was age 22. And I think that a lot of jurors believe that someone with mental illness still has the ability to commit these crimes even while they are psychotic, having these episodes. And I just think that it's just a lot of misunderstanding, misinformation as it relates to mental health.
Sure. Carlos, let me ask you, please, on October 27th, when you and Fernando go with Bianca to her sentencing, what do you plan to ask the judge for?
Well, we have a ton of information we want to share. He already heard most of the information regarding her mental health, her struggle on and off medication. Obviously, we're going to ask for the least sentence that he would impose. We don't know where he might be. He has a long range of sentencing up until life in prison, which is on the table. And we're worried about her mental health, that they maintain her meds compliance while she's in an institution or prison, because we don't want her to go back to that state that you see on the screen where she just is out of it.
Sure. I wondered if there might be a specific prison you have in mind that perhaps has programs for mental health for someone like her. We just have a couple of seconds. Is there a place?
The DOC decides where they go. They'll do an assessment once she gets to Marion Correctional Institution for Women, and they'll make a decision where she should go for the rest of her sentence.
Understood. Attorneys Carlos Johnson and Fernando Mack, thank you both for taking time out of your busy schedules to come on the show with us and give us some insight into the battle that you all were fighting. You did such a fine job for Bianca Ellis. Not an easy job to do. We want to acknowledge that. Thank you both kindly.
Thank you, Julie.
We're going to hit a break. When we come back, we're going to go to Massachusetts for the Irish firefighter rape trial. We thank you for watching opening statements this morning, and much more is straight ahead. Court TV Live begins right after this break.
Medicare Part C plans are available now. Plans may include benefits you are not receiving with original Medicare alone. Call today. You don't get a new Medicare Advantage plan automatically. Call now to enroll during the Medicare annual enrollment period. If you already have a plan, call to find out if any changes have been made to your coverage for 2026. If you only have Medicare Parts A and B, there are 3 things you should do. 1, call the number on your screen. 2, give the licensed insurance agent your zip code. 3, see what Part C plans with benefits are available to you. 1, 2, 3. It's that easy. Medicare Part C plans may be available with benefits you are not receiving with original Medicare alone. The Medicare Benefits Helpline is accepting calls right now to see what 2026 plans with benefits are available to you. Everyone on Medicare can call today for a free Medicare benefit review. The call is free. There's no obligation.
Call 800-816-0106. That's 800-816-0106. 800-816-0106. Call now.
Hello. Today we are talking about Medicare Advantage plans, also known as Medicare Part C. If you have original Medicare, you have Medicare Part A and Part B. Part A covers hospital stays, while Part B covers medical visits like seeing the doctor. A Medicare Part C plan covers everything in Parts A and B and could save you money or include additional benefits you may not be receiving with your current plan. Right now is the Medicare annual enrollment period, and now is the time to call and enroll in a Medicare Advantage plan that could include additional benefits. All you have to do to enroll in a plan that could save you money or include additional benefits is follow these steps. 1, call the number on your screen. 2, give your zip code to the licensed insurance agent. And 3, find a plan best for you and your needs. Part C plans can change every year. Call now, even if you've called in the past, because you could be eligible for 2026 plans with additional benefits that may have previously been unavailable to you. So call today and find out the plan options available to you in your zip code. You do not automatically get enrolled in a Medicare Advantage plan that saves money or includes additional benefits, so you should call now during the annual enrollment period to find out what plans are available to you. Insurance companies offer different plans in different zip codes. Call today and find out what plans are available to you in your zip code. Call now to see if you're eligible to enroll in a Part C plan that could save you money and include additional benefits. All you have to do is follow these steps. 1, call the number on your screen. 2, give your zip code to the licensed insurance agent. And 3, find a plan best for you and your needs. Remember, you do not automatically get a Part C plan. Call now during the Medicare annual enrollment period for your free 2026 no-obligation Medicare benefits review.
Call 800-484-3074. 800-484-3074. 800-484-3074.
Welcome to Court TV Live on this Friday morning. I'm your host, Julie Grant. We are in Massachusetts for the rape trial of Irish firefighter Terrence Crosby. This defendant is standing trial for a second time on allegations that he raped a woman in a Boston hotel. This hour, we're catching you up ahead of today's testimony. The accuser will be returning to the stand. Before that, though, let's take a look at the background of the case. Court TV crime and justice correspondent Matt Johnson has more.
March 14th, 2024. A night of Boston bar hopping ahead of St. Patrick's Day holiday ends with allegations of rape against a visiting Irish firefighter. 38-year-old Terrence Crosby was visiting from Dublin and came to the U.S. to march in the St. Patrick's Day parade with other members of his fire brigade. He and his friend, Liam O'Brien, were sharing a hotel room when O'Brien met a woman at the Black Rose pub. According to court documents, O'Brien went back to the hotel and had consensual sex before falling asleep in separate beds. The 28-year-old woman says that she was awakened at around 2 a.m. by Crosby, who was having sex with her. She managed to get out of the hotel room and went to the Massachusetts General Hospital to get a rape kit performed and report the alleged sexual assault. Crosby was arrested the next day at Logan Airport, where he was preparing to board a flight after moving up his travel plans.
St. Patrick's Day weekend, the consulate wasn't open. He couldn't get advice from, attorneys from back home, short of going home.
Terrence Crosby pleaded not guilty, and his first trial ended with a hung jury.
Mr. Crosby is adamant that he's done nothing wrong, that he's an innocent person.
If convicted, he could be sentenced up to 20 years in prison.
Now, the accuser in this case will be returning to the stand this morning to talk about the alleged assault. On Thursday, she set the scene for the jury of what happened that night, talking about going to a bar and meeting one of the defendant's friends, whose name is Liam. Now, this is one of the final questions that was asked before court concluded for the day.
After you and Liam left, did you go back to the Black Rose?
No.
Where did you go?
We went to the Omni Parker House, which is where Liam was staying.
And how did you decide to leave?
We'd been talking all night, and he had asked me to come with him.
How did you go back there, or how did you get there?
We walked there.
Did anyone from his larger group join you on the walk back?
No.
So let's talk about what will happen today and what this alleged victim will have to speak about on the stand before this jury. And let's also talk about what that's like to have to do that if you're a victim of rape. And let's talk about what it's like on the defense side if you have to cross-examine someone who is allegedly a rape victim. Let's bring in criminal defense attorney Lindsay Richards and the executive director of the National Center for Victims of Crime, attorney Renee Williams. Good morning to you both. Renee, I want to begin with you. Would you help us understand what it's like for someone who has been victimized in such an atrocious way to speak about those things before complete strangers in a very public, intimidating setting?
Sure. These cases are incredibly traumatic, and it's incredibly traumatic to have to relive that not once but twice. And for most rape victims, we have to remember that there was a retelling of their story multiple times before they got to the stand. And so not only is that traumatic, but in this case, I want to point out that this victim did everything that we encourage women to do. She had a rape kit done within an hour. I mean, within 12 hours, I think, but definitely very, very quickly. She's done everything correctly. She went to the police. And so I think to have a jury say to her the first time, we're just not sure we believe you, that also has to be just incredibly damaging. There's no upside for victims when they have to repeatedly tell their story.
Renee, thank you for that. Yes, for anybody wondering, this is a retrial. So we had a mistrial last time, a no verdict. Lindsay Richards, let me go to you, please. Tapping into your experience as a criminal defense attorney, that's not an easy job to cross-examine someone who is allegedly a victim of rape. What kind of approach needs to be taken in such cases?
Well, I will tell you, as a criminal defense attorney, tact and being patient and understanding and kind is important. You can still be kind and also point out inconsistencies or issues in the case on a cross-examination, and jurors do not like it if you are combative and cruel and aggressive, especially with the survivor. I also was a adult sex crimes prosecutor for about 5 years. And I will tell you, these are the hardest cases to try. And unfortunately, it really is all going to land on whether or not this jury believes this particular survivor beyond a reasonable doubt. And it's really going to come down to her testimony, as it does in the majority of these types of cases.
Lindsay, thank you for sharing that about your background. I was unaware, and so of course I have a follow-up for you. Tell us more. Tell us what makes these cases so challenging when you have two adults with very different narratives.
Well, consent is always going to be the issue in the majority of these cases. Unfortunately, here it actually doesn't seem like consent is the issue. It's whether or not he actually engaged in any sexual contact with her at all. But the DNA in this case is inconclusive. Essentially, there's two male DNA profiles, and one of the male profiles is insufficient to create an entire male profile. So we just know it's male DNA, but we can't say exactly who it is. So it's, the question that she's likely to get on cross-examination is there anyone else that you had sexual relations with, leading up to that night that could have been an alternative profile in this particular case? And so it really just boils down to if this jury believes her, because there's really not much else, that proves whether or not this happens. But the prosecutors can prove a case through the testimony of one witness alone if a jury believes them beyond a reasonable doubt. And in this instance, the state prosecutors are going to have to keep coming back to, why would she make this up? Why would she lie? Why would she go through this whole process of getting this exam if it's not true? And that's going to be their case. Now, the defense does have a strong case, to poke holes in this story and essentially say whether or not there's enough evidence.
Right. And dovetailing off of the last point you made, Lindsay, Renee, isn't it a lot easier for victims to say nothing rather than to go through a trial and go through the re-traumatization? Would you speak to how much courage that process takes?
Absolutely, and the statistics tell us all we need to know. It is so much easier for victims to not go through this, especially when there's no reason to. As Lindsay said, she didn't have some reason for revenge on this man. She is not going to probably later sue him for money. There's really no reason for her to go through this. And what we see with victims, I want to say it's 5% right now we know of cases that are even reported, like 2% make it to prosecution. There are so many victims that just choose to stay silent for a multitude of reasons, and that's not the wrong decision if that's what's best for you. But it is much easier to just take a backseat.
Right. And I love how you qualified that, Renee, about, of course, whatever is best for someone personally. Everyone has different facts and circumstances. And of course, the bigger point is just that it's hard to go through and testify, and especially about something so horrific and personal. And that's really the main point I wanted to underscore. But just my heart goes out to anyone who's in a position like that, and you must do what's best for you, and getting treatment and being able to live a fulfilling life is what's most important. I have some clips I want to play for you both here now. We have a clip from the state's opening statement and the defense opening statement to kind of give everyone at home a perspective on this new trial, what the theories we're going to be seeing at play are here. So let's take a look together.
Through her testimony and all of the evidence that corroborates it, we will prove to you that the defendant went into that room, raped as she slept, and continued to do so after she woke up and struggled to get him off of her. The defendant thought...
Not a single time did they find a trace of Did they find a trace of Terrence Crosby's DNA? Not inside her, not outside her, not on her clothes, nowhere. The only identified male DNA found came from the other person in that room that night, Liam O'Brien.
Okay, Renee Williams, want to really tap into your lawyer brain, kind of apart from the victim's advocacy. So looking at it, very objectively, just as an attorney, and you hear these two sides, what are some of the things that you're going to be watching for as we get ready for the big moments of the accuser's testimony coming today, and then what's going to follow with the cross that we know that's coming?
It's very hard for me to be objective, and I think you saw me shaking my head throughout the defense's opening statements. From what I can distill, right now the defense is saying that the prosecution just can't prove their case. They're not even saying he didn't have sex with this woman. And they seem to be infusing a little bit of doubt in saying, oh, she was drunk. She had just slept with his friend. And I think that leads to a larger conversation about consent, because the media has picked up and run with that. And I just want to say, morally and not legally, without my lawyer hat actually on, and I can't believe we're having this conversation in 2025. Consent is very clear. There's not a reasonable person standard when it comes to consent. You have it or you don't. Consent cannot be transferred. If a woman is so drunk she can't form a coherent sentence, you do not have consent. Just because she consented to having sex with your friend, she did not consent to having sex with you. And I think that the law is very clear about that. But I think that what we see this defense attorney doing is trying to infuse that idea into the jury's mind subconsciously.
Such excellent points from you both. Thank you so much for the conversation. Renee, we need to let you go. National Center for Victims of Crime is where all the great advocacy is that you do. Thank you so much. For anybody who wants to check it out, crimevictims.org. Anytime donations, help, volunteering, all of it is welcome. Renee, thank you kindly. Lindsay Richards is coming with us as we dissect this case even further. Stay with us at home. We're getting ready to go into the courtroom together live. This is the rape trial of an Irish firefighter named Terrence Crosby happening in Boston.
I'm going to ask you a lot of intensely personal questions. How do you explain it? The worst crime anyone can imagine. Do you feel like you took the fall for this murder? Tell me in your own words, what happened? Let's get started.
Interview with a Killer. New season premieres Saturday, October 25th. Only on Court TV.
Welcome back to Court TV Live. This morning, we're getting you caught up on our newest trial ahead of today's testimony. The Irish firefighter rape trial is the case that we are broadcasting for you. The defendant's name is Terrence Crosby. He was a firefighter in Dublin. He was visiting Boston to walk in a St. Patrick's Day parade, and now he's finding himself on trial for allegedly raping a woman at a nearby hotel. Crosby's first trial ended in a mistrial after the jury could not reach a unanimous verdict. That was back in June. Now he's being retried. Testimony is going to continue today with the accuser set to retake the stand. This is a live look at the courtroom right now, so you can see the back of his head there as he's there with his attorney. And we have a restriction I want to tell you about that's important here. We cannot share the accuser's name. And that is perfectly expected, and we want to protect her identity at all costs. What's challenging for us is that when people in the courtroom use her name, even though we're not going to say it, the prosecutor continues to say her name over and over and over again. She's not using initials, which is customary in many prosecutors' offices. When you want to protect a victim's identity, you won't even say their name out loud. You may use initials, but she's saying it, and so every time it happens, we have to omit the name and use our editing process to do that so that it's not broadcast for the world to hear. So I know you would you understand this at home. We want to be airing everything live, but because of that, we're on a little bit of a delay so that we can drop the name from the coverage. So what we're going to do now, as you can see, they're getting started with, it looks like, some housekeeping matters. I want to show you, in case you missed the opening statements, what was said by the Commonwealth, what was said by the defense. Let's take a listen.
Every act of violence begins with an opportunity and a decision to take it. Terence Crosby, a firefighter, had traveled to Boston from Ireland, along with other members of the Dublin Fire Brigade in March of 2024. They had all come to Boston. They had all come to Boston for the purpose of marching in the St. Patrick's Day Parade. Typically, when we travel, we take an escape from our responsibilities in the stress of our everyday life. But instead, for Terence Crosby, he used his trip as a way to be anonymous, far from home, and to commit a rape he thought he could get away with. Now, this group of firefighters from the Dublin Fire Brigade landed in Boston in the late afternoon of March 14th of 2024, and they quickly began their festivities. The group ended up at a bar called the Black Rose, which is right near Faneuil Hall. It was a festive night, and St. Patrick's Day was coming up that weekend, and the restaurant was full of people that were eating, drinking, and dancing. You will see video from the Black Rose of the defendant and members of the Dublin Fire Brigade drinking and celebrating too. You will also see that the defendant met a woman there. He dances with her, and you will see them kissing. Terence Crosby walked out of the Black Rose with this woman, but soon after walked back into the Black Rose alone. Terence Crosby spent the night looking for an opportunity, and when one woman walked away, he found another woman who couldn't. He found was a 28-year-old attorney living in the North End and working for a nonprofit called the Greater Boston Legal Services. On March 14th, Ms. had gone to court for work, and then she attended a work event with colleagues who included her good friend, Daniel Jacobson. Later that same night, Mr. Jacobson and another colleague decided to go to the Black Rose for dinner and drinks. While at the Black Rose, met a man named Liam O'Brien, and they hit it off. Liam O'Brien was also a firefighter from Ireland and was here for the Dublin Fire Brigade to march in the St. Patrick's Day Parade. Throughout the night, they talked and danced, and eventually they left the Black Rose together to go to the Omni Parker House Hotel, which was the hotel where Liam O'Brien was staying. They walked to the Omni Parker House together around 11:40 p.m., and they had consensual sex in Mr. O'Brien's hotel room before eventually falling asleep. There were 2 beds in that room, and because Liam O'Brien was spread out across the bed, loudly snoring, he went to sleep in the other empty bed. And that's when it happened. Close to 2 in the morning, he woke up and realized there was a stranger on top of her, naked, violating her body and raping her. Like Liam O'Brien, this man had an Irish accent, but he wasn't bald like Liam O'Brien, and he had a different physique from Liam O'Brien. This man insulted Mr. O'Brien and insisted that he wanted this. Even as she told him to stop, and physically struggled to get away from him. As Liam O'Brien slept soundly in the next bed, snoring audibly, he was raped by a stranger. I didn't know it at the time, but that man was Terence Crosby. Now, the defendant ignored her pleas to stop and continued raping her, repeatedly thrusting himself inside her body. Ms. panicked and was focused on escaping, trying her best to stay safe from a stranger who she knew was willing to hurt her. Miss was eventually able to get out from under him, and she gathered her clothes and tried to leave. But the defendant wouldn't give up. He cornered her against the wall, touching her and telling her again that she wanted this. This all happened as Liam O'Brien slept. snoring after a night of drinking and oblivious to what was happening. Was able to lock herself inside of the bathroom and get away from Terrence Crosby, who had just raped her. As she left the Omni Parker house at approximately 2:20 in the morning, she texted her friend and colleague, Daniel Jacobson, who she had been with at the Black Rose, and she told him what happened to her. By 3 in the morning, she was at the emergency department at Mass General Hospital, where a doctor and a nurse performed an evidence collection kit on her, taking swabs from inside and outside of her body to search for potential evidence.
All right, so that's just some of the state's opening statement. The defense open is next. We thank you for watching Court TV Live. We are your front row seat to justice. Welcome back. We're getting you all caught up on the Irish firefighter rape trial as we get ready to go in live for today's testimony. So this case is about a defendant who's a firefighter from Dublin. Defendant Terence Crosby is his name, and he's on trial for a second time. First trial ended in a mistrial. The allegation is that he raped a woman while he was staying at a hotel visiting Boston. This is a live look at the courtroom, and we're getting you caught up on the key moments from when this case opened up. We're watching the opening statements, and then we're going to get into the accuser's testimony. So you know, we have to be on a little bit of a delay because we cannot share her name. The court has made that order. We respect that order. And what's making it tough is that the prosecutor keeps using her name in open court. So what we have to do is we have to bleep her name out from our coverage so that you won't hear it. As we do that, we're going to show you the defense opening statement now. Let's take a look.
Good afternoon, ladies and gentlemen. Once again, my name is Patrick Garrity. Along with my colleague, Jake O'Reilly, we represent Terence Crosby. Terence Crosby will be seated right here between me and Attorney Riley for the entirety of this trial. We'll be seated here because this is the only avenue he has to fight these allegations. Allegations that he denied from the beginning, and allegations that he denies to this day. Unless or until the Commonwealth presents enough credible evidence to you to find him guilty of these allegations, he will remain seated here, an innocent man.
Okay, counsel, can you come into the center?
Yes, Your Honor.
Courtroom, please.
Now, I want to talk a little bit about the evidence that I expect you will hear in this case. I expect you are going to see the Commonwealth put on a number of witnesses and introduce a number of exhibits in order to, I submit, try and reach their very high burden that they must meet so as to convince all of you that Mr. Crosby did what he is charged with. I expect the Commonwealth will put on detectives and experts and airline record keepers and bar managers and hotel security specialists and crime lab scientists, and they're going to show you video and screenshots and tests and records and all this other stuff. But as you will see, I expect none of that will be able to tell you or show you what happened inside room 610 of the Omni Parker Hotel on March 14th. You won't have any video of inside that room that night. You aren't going to have any audio of inside that room that night. No. The only evidence the Commonwealth can present to you from inside room 610 that night is the word of a woman named. And when she gets up there and she tells you what she perceived to have happened in that room that night, pay close attention, because I submit her story is what the Commonwealth will rely on when they try to meet their burden. And when you listen to her and you hear her tell you that she had been drinking for not just a little while at the end of the night, for 10 hours that day, think about what you will also hear. That her blood alcohol level, as the Commonwealth's own witness will tell you, was as high as 0.235. And I expect that you will hear from both her and detectives in this case that her memory has, as they put it, gaps. You will hear from both her and detectives in this case that she has talked about the amount she drank that day at least 3 separate times. And you will hear that that amount that she claims to have drank that day has changed at least 3 separate times. And I expect you'll hear, though, that her drinking, no matter which version she tells you, her drinking consisted of numerous drinks at a work party, splitting multiple bottles of wine, more drinks at a bar, and a shot before the time she claims Mr. Crosby attacked her. You will also hear that she has never identified her attacker or Terence Crosby as her attacker. despite the fact that the evidence, the Commonwealth's own evidence, will show you that they met. Mr. Crosby met at the Black Rose just a little while ago before her arrived at the Omni Parker Hotel. She shook his hand, and she even hugged him goodbye that same night. But she has never identified him as her attacker, despite emphasizing that during her assault, she claims the light was on and she could describe her attacker and she got a good look at him. She's never identified our client as that guy. You also hear that she repeatedly told police that when she arrived, no one was in room 610 that night. When her and Mr. O'Brien walked into the room, no one was in there. But, again, as the Commonwealth's evidence will show you, Mr. Crosby was in that room already. You will hear that doesn't remember that. Doesn't remember seeing a full-grown person in the room when she arrived. And I expect you will see photos of the hotel room, and you will see how big or not big that room is. And yet she doesn't remember seeing anybody. As for Liam O'Brien, you will hear that other than Mr. Crosby, he was the only other person in that room that night. But you will not hear that from him. You will not hear that or anything at all from Liam O'Brien, because you won't hear testimony from him at all. Despite that, though, I expect you are going to hear plenty about Liam O'Brien from both and Joseph McDonough, the detective in this case. For instance, you will hear that Liam O'Brien was approximately, or is approximately, 5'9". You will hear that is also about 5'9". You will hear that in one version of her story, she described her attacker as being similar in height to her. Our client, though, is almost 5 inches taller than both of them. But there is more you will hear about Mr. O'Brien. You will actually hear that it was his DNA that was found and identified on. I keep mentioning what you will have and what you will hear, but let's talk about what you will not have. You will not have anyone get up there and tell you that Mr. Crosby's DNA was found. Evidence will show you that the Commonwealth had access to numerous samples from Mr. Crosby, numerous DNA samples from Mr. Crosby, including a buccal swab, a cheek swab that he provided, and a sample of his DNA from his own clothing. The Commonwealth had everything they needed to compare and contrast samples that they took from his body. They tested swabs from all over her body and her underwear. And not once, not a single time, did they find a trace of did they find a trace of Terrence Crosby's DNA. Not inside her, not outside her, not on her clothes. Nowhere was Mr. Crosby on. Despite every opportunity, despite every test, despite every swab, the only identified male DNA found came from the other person in that room that night, Liam O'Brien. I want to briefly talk about one witness in this case, Daniel Jacobson. He will be offered as what's called the first complaint witness. And when he is offered, I ask that you listen exceedingly carefully to the judge's instructions about how such evidence may be construed and the very limited purpose for which it can be offered in the limited way you can consider it in your deliberations.
There's a little more to the defense opening statement, but before we get there, I'm going to bring in our guest legal analyst on the program. She is a former prosecutor and practices criminal defense work in the private sector, now attorney Lindsay Richards, based in Austin, Texas. Lindsay, so I want your assessment, looking at this objectively. You've been on both sides of these cases. Tell me, what set of facts, arguments, theories is speaking most to you on this one?
Unfortunately, the defense here, and I say unfortunately for this accuser, the defense has a lot to work with. The fact that there's a lack of identification of him from his accuser is actually very shocking to me. I can't believe that has happened, that there was no photo lineup, that there was no time, the police presented an opportunity for her to ID him. There's a lack of, definitive DNA evidence. They're not going to hear, this jury's not going to hear from the actual only other individual in the room that night, this O'Brien witness. The fact that he's not testifying, which could be for a number of reasons, but the fact that he's not testifying or supposedly woke up during this, sexual assault, that's a whole lot that the defense has to work with to create some reasonable doubt for this jury. But like I was saying before, I think the prosecutors really just have to keep coming back to, why would she lie? Why would she make this up? She doesn't really know these individuals. And so what would be her motive here for making up this story? I just think... I think culturally we want to make sure that we are listening to survivors of sexual violence, and we want to make sure that we give them an opportunity and we move forward on their cases, which is incredibly important. But we also have to make sure that we're holding prosecutors to their burden of proof. And if you cannot prove a case beyond a reasonable doubt, unfortunately, that means, acquittal of in a case like this.
Right. I know you understand well, Lindsay, for anybody who might have missed it, you were a sex crimes prosecutor, so you fully understand what victims go through and how sometimes what you believe happened and what you can prove happened, we know sometimes aren't always the same thing. And so these prosecutors are fighting for what they believe was a sexual assault and a very traumatic event, and this defense team is representing their client and holding their feet to the fire in terms of proof. We know there's going to be a DNA problem coming up. I'll be curious to see how that plays out. Lindsay Richards, great having you weighing in. Stand by kindly, please. We're going to play the last bit of the defense's opening statement, and then we're going to get ready to hear from the accuser. We thank you for watching Court TV Live.
Donna Adelson was part of a conspiracy to kill her former son-in-law, Dan Markell.
He's not going to survive.
Oh my God!
Dan saw Donna as dangerous.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins, season finale, Saturday night at 8 Eastern and Pacific. And during the finale, don't miss an exclusive preview for the new season of Interview with a Killer, only on Court TV.
Tough case out of Boston this morning. We are getting you all caught up on here on Courties TV. We're calling it the Irish firefighter rape trial. We're getting ready to go in live. We have some restrictions on what we can show. We cannot share the accuser's name, understandably so. What's problematic is when lawyers in the courtroom are using her name. We have to take the time to remove it from the video. So bear with us. We're going to show you the rest of the defense opening statement right now before we get into the accuser's testimony.
Now, when I started, I told you that Mr. Crosby will be sitting right there between Attorney Riley and myself during this trial. And he sits there, an innocent man, not only because he must be presumed innocent, same as anyone else would be in this courtroom, including me, including you, under the laws of our Constitution and of the state. But he doesn't sit there innocent just because of that. He sits there innocent throughout all testimony, all evidence, and at all times, unless the Commonwealth has convinced you, all of you, individually, collectively, and unanimously, that he is guilty of what he is charged with beyond a reasonable doubt. That's the highest burden that exists in our country. And I'm telling you right now, they will not meet it because they can't. This case is going to involve a lot of suspicion and maybes and what ifs. It's going to involve a lot of emotion. But we do not convict people on suspicion. We don't convict people on maybes. We don't convict people on what ifs. We don't convict people on emotion. You convict it on the evidence you are presented. It's up to you to determine if that evidence is reliable, if that evidence is credible, and if it leaves no reasonable doubt in your minds. And I submit that the evidence the Commonwealth will present to you is going to leave a lot of reasonable doubt in your mind. What tells you and what evidence you hear and see in this trial, that's what matters. Because when someone makes this kind of accusation, what they say, how they say it, how often it changes, and what's missing, that matters. Memory matters. And I want to touch on something the Commonwealth brought up in their opening. Yes, you will hear our client boarded an earlier flight, earlier than the one he initially planned to be on, after he was informed of this accusation. But you will hear from witnesses that when police interviewed him, Mr. Crosby gave them his phone number, his home address, where he was staying locally, his birthday, and knew.
There's an objection. Why don't you wrap it up?
Understood. You will hear from Detective McDonough that he told Mr. Crosby, "You're a free man. You can do whatever you please."
Objection, counsel. If you keep staying in this area, you're going to have to come to sidebar.
Understood, Your Honor.
If you move on, you can keep going.
Understood.
I understand what the objection is, and it's sustained.
Understood. Please listen to the evidence before you jump to conclusions. Please. His Honor will further instruct you on that burden I mentioned. But that burden of convincing each and every one of you beyond that tall reasonable doubt remains solely with the prosecution this entire time. It doesn't shift to the defense. It's with them from start to finish. The Commonwealth can put up any witness they want, and we could sit back and let them say and do and show whatever they want without putting on a single question or putting on any of our own witnesses. We're not going to do that, but my hope is that you get the point, that this is all on them to try and prove to you that the story is true and she didn't get it wrong. And again, I submit they will not do it because they can't. So at the end of this, Attorney Riley is going to come up here, and he's going to stand before all of you and give what's called a closing argument. And at the end of that closing, you will go into that room and begin your deliberations. And when you do, recall all the doubt that I said you will hear from the Commonwealth's witnesses. Because if you do, I expect you will be able to return the only reasonable and logical verdict. That if you got it wrong, Mr. Crosby should go home not guilty.
Oh, he's doing a little argument there in that opening statement. Tell you what, though, I give them credit because good trial attorneys know how to walk that line. It's called opening statements for a reason, not opening arguments. Opening statements, but good attorneys will know to walk that line of argument. I teach that in trial advocacy. All right, here's what we're gonna do. We're gonna hit a break. When we come back, we're getting ready for the accuser to take the stand. We thank you for watching Court TV Live. This is the Irish firefighter rape trial. Welcome to our second hour of Court TV Live. I'm Julie Grant. We're in Massachusetts for the rape trial of Irish firefighter Terrence Crosby. This defendant on trial for a second time on accusations that he raped a woman at a Boston hotel. His accuser is returning to the stand today. She started her testimony on Thursday, but didn't get to the sum and substance of what the jury is going to have to consider. So as we wait to get in there live, I want to show you some of what ER doctor Lindsay Walsh, who treated the accuser, had to say to the jury.
What is the time frame, of your care of Ms.
So the time frame of my care was from March 15th at 3:10 a.m. Until March 15th at 7:26 a.m., which was when we switched off care to the oncoming morning team.
I asked you earlier as well if you performed the evidence collection kit with a registered nurse. Was her name Carly Littlejohn?
Yes.
And do you see Miss Littlejohn represented on this timeline as well?
Yes, I do.
And so is it fair to say that her care of would have been from 3:20 a.m. until 7:34 a.m. according to this this record?
Yes.
All right, so moving down to the timeline on page 13 of Exhibit 1. Do you see where it says ED care timeline at the beginning of, or I'm sorry, at the top left of the page?
Yes.
So can we just move through this page and I'll ask you to explain what is noted within the timeline?
Yes.
Okay, so starting from the beginning, can you explain what this timeline shows?
Yes, so at 3:05 a.m., an emergency encounter was created, which was when the patient came to triage. There's a name and they have to enter the medical information into the chart to get her registered. So that is what happened at 3:05:32. Then an arrival complaint was assigned, listed as SA. At 3:06, there's a standard travel and symptom screening that's done. At 3:07 a.m., there was an entry to start the triage note portion of her registration. At 3:07:34, there was a chief complaint that was updated. And then at 3:07:35, the triage note is published in the chart.
I apologize.
That's okay.
I went to the next page instead of just scrolling down a bit. So looking on the right side of the screen, I see the name Jennifer McBrien, an RN. Yes. Would that be registered nurse?
Yes.
So does that indicate that she is the one who is performing what's documented here?
Yes, she was presumably the triage nurse registering the patient.
Okay, so looking down here, for example, at the entry from 3:08 a.m., vital signs, what does that represent to you?
So the vital signs are, again, a standard part of triaging a patient and being able to get them to a certain area of the emergency department. So her temperature was 97 degrees Fahrenheit, her heart rate was 140, her respiratory rate was 18, blood pressure was 168/97. The SpO2 is her oxygen saturation, which anywhere from 96 to 100% is normal. The O2 device, she didn't require any supplemental oxygen. She was on room air. And then there's a pain assessment that's done for every patient as well on a scale of 0 to 10.
And so that would have been done while she was interacting with Jennifer O'Brien?
Correct, yes.
Okay.
Give me a moment, please. So, jurors, you see the black boxes here. So when an exhibit is entered, there's some things on the exhibit that may not be admissible. That's what the black boxes are for. Sometimes that means I made a ruling. Here, I didn't make a ruling. The two sides agreed themselves what was relevant, what was not relevant. So an important point is things that are blacked out are not blacked out because they're relevant. They're blacked out because they're not relevant. So you're not missing anything that's probative to the case. It's the irrelevant information, and you're not to speculate on what might be beneath the black box. And we call those, in the legal world, we call those redactions.
Thank you. On the next page, which is page 14 within the medical record, do you see the entries at 3:10 a.m. that include your name?
Yes, I do.
Can you explain what it means when it says provider first contact there at 3:10:54 a.m.?
Yes, so there's a From the time the patient comes into triage to get the vitals, et cetera, they're then moved back to a room in the emergency department. When that happens and they come up on our screen, a provider will assign themselves. So that's what I did, where you see assigned resident, and then provider first contact was when I first went in to see the patient.
So moving now to page 15, can you explain what appears to be your order there means?
Yes. So this is a documentation about the evidence collection kit. It's an order to get the patient into a private room, have certain tools set up to perform the necessary parts of the exam. And there's a placement in there to call a SANE nurse, which is a trained nurse to perform the evidence collection portion of the exam. They cover the Boston area, so we have to put out phone calls and pages to them, and if they are available, they will come and perform the exam. But nurses as well as physicians in the emergency department are also trained and frequently do these exams as well.
Thank you. I'm going to move through the next portion of the timeline down to the bottom of page 15. Do you see where it says 3:35 a.m. and it notes that a SANE was paged?
Yes, I do.
And is that the time when you requested that forensic nurse to come to the hospital?
Yes.
And just moving through the remaining portion of the timeline, is it fair to say that the next couple of pages, as I'll scroll through, shows that different labs were being ordered and resulted from during that time, and that she was interacting with different medical personnel within the emergency department?
Yes.
So now looking here at the entry toward the top of the page from 3:39 a.m., do you see where it says patient observation within the bottom of that section, and it says per MD Lindsay Walsh, patient medically cleared?
Yes.
What does that mean?
So medical clearance, we document this as part of a SANE evaluation as well as for patients coming in with mental health complaints. It means that from the clinician standpoint, we have cleared this patient from having any sort of life-threatening injuries and have determined that they are able to participate in their own care. They're alert, they're oriented, they understand what the medical care being provided to them includes, and they're able to tell us the risks, benefits, et cetera, and participate fully in their care.
And here, was that done because you were seeking consent to undergo an evidence collection kit?
Correct, yes. It is also part of the consent process. We have to make sure that a patient fully understands what is entailed in an evidence collection kit. So that is also part of it.
Okay, so we know this accuser went and had a rape kit done, which is the right thing to do after you've been victimized by way of a sexual encounter. That's a great way to preserve evidence. In this case, the defendant's DNA has not been identified as part of that rape kit. So that makes one of the most triable issues in this case for the defense side. Because if his DNA is not there, you can see why he would go to trial. He's cloaked in the presumption of innocence. We'll find out what more evidence we have coming in against him as the accuser set to bring in the testimony about the alleged rape any minute now. And as soon as we can remove her name from that testimony, then we're going to show it to you live. Let me bring in someone who's tried sex abuse cases in the studio this morning. I'm so pleased to have with me attorney Krista Ramey. Krista, so nice to see you here. And what an awful case. As you know, these cases are tough. Speak to us from experience, please, how different it is when you're doing a direct examination or a cross-examination, for that matter, of someone who is said to have been sexually assaulted.
You know, from the perspective of the prosecutor and you're doing that direct examination, one thing that I try to impress upon my staff and on myself, remind myself I have to be trauma-informed, because the last thing you want to do with a witness on the stand is to re-traumatize them, which is, they're going to be re-experiencing their trauma anyway. but to make sure that they are able to tell their story. So you have to approach them in a way, we ask open-ended questions anyway, but we really have to get to it slowly with them. And I know with this, that's what they are doing. She started testifying and then stopped and, haven't gotten to it yet, but you need to make sure that she is able to tell that story in a way that doesn't freak her out. Because it's not going to help if that happens. So I think that from that perspective, and then on the flip side, when you're cross-examining her, you've got to be respectful of that too, because she is an accuser and you are representing someone that is the accused, but you don't want to come across as a jerk, because that might end up hurting your client more than helping your client. So
right. With those warm-up questions, we'll call them, is there a framework you like to have as kind of standard? In other words, do you start with, family? Do you start with education? Do you start with, there's kind of, what's the formula, if you would kind of walk us through that, Krista, that you go through?
It is a build. Yeah. And that's what makes it easy, or easier for her, or him, as the case may be. But you start with kind of general background, so she feels comfortable talking to the jury. You've also practiced with them. You've talked to them. That's kind of like, people think that maybe is a taboo. It's not. If a prosecutor is not talking to a witness before that witness takes the stand, that prosecutor is not doing their job.
Right.
You have to make sure you know everything that they're going to say. You're not telling them what to say, but you're walking them through their testimony. So you've already done this. And I think that's the most important part of the formula, is making sure that they're prepared to do it, and maybe even do it around people, so they're used to talking about it in front of people that they don't know.
Sure. Maybe in a law office, you have some staff members who could sit there, to get them used to telling the story among people that aren't part of their family or their close friend circle, people that they would feel vulnerable in front of.
We actually have a mock jury room in our office.
Yes.
And that is the mock courtroom. There's a witness stand, there is a jury box, and we run them through that. So it feels like more of a real-world setting.
That's really helpful. Krista, I'm so glad you're here today. We're going to talk more about this case. We'll hit our first break of the hour. When we come back, we'll hear more from that doctor in the rape trial of defendant Terrence Crosby.
Edelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
Welcome back to Court TV Live. We're going to take you back to Massachusetts in just a moment. First, though, I have an update for you on the Minnesota woman who killed 2 Amish children in a methamphetamine-fueled crash. She was sentenced on Thursday. Defendant Samantha Jo Peterson pleaded guilty to 2 felony charges stemming from that September 2023 crash. Peterson initially tried to pin the crime on her twin sister at the scene. Remember this case? I know you do. But now she admits that she was the driver and that she was high on meth when she crashed into the back of that horse-drawn buggy. Peterson learned her sentence on Thursday.
Ms. Peterson, I am committing you to the Commissioner of Corrections for a period of 48 months. Minnesota law requires that you serve at least 2/3 or 32 months with the remaining 16 months on supervised release. Ms. Peterson, I will note too, and I'm sure you talked about this with your attorney, it's entirely possible because of all the good work you've done and the treatment that you've participated in and completed, you may very well qualify for early release programming with the Department of Corrections, and of course you've earned that as well with your conduct.
All right, so there we have it. That case is closed. In the meantime, let's take you to a case that is wide open in Boston, the trial of a firefighter from Dublin, Ireland. This defendant's name is Terence Crosby, and we're going to get into the accuser's testimony shortly. She started her testimony on Thursday. She's continuing it this morning, and our editors are working very hard to remove any identifying information from it. We cannot share the identity of this accuser. So let's listen to some more of the doctor. This accuser goes and gets a rape kit done. The ER doc is on the stand.
Do you see where it says ED provider note by Kamal Medledge?
Yes.
And who is he?
Kamal Medledge was the attending physician that was initially assigned to take care of the patient along with myself.
Okay, so page 22, the very bottom of page 22 and page 23, is this Dr. Medledge's note regarding essentially his oversight of the care of Ms.
Yes.
So I'm going to move down to the bottom of page 23, and again, at the very bottom of this page, do you see where your note begins?
Yes.
And so on page 24, where it says ED provider note continued, history of present illness, is this essentially where the substance of your note begins?
Yes, it is.
And can you explain what you documented here?
Yes, so in these types of cases where we see patients coming in with the complaints such as Ms. We don't document the evidence collection kit. We don't have any redundancy in our documentation. So I state why she came in. I talk about her various vaccination statuses, and then I refer to the evidence collection for further detailed documentation of the genitourinary portion of the exam. I state that she has no neck swelling, no redness on her neck, no bruising, no hematomas, which are things that we look for as part of the medical clearance process, because any evidence of those could indicate some sort of strangulation injury. And then the review of systems is when we ask the patient about specific symptoms that we then document in the chart as well.
So the review of systems here, is that something that you documented, or did you draw that from another provider's notes within the record?
This is what I documented.
Okay. And so as part of your, it's called a review of systems, would you have made observations of Ms. head and eyes, her neck, and other parts of her body?
Yes.
How do you do that? Is there a full physical examination that happens then, or what's involved in the review of systems?
So yes, the review of systems is part of the history taking when we ask the patient, what brings them in. We go through all of these symptoms, and the patient will essentially say yes or no. We document that, and then the physical exam, which is further down in my note, is separate, where we actually examine the patient, look at the skin, listen to the lungs, heart, etc.
Okay. So I'm going to scroll down further within your note where it says pertinent vital signs and pertinent exam findings. Mm-hmm. Again, are these notes that you input based on your examination of this?
Yes.
Under pertinent exam findings, where it says neuro, moving all four extremities, motor function intact, and speech fluent, can you explain what that means?
Yes, so our neurologic documentation for a patient includes, do they have any sort of paralysis? Are we concerned about a stroke? That's like where this comes from. So she was moving all of her extremities, motor function intact, meaning she was able to move everything. She had no deficits, as we would call it. And fluent speech means that she's not having slurred speech. She's not, having any facial droop. She's clear. She's coherent.
Looking at the assessment and plan portion of your note, can you explain what you documented there?
Yes, so the assessment is our overall summary of, based on our physical exam, the presenting history, what we think might be going on. So I say that this is a 28-year-old female who presented with the complaint, as we've discussed. We take into account the time frame in these specific patient scenarios for when, an event happened and when they are coming in, because that will dictate what types of medications we can give as a precaution or to treat possible infections that might be there. So she presented within the 120-hour window for the forensic evaluation and then also to receive certain types of medications. I documented that she consented to the evidence collection kit, which included forensic documentation and then evidence collection. Involvement of BARC, which is basically a support that we provide for resources when patients come in with concern for sexual assault. We gave prophylaxis, which is medication that we give as a precaution if somebody is pregnant, and also to treat any possible sexually transmitted infection. And she was unsure of her hepatitis B immune status, so we test those labs as well.
Okay. We saw earlier in the note, or in this record, that you had paged, or someone had paged a SANE nurse at approximately 3:35 a.m.
Yes.
Did one of those forensic nurses arrive?
No, the forensic nurse, after we have a protocol for how often and how frequently we reach out, and that's all documented. The SANE evaluator who was on call on that overnight had another case, so she was at a different care facility.
And you said that when that situation arises, when a SANE or a forensic nurse is not available, that a registered nurse or a doctor within the emergency department can step in and perform an evidence collection kit.
Correct. Typically in those cases, the emergency room nurse and the responding clinician, the assigned provider, do the exam and the collection together.
And in this case, was that you and Nurse Carly Littlejohn?
Yes.
In your role as an emergency department doctor, had you been previously trained in how to perform an evidence collection kit?
Yes, I had been previously trained, and I had performed these collection kits previously.
I'm one of the attorneys representing the defendant, Mr. Crosby. You spoke with ADA Murphy about consent requirements, correct?
Yes.
And as it applies to treatment generally and evidence collection kits specifically, right?
Yes.
And you said in response to several questions that you would not proceed with evidence collection if you were, quote, under the influence of drugs or alcohol. Is that right?
Yes.
Is that a technical or medical term, under the influence?
I believe, when we assess somebody to answer that question, it comes down to capacity and whether or not we think that they have the ability to make medical decisions for themselves.
So can someone have a high blood alcohol concentration and not be considered under the influence?
I don't think so.
But you were aware that toxicology was ordered as part of care, correct?
Yes.
And you're aware that having reviewed this medical record, she did have a high BAC, correct?
She did, but she was able to consent and follow the instructions that we were giving her in the emergency room. So
that it would, in fact, be possible to have a high BAC and not be considered under the influence, correct?
Sure.
Is it fair to say that under the influence means drugs or alcohol appear at least outwardly to be affecting a person's presentation and ability to interact with you?
Yes.
Is it fair to say it's a judgment call on your part if they meet the criteria for being under the influence versus clinically sober?
Yes, it's a provider. It's a provider evaluation. Yes.
Is it fair to say someone who drinks regularly or has a higher tolerance is more likely to present as not under the influence?
I can't answer that. I don't know.
You haven't seen multiple people presenting in your ER with signs of intoxication?
I have, yes.
And you've had to decide whether or not they are presenting as clinically sober or under the influence?
Yes, based on the exam that we provide.
And so as part of that exam, do you ever inquire as to if they're a regular consumer of alcohol?
No, it's based on our exam that we provide in the emergency room.
Okay. So regardless, despite what their blood alcohol might be, you make a determination without knowing that potentially as to whether or not you believe they're under the influence or not, correct?
Yes.
Okay. So they can be intoxicated but not under the influence, right?
Yes.
And intoxicated but coherent in your opinion?
Yes.
So they could have presented as clinically sober or not under the influence and still had a high BAC, correct?
Yes.
However, she still could have been drunk, right?
Yes. But she, again, she had capacity and was able to participate in the exam that we were providing and the instructions.
So she could answer your questions, but she could have had issues with her memory or perception due to intoxication, but still answered those questions.
Objection. Are you able to answer that question?
No, I'm not.
All right, next question.
You'd agree someone who's been drinking can tell you why they presented to the ER, right?
In some cases.
And you'd agree that they could potentially understand what was involved in the evidence collection kit, correct?
Yes.
And someone who's been drinking can also participate in their own care, correct?
Yes.
And as a doctor, you observe and treat medical conditions, right?
Yes.
But you don't personally observe how these conditions come about outside the hospital,
Correct.
Right?
Yep.
So you can't know what actually happened prior to their arrival at the hospital, right?
Yes.
In the medical records, Exhibit 1 that you reviewed with ADA Murphy, you indicated that there was no report of pain from, correct?
Yes.
You noted the skin was intact, no mention of bruises or scratches, right?
Yes.
With regard to the laceration of the vaginal opening that you testified about, you said it's a small tear without active bleeding, right?
Yes.
Would you agree that that can be from consensual sexual activity?
Yes.
Would you also agree that it could be from some other perfectly innocent activity?
Sorry, can you repeat that?
Would you also believe it could come about from other innocuous activity?
Yes.
So you did not observe, and you're not personally aware of what did or did not happen to before her arrival at MGH, correct?
Correct.
All right, so that's the testimony from the ER doctor. So I will say this, if this rape did occur, and this woman says that it did, she did the right thing going to the hospital and getting that rape kit. That is the right thing to do. It's a hard thing to do. And it's a very brave thing to do. And we know that she did that here. What the kit yielded is going to be another battle within this contentious trial. We're not quite there yet. We still have to hear from the accuser. She is on the stand, and we're going to start showing her testimony to you. Don't go away. It's coming up after the break. Here we go, back to Massachusetts in the Irish firefighter rape case. We're about to show you unaired footage from the accuser's testimony. Here we go.
I have some questions for you now about March 14th of 2024. Do you know if you worked that day?
I did.
And do you know what day of the week that was?
It was a Thursday.
Do you remember if you were in the office in the earlier part of the day or if you were somewhere else?
Yes, I was in court in the morning. We have court typically Tuesdays and Thursdays. And then I went back to the office after court.
I'm sorry, I missed the last part of what you said.
I went back to the office after court was over.
If you could just keep your voice up. Thank you. Did you attend an event in the afternoon outside of the office?
Yes, I did.
What was that event?
It was a staff appreciation event that I helped plan.
A staff appreciation
Yes.
event? Where was it held?
It was at Big Night Live, which also happens to be in the West End.
What is Big Night Live?
It's a mixed event space. The event that we had specifically was in a hall of sorts.
Okay. And were you able to walk there?
Yes, absolutely.
You said you participated in planning the event?
Yes, I did.
Who else planned it?
It was myself and a few other colleagues, including my friend and coworker, of course, Daniel, and then the CFO, assistant planning, as well as some of the admin folks.
Other staff for Greater Boston Legal Services?
Yes.
Do you know approximately what time you arrived at that event?
I would say around 1:45.
And can you also explain generally how the event was set up, what the timeline of events was going to be?
Yes, absolutely. I got there a little bit early because we had planned or participated in the planning. It was a hall, as I said. There were tables for sitting. There was a white elephant, even though it was in March. It happened to be Pie Day, so I facilitated a pie contest. There was karaoke. There was a photo booth. So various events, and a bar, and then a display of food.
And in general, who attended that event?
Any staff, some of our volunteers, some of our interns.
How long were you there for, approximately?
About 4 hours, I would say.
And when you left, where did you go?
I went back to the office. I walked back to the office briefly with my friend and coworker, Daniel.
What is Daniel's last name?
Jacobson.
Do you know approximately how long you were back at the office for?
I would say about 30 minutes.
Were you planning to go somewhere after that?
Yes. There's a lot of mingling at the event. I happened to have a conversation with our executive director, Jackie Bowman, and our CFO, Joanne Sanders. We got along quite well, so they were also back at the office. They didn't walk back with us, but we ended up making the decision to go to another place after we were at the office.
What was the other place that you decided to go to?
It's called State Street Provisions.
And what kind of place is that?
It's a bar restaurant right by the aquarium.
Did the people who you just described, the CFO and other staff, did they eventually go to State Street Provisions?
Yes, there were a total of 6 of us. At State Street Provisions.
What time would you say you arrived at State Street Provisions, just approximately?
I would say approximately 7.
And while you were there, did you have anything to eat or drink?
Yes. Between the 6 of us, we had 2 bottles of wine. We also had ordered some appetizers to split between us.
And earlier at the staff appreciation event, did you have anything to eat or drink there?
Yes, I had hard seltzers, alcoholic seltzers while I was there, as well as various hors d'oeuvres, lots of cheese, various of the food that was on the table.
Okay. At some point, did you and your group of coworkers leave State Street Provisions?
Yes. 3 of us left together. We all left, but 3 of us went on to another place together.
And who were the 3 of you that stayed together to go on to another place?
It was myself, Daniel Jacobson, and our 3rd coworker, Anaudi.
What is Anaudi's last name?
Hernandez.
And where was the other place where you and Mr. Jacobson and Mr. Hernandez went?
It's called the Black Rose. It's in the same area as State Troop Provisions. It's right by Faneuil Hall.
You mentioned that in addition to being coworkers with Mr. Jacobson, that you're also friends outside of the office?
Yes, we started at GBLS at the same time, so we've been quite close for a good amount of time.
And had you ever gone out with him socially before this particular night?
Yes, several times.
And what about Mr. Hernandez? Did you ever socialize with him outside of the office?
Yes, on a few occasions.
How did the 3 of you get to the Black Rose from State Street Provisions?
We walked.
Do you know approximately what time it was when you got there?
I would say approximately 9 p.m.
And can you describe the general atmosphere of the restaurant when you got there?
Mm-hmm. The Black Rose is a Irish bar, and it was St. Patrick's Day that following weekend. So there was live music. It was very lively. The bar has tables, but also has a stage for dancing, and the live music, of course.
The live music?
Yes.
Okay. Were you able to get seats when you got there?
Yes, we had Anaudi, Daniel, and myself sat at a table.
Did you have anything more to eat or drink while you were there?
I ordered a burger with a lettuce wrap and fries, and then I continued to have the hard seltzers, similar to what I had at Big Night Live.
While you were at the Black Rose, did you begin socializing with anyone outside of the group that you were with?
Yes, several people.
All right, so we're going to pause things right there. Let me bring in our legal analyst guest in the studio with me today, attorney Krista Ramey. Krista, you picked up on something as you and I were watching the testimony, and you heard the accuser talk about going to court. And right then, it brings up what I think is a significant factor for this jury. Tell me what you think. This accuser's profession is the law. She is a lawyer. We're not going to speak about any of her employment history or anything like that, but she's an attorney. What weight do you think that carries with the jury?
You know, I think it can carry significant weight. One, I think it explains like how calm she is when she's testifying. And so she's used to being in a courtroom, maybe, we don't know, but she certainly said she was going to court. But I think it also, that oath is very sacred and precious. I know that every time I see a jury get sworn in even I get goosebumps. And so for me, it lends her that extra, there's something that lawyers take all these oaths very seriously. And so I think that it gives her some credibility that maybe wouldn't come necessarily with a witness that's not as familiar with this system of justice as we are as attorneys.
Right. The oath, I would argue, means more to lawyers. Yeah. I would argue, you just understand the seriousness. You understand the penalties that attach, the penalty of perjury. If you take an oath and swear to tell the truth, you can't lie under that oath, and you're an officer of the court. Mm-hmm. In addition to just being a witness, as a lawyer, you walk in any courtroom, you are an officer of that court. You have an ethical obligation under our rules of responsibility that we share as lawyers to tell the truth. And so when I heard that, I thought, wow, that just kind of made me take a step back and think, okay, this is someone who I would think would be taking this process incredibly seriously, and perhaps also why we're seeing the bravery. We talked in our last hour, Krista, about how hard it is, and you know this because of many of the clients that you represent who've been victims of various types of sex assault and rape, that it's hard to go in front of a group of strangers and tell your story and recount this. And for some people, it's just best to not talk about it at all. But I would think that someone who may have a different respect for the law because of the profession they've chosen, it may be more meaningful to do this. What do you say?
Yeah, you know, that's a really good point, because I think that when you're thinking about, you know it, the system, you know what this is about. You know that there's going to be victim blaming. You know how you're going to be treated by the defense and others as they're watching you. And you're airing your mistakes, maybe, of how you feel about drinking and decisions that you've made, that you did make, and that maybe led you, and that self-blame. So she knows all of that going in. And you know, also, this is not about money. She's not suing civilly for some, you know, good payout to some fire department or whatever. This is about doing justice. And, you know, former prosecutor, you know, that's what it's about, doing justice. And so I think that this, to me, does do that with credibility and lending that extra credibility.
Right. Krista, I'm so glad we have you here to weigh in. We're going to hit a break. When we come back, more unaired footage from the accuser in the case against Dublin firefighter Terrence Crosby.
I'm going to ask you a lot of intensely personal questions. How do you explain it? The worst crime anyone can imagine. Do you feel like you took the fall for this murder? Tell me in your own words, what happened? Let's get started.
Interview with a Killer. New season premieres Saturday, October 25th. Only on Court TV.
Welcome back to Court TV Live. I'm Julie Grant. Let's get you into the courtroom for more unaired footage from the accuser's testimony in the Irish firefighters' rape trial happening now in Boston.
Did you notice anything about their clothing, the clothing worn by the group of people that Liam was with?
They were all wearing similar, if not matching, T-shirts and or sweatshirts that show that they were part of the Dublin Fire Brigade.
What did Liam look like?
He's about my height, bald, white.
How tall are you?
I'm 5'9". I'm also not the best at height identification, but I would say when we spoke, we were relatively looking at the same.
Okay. Did you notice anything about his voice?
Yes, he had an accent.
Were you able to recognize what type of accent it sounded like to you?
Irish, and then with the Dublin Fire Brigade sweatshirt, I put those two together.
As far as your interactions go with Liam, can you describe what your interactions were like with him during the time you were at the Black Rose?
Yes. Very lighthearted. We spoke, we danced, we kissed at one point. Like I said, he was introducing me to various people. I was talking to other people, but we spent our time together.
How long approximately would you say that you stayed at the Black Rose?
About 2 hours, maybe a little bit more.
Were Daniel Jacobson and Anaudi Hernandez still there when you were socializing with Liam, the person who you had met?
Yes, at times, but Daniel left prior to me leaving.
Okay, so Daniel left and you remained at the Black Rose?
Yes, correct.
Have you seen videos from inside the Black Rose that night that depict you, Liam, and the respective groups that you were with?
Yes.
And before testifying today, were you able to see portions of that video that you recognized?
Yes, I was.
Based on what's going on in the video, do you have a sense for how long you had been at the restaurant at this point?
We had ordered our food and we'd received our food, so I would say at least 30 minutes. Might be more.
So later on in the night, have you seen video where you get up and start dancing?
Yes, I have.
Okay. And were you the only one dancing, or were there others dancing in the restaurant as well?
There were others dancing.
Can you see where the live music is that you referenced?
Yes. Here you can see the stage and somebody's playing.
Okay. Thank you. How would you describe the noise level in the restaurant that night?
It was quite loud. I mean, there are a good amount of people, even more people behind the wall, and then obviously the live music. There's a lot of Irish music being played, so there's a lot of clapping. So I would say it was quite loud.
At various times throughout the night, would you return to the table that you had originally been seated at?
Yes.
When you were ordering drinks and food, do you know if you were doing that through a person, or if you had to go up to the bar for that?
We had a waitress, but there was also a time that I was at the bar.
After you and Liam left, did you go back to the Black Rose?
No.
Where did you go?
We went to the Omni Parker House, which is where Liam was staying.
And how did you decide to leave?
We'd been talking all night, and he had asked me to come with him.
How did you go back there, or how did you get there?
We walked there.
Did anyone from his larger group join you on the walk back?
No.
All right, Jurors, we've got a lot done today, so I'm going to break here before we change venues from one location to another location. And I want to remind you, keep an open mind. Don't talk to anybody about the case. Don't do any independent research. Don't post anything. Don't look at any media accounts. We'll take a few minutes to tell you why these rules are important, why we have them. We selected 15 fair and impartial people who can decide this case based on the evidence that's presented in the courtroom. If you were to go home, It's fine to tell somebody, I'm selected as a juror, set in Superior Court, it's expected to be this length of time, that's fine. But if you started talking about the case, what's the first thing that person would do, the person you're speaking with? They tell you about some experience they're aware of or some opinion they have. So then you wouldn't be the same fair and impartial jurors when we selected you. So that's the reason we have those rules. The independent research, I think you'd like to see that if you're going to decide the case based on the evidence, you can't be...
We're going to hit pause right here as we continue our coverage of the Irish firefighter rape trial. Thank you for being with us on this Friday morning. We'll be right back.
Welcome back to Court TV Live. I'm Ted Rowlands. Good to be with you on this Friday as we round out another busy week. We're going to begin the hour where we left off last hour in Massachusetts, fascinatingly raping a woman over St. Patrick's Day last year. Prosecutors say that Terence Crosby, a firefighter who was visiting with his buddy from Ireland, raped a woman who had stayed the night in a hotel room he was sharing with that buddy from Ireland. The 28-year-old alleged victim, who we're not naming, says she had consensual sex with the first fireman, but Crosby then apparently, according to her, forced himself on her while she was sleeping. Let's get a little roundup of this case, and for that we'll turn to Court TV correspondent Matt Johnson.
March 14th, 2024. A night of Boston bar hopping ahead of St. Patrick's Day holiday ends with allegations of rape against a visiting Irish firefighter. 38-year-old Terence Crosby was visiting from Dublin and came to the U.S. to march in the St. Patrick's Day parade with other members of his fire brigade. He and his friend Liam O'Brien were sharing a hotel room when O'Brien met a woman at the Black Rose pub. According to court documents, O'Brien went back to the hotel and had consensual sex before falling asleep in separate beds. The 28-year-old woman says that she was awakened at around 2 a.m. by Crosby, who was having sex with her. She managed to get out of the hotel room and went to the Massachusetts General Hospital to get a rape kit performed and report the alleged sexual assault. Crosby was arrested the next day at Logan Airport, where he was preparing to board a flight after moving up his travel plans.
St. Patrick's Day weekend, the consulate wasn't open. He couldn't get advice from, attorneys from back home, short of going home.
Terence Crosby pleaded not guilty, and his first trial ended with a hung jury.
Mr. Crosby is adamant that he's done nothing wrong, that he's an innocent person.
If convicted, he could be sentenced up to 20 years in prison.
All right, we are restricted in what we can air in this case because we don't want to say the accuser's name in this case. So it's taking a little while. We're going to edit today's testimony throughout the day. But right now, let's go back and listen to some of the opening statements from yesterday.
Every act of violence begins with an opportunity and a decision to take it. Terence Crosby, a firefighter, had traveled to Boston from Ireland, along with other members of the Dublin Fire Brigade in March of 2024. They had all come to Boston. They had all come to Boston for the purpose of marching in the St. Patrick's Day parade. Typically, when we travel, we take an escape from our responsibilities in the stress of our everyday life. But instead, for Terence Crosby, he used his trip as a way to be anonymous, far from home, and to commit a rape he thought he could get away with. Now, this group of firefighters from the Dublin Fire Brigade landed in Boston in the late afternoon of March 14th of 2024, and they quickly began their festivities. The group ended up at a bar called the Black Rose, which is right near Faneuil Hall. It was a festive night, and St. Patrick's Day was coming up that weekend, and the restaurant was full of people that were eating, drinking, and dancing. You will see video from the Black Rose of the defendant and members of the Dublin Fire Brigade drinking and celebrating too. You will also see that the defendant met a woman there. He dances with her, and you will see them kissing. Terence Crosby walked out of the Black Rose with this woman, but soon after walked back into the Black Rose alone. Terence Crosby spent the night looking for an opportunity, and when one woman walked away, he found another woman who couldn't. On March 14th, Ms. had gone to court for work, and then she attended a work event with colleagues who included her good friend, Daniel Jacobson. Later that same night, Mr. Jacobson and another colleague decided to go to the Black Rose for dinner and drinks. While at the Black Rose, I met a man named Liam O'Brien, and they hit it off. Liam O'Brien was also a firefighter from Ireland and was here for the Dublin Fire Brigade to march in the St. Patrick's Day Parade. Throughout the night, they talked and danced, and eventually they left the Black Rose together to go to the Omni Parker House Hotel, which was the hotel where Liam O'Brien was staying. They walked to the Omni Parker House together around 11:40 p.m., and they had consensual sex in Mr. O'Brien's hotel room before eventually falling asleep. There were 2 beds in that room, and because Liam O'Brien was spread out across the bed, loudly snoring, he went to sleep in the other empty bed. And that's when it happened. Close to 2 in the morning, he woke up and realized there was a stranger on top of her, naked, violating her body and raping her. Like Liam O'Brien, this man had an Irish accent, but he wasn't bald like Liam O'Brien, and he had a different physique from Liam O'Brien. This man insulted Mr. O'Brien and insisted that he wanted this. Even as she told him to stop, and physically struggled to get away from him. As Liam O'Brien slept soundly in the next bed, snoring audibly, he was raped by a stranger. I didn't know it at the time, but that man was Terrence Crosby. Now, the defendant ignored her pleas to stop and continued raping her, repeatedly thrusting himself inside her body. Miss panicked and was focused on escaping, trying her best to stay safe from a stranger who she knew was willing to hurt her. Miss was eventually able to get out from under him, and she gathered her clothes and tried to leave. But the defendant wouldn't give up. He cornered her against the wall, touching her and telling her again that she wanted this. This all happened as Liam O'Brien slept, snoring after a night of drinking and oblivious to what was happening. She was able to lock herself inside of the bathroom and get away from Terrence Crosby, who had just raped her. As she left the Omni Parker house at approximately 2:20 in the morning, she texted her friend and colleague, Daniel Jacobson, who she had been with at the Black Rose, and she told him what happened to her. By 3 in the morning, she was at the emergency department at Mass General Hospital, where a doctor and a nurse performed an evidence collection kit on her, taking swabs from inside and outside of her body to search for potential evidence.
Good afternoon, ladies and gentlemen. Once again, my name is Captain Courties. Along with my colleague, Jake O'Reilly, we represent Terrence Crosby. Terrence Crosby will be seated right here in between me and Attorney Riley for the entirety of this trial. We'll be seated here because this is the only avenue he has to fight these allegations. The allegations that he denied from the beginning and allegations that he denies to this day. Unless or until the Commonwealth presents enough credible evidence to you to find him guilty of these allegations, he will remain seated here, an innocent man.
Okay, Counsel, can you come in for a second?
Yes, Your Honor.
Courtroom, please.
Now, I want to talk a little bit about the evidence that I expect you will hear in this case. I expect you are going to see the Commonwealth put on a number of witnesses and introduce a number of exhibits in order to, I submit, try and reach their very high burden that they must meet so as to convince all of you that Mr. Crosby did what he is charged with. I expect the Commonwealth will put on detectives and experts and airline record keepers and bar managers and hotel security specialists and crime lab scientists, and they're going to show you video and screenshots and tests and records and all this other stuff. But as you will see, I expect none of that will be able to tell you or show you what happened inside room 610 of the Omni Parker Hotel on March 14th. You won't have any video of inside that room that night. You aren't going to have any audio of inside that room that night. No. The only evidence the Commonwealth can present to you from inside room 610 that night is the word of a woman named. And when she gets up there and she tells you what she perceived to have happened in that room that night, pay close attention. Because I submit her story is what the Commonwealth will rely on when they try to meet their burden. And when you listen to her and you hear her tell you that she had been drinking for not just a little while at the end of the night, for 10 hours that day, think about what you will also hear. That her blood alcohol level, as the Commonwealth's own witness will tell you, was as high as 0.235. And I expect that you will hear from both her and detectives in this case that her memory has, as they put it, gaps. You will hear from both her and detectives in this case that she has talked about the amount she drank that day at least 3 separate times. And you will hear that that amount that she claims to have drank that day has changed at least 3 separate times. And I expect you'll hear, though, that her drinking, no matter which version she tells you, her drinking consisted of numerous drinks at a work party, splitting multiple bottles of wine, more drinks at a bar, and a shot before the time she claims Mr. Crosby attacked her. You will also hear that she has never identified her attacker or Terrence Crosby as her attacker, despite the fact that the evidence, the Commonwealth's own evidence, will show you that they met. Mr. Crosby met at the Black Rose just a little while ago before her arrived at the Omni Parker Hotel. She shook his hand, and she even hugged him goodbye that same night. But she has never identified him as her attacker, despite emphasizing that during her assault, she claims the light was on and she could describe her attacker and she got a good look at him. She's never identified our client as that guy. You also hear that she repeatedly told police that when she arrived, no one was in room 610 that night. When her and Mr. O'Brien walked into the room, no one was in there. But, again, as the Commonwealth's evidence will show you, Mr. Crosby was in that room already. You will hear that doesn't remember that. Doesn't remember seeing a full-grown person in the room when she arrived. And I expect you will see photos of the hotel room, and you will see how big or not big that room is. And yet she doesn't remember seeing anybody. As for Liam O'Brien, you will hear that other than Mr. Crosby, he was the only other person in that room that night. But you will not hear that from him. You will not hear that or anything at all from Liam O'Brien because you won't hear testimony from him at all. Despite that, though, I expect you are going to hear plenty about Liam O'Brien from both and Joseph McDonough, the detective in this case. For instance, you will hear that Liam O'Brien was approximately, or is approximately, 5'9". You will hear that is also about 5'9". You will hear that in one version of her story, she described her attacker as being similar in height to her. Our client, though, is almost 5 inches taller than both of them. But there is more you will hear about Mr. O'Brien. You will actually hear that it was his DNA that was found and identified on. I keep mentioning what you will have and what you will hear, but let's talk about what you will not have. You will not have anyone get up there and tell you that Mr. Crosby's DNA was found.
All right, that was snippets from both the Commonwealth and the defense in their opening statements. Today, they are back at it, and the accuser is back on the stand, and we are going to be airing that within the next hour as soon as we get it in. Let's bring in our guest for the hour, talking about this fascinating case in studio. Chris Darabia is with us, was here last hour as well, and trial attorney Mackenzie Joy Brennan is also with us. Mackenzie, to you first. What's your overall take of this case, the strengths and maybe weaknesses of the Commonwealth's case?
Yeah, I mean, obviously there are some pretty big holes. Liam O'Brien's absence is a big one. It's too bad, and you have to wonder if there are some organizational loyalties that kept him from testifying, but that would have been very helpful. On the other hand, even according to the accuser's account, he was asleep, so who knows what he could testify to versus not. But certainly that gives an opening for reasonable doubt. The lack of DNA in the rape kit, you know, for those of us who know how these things go, that's not dispositive at all, especially given that she had had consensual sex with somebody shortly before this happened. We don't know if DNA would have been produced by the encounter that she had with the person that she's actually accusing. But again, for a jury, that is something that they would like to see, especially given that she did seek a rape kit. And I don't know, I do think the fact that she's an attorney could cut both ways. As your guest was saying, for those of us who are attorneys, we know that that oath is taken so seriously that she wouldn't put herself through this if it were frivolous or attention-seeking, although I don't know what kind of positive attention would come out of something like this. But I could see jury members thinking that she's savvy and knows how to fake something like this if they are disinclined to believe a victim to begin with. Obviously, we know that this ended in a mistrial before, so there are some holes that can be exploited.
Yeah, absolutely. The fact that the jury couldn't come to a decision the first time around is a potential issue. The O'Brien not being there, Mackenzie brings up a good point. This is an intentional, I'm going to support my firefighter buddy and not participate? Do you think?
I think that there could be multiple reasons for it, you know, least of which, or most of which maybe, is that he lives in Ireland and getting...
He got himself over here for the St. Patrick's Day parade last year.
Exactly. But, you know, I think that that does play a role in travel and expense and all of that. But I also think in not having the power of the subpoena over him to force him to come. Yeah. And so you remember the prosecutor has to be able to get people there. And if he doesn't want to be there, she can't make him be there, you know, in terms of getting...
Why would she make up this story?
I just...
She doesn't know the guy.
Yeah, I don't think there's a reason to. I really don't, Ted. You know, we were talking about this a little bit. You know, there's no lawsuit happening, no civil lawsuit happening. There's no motive to lie. She's a survivor putting herself out there for scrutiny. She knows what, you know, as a lawyer, she knows what this is like. She knows what, you know, she's going to, the victim shaming and all of that that will accompany it. I don't think that there is strong motivation for her to be making something like this up. You know, they don't have a history together. It doesn't track to me as a made-up story.
Right.
Where some of them, you know, you think, oh, that would be a really good one for the defense for a made-up story.
Yeah, there's no, I don't get it, why she would make this up. You know, she's already in a hotel room and admits that on her own volition. It's not like she left and had regrets about that decision. It's a unique story. Let's get a break. When we come back, we'll be playing out more of the testimony from this case out of Boston, but we're gonna head to California. Jake Haro has pled guilty to the murder of his 7-month-old baby. This was a shocker. Stay with us.
I'm going to ask you a lot of intensely personal questions. How do you explain it? The worst crime anyone can imagine. Do you feel like you took the fall for this murder? Tell me in your own words, what happened? Let's get started.
Interview with a Killer. New season premieres Saturday, October 25th. Only on Court TV.
We're going to switch gears now to California briefly, where the father of missing baby Emmanuel has now pled guilty to his infant son's murder.
How do you plead to the charge in count 1 of the amended complaint of violation of Penal Code Section 187A?
I'm guilty.
And for clarification for the record, that's going to be in the second degree?
Yes.
Sir, do you admit that you committed a violation of Penal Code Section 187, Subdivision A, a felony, in that on or about August 5th of 2025 through and including August 14th of 2025 in the county of Riverside, state of California, you did willfully and unlawfully murder baby Doe, initials EH, a human being?
I admit.
Jake Haro, you see him, he sobbed in court yesterday as he admitted to abusing and murdering his defenseless 7-month-old son. Baby Emmanuel's remains still have not been found. He admits to doing it, but he apparently hasn't told anybody the details. His wife, Rebecca Haro, was in court too, but pled not guilty. She's scheduled to have her preliminary hearing on charges of murder and filing a false police report on November 3rd, the same day that her husband Jake is scheduled to be sentenced. The false report charges stem from the defendant's falsified reports of Emmanuel's abduction on August 14th, when Rebecca Haro claimed she was attacked in a parking lot while changing the baby's diaper. You remember this? And Emmanuel was then kidnapped. Of course, it was all a bunch of lies. We'll continue to monitor the developing case. Let's talk about it. Krista Ramey and Mackenzie Joy Brennan still with us. And Krista, this was, you've got this family telling this elaborate story about an abduction. Do you think that Dad is covering for Mom, and at the end of the day, he's gonna fall on the sword, and that's why he's not coming completely clean? Because where's the baby?
Where's the baby? When this happened, I thought that immediately. Like it seemed orchestrated, and like stories that we've heard in the past with babies gone missing. I think about several murders that have ended up happening that way. But here you don't have any evidence of where this child is. No remains have been found, and the baby was with the mother when it happened. So I think there is something to that, Ted. Why haven't we heard where the baby is? And maybe the father just quite frankly doesn't know. Maybe he is guilty by helping her. Ultimately, did she leave the baby in the car? Did she shake the baby? What happened? Well, I don't know if we'll ever know. But that is the biggest question mark.
Yeah, let's listen to them telling folks, please bring my baby back.
We come to you guys asking you to help us find our son. He was abducted last night from Big 5. Somebody struck my wife while she was trying to change his diaper. And we just ask if anybody knows anything to please contact Ukaipa Police Department.
Don't hesitate, just call.
Mackenzie, while that was happening, to Krista's point, there was the uh-oh feeling, and just watching it was cringy because you felt like, oh no, something's going on here. What do you think is the reason that Dad is saying I did it and Mom is pleading not guilty?
Yeah, it's hard to know. Certainly, she must know something because she was the one who was with the child in their version of events when he disappeared. On the other hand, he does have the history of violent abuse of children, at least something that reached a court level, and she doesn't. So that does make me think that he is more prone to violence. I also think there are plenty of reasons, none of which we want to think about too deeply, that could explain why he was unable to find remains or why they were unable to find remains. Obviously, we saw footage of him out there searching with police, so there has been an attempt. But I don't know. I think all of us saw the missing kid poster and cringed a little bit. And like you were saying, Ted, we all knew from the beginning that this was not going to end well.
Yeah, and we'll say it's a good point that, maybe she was covering for him with the elaborate, Big 5 kidnapping story. He said, here's what we're going to do, or tell this story. And a lot of questions, but the charade is over, at least on Dad's part. Let's get a break. We're waiting again for that testimony to come in from Boston. But as we wait, you remember this. We saw this entire trial play out. Bianca Ellis found guilty. Well, her attorneys joined Julie Grant this morning, and we're going to listen to that when we come back. They say the jury got it wrong. Welcome back to Court TV Live. Good to be with you on this Friday as we round out another week. We're awaiting more testimony out of Boston in the firefighter case. We're going to turn our attention to Ohio now, where the attorneys for now convicted killer Bianca Ellis spoke with Court TV earlier this morning. Ellis was, of course, found guilty on all charges earlier this week for fatally stabbing a toddler and injuring his mother. The jury deliberated for 8 hours before making this decision, and they were tasked with making the decision of whether or not she was legally insane at the time of this incident. She had a mental history, a mental illness history, schizophrenia, et cetera, and jurors were very clear that it was made clear by both sides that the history was there, but did she know right from wrong? Earlier today, the defense attorneys spoke with our Julie Grant about the verdict and Ellis's mental health.
It was a sad case all the way around. I mean, a young child died, for no reason but for her mental health. And I think the jury possibly got it wrong. I think our doctors was correct. I mean, she's a sick woman. She's been sick for a long time. And Fernando and I had an opportunity to meet her when she was at one of her worst points. And once forced medication got involved, she was a totally different person. I mean, totally articulate, a sweet young lady. You would never think she could harm a fly if you met the lady on medication. We took breaks to make sure her medication remained on schedule. You wouldn't have noticed, but the judge synchronized breaks for the jury so she could go down into the jail to make sure she was administered her medication. And she was heavily medicated. She didn't communicate much with us, but she did communicate.
Ellis will be sentenced October 27th, 8:30 a.m., facing life in prison, of course, for those guilty verdicts. Still with us, Krista Ramey, Mackenzie Joy Brennan. Mackenzie, this is a difficult case because mental illness was clearly present in the defendant, but at the end of the day, the jury decided with the state. Your thoughts overall, and listening to the defense attorney, your thoughts there?
Yeah, I used to work in adult guardianship, and the difficult thing about forced medication is that it can only be enforced until or unless that person is no longer a threat to themselves and others. And obviously, you see in a case like this, they then are free to go off their medication, and what is to prevent that happening again in future? You often see cases where either the medication side effects are things that somebody can't tolerate, or they think, I'm doing so much better, I don't need this anymore, when really it was the medication that made them so much better. But enforcing that beyond some sort of criminal intervention isn't possible after they are stabilized. So I think that's the problem going forward when somebody has not been medicating themselves of their own volition and that ended up in something extremely harmful happening. And so that's what you have here.
Yeah, a lot of times, Krista, unfortunately, when you see something tumbling out of control within an individual's mental health, it's not until they commit a crime until that they can really be handled by law.
Yeah,
especially an adult.
Yeah, yes. There are, I know that there are laws in California, 5150 holds you can put people on. It's only for limited periods of time. It's not, it's for, I think 72 hours, and then you release them if there's nothing, if they won't self-commit. So there are some ways to intervene, but really you're watching that spiral. And like Mackenzie said, there's not really anything much you can do about it in terms of stopping it unless you can do one of those holds, and that's only temporary. It's a Band-Aid. When someone's got a mental illness like this, there's going to be more times it's going to pop up.
Both sides, as referenced in that interview, had experts that testified. Let's take a listen to both sides.
After that, can you identify what your opinion is?
So ultimately, to summarize, it's my opinion with reasonable medical certainty that Ms. Ellis suffers from a severe mental disease, namely schizophrenia, and was experiencing symptoms at that time related to this illness that caused her to not know what she was doing was wrong.
It's my opinion with reasonable medical certainty, however, that the defendant did not have a severe mental disease or defect at the time of the June 3rd, 2024 offense that caused her to not know the wrongfulness of the offenses. So despite having schizophrenia, it did not cause her to not know the wrongfulness of the offenses.
All right, experts cancel each other out. A lot of times Mackenzie. In this case, we were just talking while that was playing. Jurors have a choice in a case like this, and that is guilty or not guilty by reason of insanity. If the verdict form read guilty but nuts, you would have jurors say, oh yeah, that's exactly what we saw play out here. But the not guilty portion of that verdict form, I think, makes it virtually impossible for jurors to say, no, we can't find her not guilty. We watched her stab a 5-year-old.
I think you're absolutely right. And that is something that a lot of states have actually done, really in the wake of John Hinckley Jr.'s conviction, or not guilty verdict, rather, for that reason, that the public reaction to finding somebody not guilty is that it's just unpleasant. So a lot of states have enacted this guilty but insane verdict option to avoid exactly what you're talking about.
And then it triggers, and because jurors really are not supposed to think about punishment, but of course you do. I mean, the idea of letting this woman out is horrifying for a juror, right? What she did was dangerous and scary on every level.
Yeah. I mean, who knows what jurors actually talk about when they're back there, but of course they talk about things they're told not to talk about or not to consider, because it's human nature to think about exactly what you're talking about, Ted, about, this person's gonna get out and do it again. They're gonna go off their meds, just like they have in the past, and they're gonna be a danger to society, so we can't do the guilt or not guilty by reason of insanity, because like John Hinckley Jr., that person's gonna get out.
And what's wrong with that thought process as a society? Because when someone does do something so egregious, so scary, who wants to roll the dice that it's not gonna happen again?
No one, and I'm fine with it. I mean, I really am. I wish there was a not guilty or guilty but insane option, rather. I think that provides a different level of comfort to people that don't want to say the not guilty part of it. And ultimately, in states where there is the guilty but insane option, I'm tongue twisting this up, they're incarcerated still. It's not like they're out free as a bird. So, there is safeguards with that, but I think it maybe gives someone a little bit more comfort, because the big question, always is, did they know right from wrong at the time they did it? And
right. And who knows? Because who knows what's going on in that end, or in any of these scenarios. They're all sad, and I think it was well put by that attorney. This is such a sad case from start to finish, and it just is. There's no other way around it. A little boy lost his life, and his parents lost their boy. Let's get a break. When we come back, a woman sentenced for a fatal crash that left 2 Amish children dead. The twin, Samantha Peterson, what she had to say in court.
Donna Adelson was part of a conspiracy to kill her former son-in-law, Dan Markell.
He's not going to survive.
Oh my God!
Dan saw Donna as dangerous.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific. And during the finale, don't miss an exclusive preview for the new season of Interview with a Killer. Only on Court TV.
Let's turn to Minnesota now, where the woman who killed 2 Amish children in a meth-fueled crash, Samantha Jo Peterson, pled guilty to 2 felony charges stemming from the September 2023 crash. Peterson initially tried to pin the crime on her twin sister at the scene, but now she admits she was the driver and was high when she crashed into the back of a horse-drawn buggy. Let's take you into the courtroom now. Listen to Samantha Peterson addressing the judge.
I want to begin by saying how deeply sorry I am to Sarah, Mena, and the entire Miller family. I stand before you today to take full accountability and acknowledge that I should have never been driving on the morning of September 25th, 2023. The loss of Irma and Wilma and the harm that I've caused to Ellen and Rosanna are entirely my fault. No words or apologies can bring back Irma and Wilma. But I need you to know how truly, deeply sorry I am. My actions caused the Miller family a pain that no parents or family should ever have to experience. The guilt and shame I live with every day are nothing compared to the loss that they've endured. I know I have caused an unthinkable void in their lives. I cannot imagine the grief that they carry each day, but I recognize the depth of the harm that I've done. I think about it every single day, and I know I will carry that weight for the rest of my life. There's no excuses for my action that morning. Every day I wish I could go back and make a different choice. My addiction took a lot from me, but it took your world from you, and for that, I will never be able to forgive myself. Every day, I wish it would have been me instead of them. I know forgiving myself may never happen, but I am working towards healthier ways to cope, staying committed to my sobriety, and dedicating my life to honoring the memory of those I took from this world so that nothing like this ever happens again. I also want to sincerely apologize to law enforcement and to the court for my dishonesty following the accident. In my fear and shame, I made terrible decisions to deceive the police and the justice system. I know that my actions disrespected the officers who are simply doing their jobs and the court that seeks truth and justice. I am deeply sorry for that. I have learned that integrity and honesty must guide my life moving forward, no matter how difficult the truth may be. The guilt and sorrow I feel are constant reminders that the devastation I caused. I wish with everything in me that I could go back and change what happened, but I know I cannot. Since that day, I have chosen to get clean and sober. I have been fully committed to my recovery and actively participating in therapy to address the issues that led me down this path. These changes cannot undo what happened, but they are steps to ensure that I never cause harm again. I know that no words can undo the harm I caused or bring peace to the family that has suffered such an irreplaceable loss. All I can do is admit my wrongs and continue to work every day to live differently and accept the consequences for my actions. Your Honor, I humbly ask for mercy in sentencing, not to avoid accountability, but to allow me the opportunity to continue the work I've started in my recovery and to someday make amends in any way possible. I'm committed to honoring the memory of Irma and Wilma in every way that is honest, sober, and responsible. Thank you.
I do find that you are genuinely remorseful. I think you were candid in your material, your treatment provider notes, that you're certainly remorseful for what happened. I do disagree with your attorney that in the moment, at the time, I don't think that those text messages showed genuine remorse. I think there was some remorse, and that you do have a conscience, which was demonstrated by some of your actions. But I think primarily at the time, if you really look at those text messages, it was really all about you and what was happening to you and your life at a time when children were literally dying in a ditch. So I don't agree on that assessment, but the case law is clear that when you come to court and everything that happens in between, you've demonstrated remorse. I believe your heartfelt statement here today. You do have the support of friends and family as well. And of course, the major component with respect to rehabilitation, one of the factors, is that you have completed extensive treatment, which is to your credit. I want to be clear, though, that I am not departing from the presumptive sentence. It's not appropriate in this particular case for a number of reasons, despite the arguable presence of that particular factor. Particularly, the court looked at, when reviewing all of the information and those sentencing factors, the conduct itself cries out for a consequence, accountability, a punishment. You were a meth user for over 10 years. You had the 2 prior DWIs, and you were still choosing to use and be on the road. You had numerous opportunities to address the issue prior to this incident and this intervention. You were driving on an open road, high on meth. There was no visibility issues or weather issues, and you plowed into that buggy. You did call 911, but you didn't identify yourself on that 911 call. And while you may, based on your material, have comforted, at least for a short period of time, one of the children, your action that day quickly turned to intentional and deliberate attempt to not be caught. And that was your focus. That focus was something that you had done in the past, apparently, with your giving false name to police. I know it came up in your sister's sentencing as well. 36 hours later, law enforcement came to your door, and you were still attempting to not be caught. It took other people doing the right thing. Your Hy-Vee HR director, your Hy-Vee manager, your niece even, if memory serves, went to personnel at school and indicated that this is not right. I'm scared because they've switched and my mom may go to prison. Other people knew the difference, even children, between right and wrong, and you were still focused on not getting caught. Ms. Peterson, I am committing you to the Commissioner of Corrections for a period of 48 months. Minnesota law requires that you serve at least 2/3 or 32 months, with the remaining 16 months on supervised release. Ms. Peterson, I will note too, and I'm sure you've talked about this with your attorney, it's entirely possible, because of all the good work you've done and the treatment that you've participated in and completed, you may very well qualify for early release programming with the Department of Corrections, and of course you've earned that as well with your conduct.
All right, quickly, reaction. Mackenzie Joy Brennan, she'll be out less than 4 years, it sounds like. 2 kids are dead.
Yeah. It's interesting. It's not dissimilar from the Ellis situation, given that, she's in treatment now. But we do see that they said that she'd been using for 10 years prior and had 2 prior DWIs. So the fact that she is eventually remorseful and seeks treatment in that pre-sentencing period, it's a pretty high incentive in that period to be your best self. So I don't know. It's a little low, but hopefully it keeps her clean, I guess.
Quickly, Krista, too light?
I think it is. If I'm the mother of those 2 children, I'm pissed about this.
Yeah.
Really pissed.
Yeah. Well, let's leave it there. Thank you, ladies. Let's get a break. When we come back, we are going to be heading to Massachusetts. This Irish firefighter rape trial. This is a retrial. The alleged victim, the accuser here, is back on the stand today, and we are going to start listening to her testimony. We won't be able to show her, obviously. She's an accuser in a sexual assault case. But we're going to listen to the specifics of what she says happened that night. Stay with us.
That's 800-673-8080. Morgan & Morgan.
Welcome back to Court TV Live, along with Julia Janae. I'm Ted Rollins. Good to be with you on a Friday. We're in Massachusetts this afternoon, where it is day 2 of testimony in the Irish firefighter rape trial.
Yeah, this is one where prosecutors say that the defendant, Terence Crosby, raped a woman last year while he was visiting from Ireland to participate in the St. Patrick's Day parade in Boston. And the accuser is a 28-year-old woman, alleged victim. She says she first had consensual sex with Crosby's friend, but after she fell asleep in the hotel room that the men shared, she awoke to Crosby having sex with her.
Before we head into court, let's get you caught up. Here is Court TV Justice correspondent Matt Johnson.
March 14th, 2024. A night of Boston bar hopping ahead of St. Patrick's Day holiday ends with allegations of rape against a visiting Irish firefighter. 38-year-old Terence Crosby was visiting from Dublin and came to the U.S. to march in the St. Patrick's Day parade with other members of his fire brigade. He and his friend, Liam O'Brien, were sharing a hotel room when O'Brien met a woman at the Black Rose pub. According to court documents, O'Brien went back to the hotel and had consensual sex before falling asleep in separate beds. The 28-year-old woman says that she was awakened at around 2 a.m. by Crosby, who was having sex with her. She managed to get out of the hotel room and went to the Massachusetts General Hospital to get a rape kit performed and report the alleged sexual assault. Crosby was arrested the next day at Logan Airport, where he was preparing to board a flight after moving up his travel plans.
St. Patrick's Day weekend, the consulate wasn't open. He couldn't get advice from, attorneys from back home, short of going home.
Terence Crosby pleaded not guilty, and his first trial ended with a hung jury.
Mr. Crosby is adamant that he's done nothing wrong, that he's an innocent person.
If convicted, he could be sentenced up to 20 years in prison.
All right, let's go into the courtroom now, where the attorneys are meeting outside the presence of the jury. Again, this is from earlier in the day. We have a little delay because of the nature of the charges here. We can't identify, as we never do, the accuser. She's accused of,
she's accusing him of rape, and she
yeah.
is a sexual assault victim, according to the prosecution.
Right. So, because of that, it's a little tricky, but bottom line is, we have it now, so let's go in.
We have defense motions. What did you want to address?
Yes, right. So this is semi-related to our other motion, document 81. There is a series of statements that CC made to Nurse Littlejohn, who is expected to testify later today. We do believe that these statements, some of the statements we received prior, the second half statements we received on 2 days ago, they were made on October 8th of this year. They go to speaking about past sexual experiences and potentially prior assault, and how her mother wasn't there to comfort her, and which his motions are to...
You want to exclude them or include them?
Exclude them. Exclude them. But they're pure hearsay.
What's the Commonwealth's plan with that?
We assent. I have no intention of eliciting that from Carly Littlejohn.
Okay.
There's a new motion from counsel today regarding a more recently disclosed statement that I turned over. In speaking with Ms. Littlejohn, I asked about the portion of the kit forms that inquire about past consensual intercourse within the past 5 days, and asked her if there was more than one incident of consensual sex during that 5-day period, if she would know all of them, or just the most recent. She responded and added that she recalled Ms. Creamer remarking that she had not had consensual intercourse in several months prior to the night in question. So that, the last half of that statement, her recollection of what said on that front is what I recently disclosed to counsel following that meeting, and so that's the subject of his motion today, is to exclude that.
All right, so that is in the motion, defendant's motion to include certain testimony by witness Carly Littlejohn. Is that the motion?
Yes, that's the new one.
And so I'll hear you on that. We're expecting, are you expecting Nurse Littlejohn later today?
Yes.
Okay. I'll hear you on that, Counsel.
Your Honor, it's the same arguments pertaining to document 81 that these statements constitute hearsay without any exception, and I do believe they'd also be barred by the rape shield statute as well. If they came in through Nurse Littlejohn, they'd be far more prejudicial and probative for anything. It would bolster CC's statement. It's different as coming in through CC, but through Nurse Littlejohn, it's pure hearsay.
All right. Well, did CC testify to that herself?
No.
She can testify to that on the stand herself.
That's different. I agree. That's different. But if Nurse Littlejohn gets up there and says, "Oh, by the way, she told me she hasn't had sex,"
right? Well, I'll look at it. I'll read the statement and I'll read what you wrote. But it would typically be related to medical treatment and diagnosis. So I'll look at it more in more detail. But typically, it would be a statement for medical treatment and diagnosis.
Understood. So we could do further arguments after you read them.
No, I want to hear from you now, and then I'm going to read what you wrote because I haven't had a chance to do that.
So it is our stance that, and it's noted in our motion as well, this was not a statement made for the purpose of diagnosis or treatment.
And why not? She didn't ask it for a personal reason. She wasn't curious about the woman's history. Wasn't she asking for a medical reason? They didn't know each other before this, right?
It doesn't seem like she asked it at all. It sounds like from the context of the statements from Nurse Littlejohn that offered that up. That she hasn't had sex in several months and that she has prior sexual assault and her mom wasn't there for that.
But isn't it a question on the form that gets checked?
By Nurse Littlejohn, yes.
But she has to ask the person in order to get the information to check it, right?
I believe so, but that's not how it's conveyed in the statement.
Well, I need to see the medical record to see whether it's a part of the medical record, how it's recorded there. I know the complete statement's not there, but I need to see if it's part of the medical treatment.
And just to clarify,
diagnosis process.
If this did come in, is it this court stance that this does not pierce the rape shield statute?
Well,
we're going into other.
I mean, first of all, the rape shield statute does not prevent someone from saying, I haven't, and this goes to the issue of the DNA. So it's related to an issue in the case, so it's relevant because it goes to the issue in the case.
Perhaps in that 5-day period, but if we go into the months prior, does that not pierce?
Well, I don't think the rape shield statute applies to the absence of the sexual activity. I don't think it applies to that. It applies to the presence of it.
In understanding that, what I'm talking about is if she said last time I had sex was months ago, does that now pierce the shield? If she started,
she would be subject to impeachment on that. I mean, if you have some evidence that that's not true. I mean, if you have some good faith basis, then you have discovery obligations as well.
Right, but I'm just trying
so
to...
So why don't we just, before you introduce it, before the nurse testifies, we'll talk about this again. You need to identify the page of the medical records that I need to look at. And then I need to look at what has been disclosed, the details of what's been disclosed. And I'll read what the defense has written in opposition, because I just handed it to me. And then we'll talk about it either in court or in sidebar. And as I said, the defense has certain discovery obligations.
I'm sorry.
All right, we're ready for the jury.
Okay, that's how the day started with the parties outside the presence of the jury. Let's get a break. When we come back, the alleged victim back on the stand. She was on the stand briefly yesterday. Today.
Yeah, didn't get into the incident, so today we expect she is going to be deep diving into the reason we are inside of this courthouse.
I'm going to ask you a lot of intensely personal questions. How do you explain it? The worst crime anyone can imagine. Do you feel like you took the fall for this murder? Tell me in your own words, what happened? Let's get started.
Interview with a Killer. New season premieres Saturday, October 25th. Only on Court TV.
Welcome back to Court TV Live. Let's get you back inside of a Massachusetts courtroom where we are watching together the Irish firefighter rape trial, where defendant Terrence Crosby, whose brother is a well-known MMA fighter, and also managed by Conor McGregor, is accused of raping a woman. And this all happened last year over the St. Patrick's holiday weekend.
The alleged victim, who we are not showing or naming, admits to having sex with Crosby's friend in their shared hotel room. She says, though, after that, she was on this other bed and woke up and Crosby was on top of her. Let's go into the courtroom now. Yesterday, the alleged victim took the stand, only briefly, sort of a setup. They took the break for the day. She's back on the stand for day 2. Let's go in.
Creamer.
Good morning.
When we left off yesterday, I was asking you some questions about leaving the Black Rose.
Yes.
And you stated that you and Liam O'Brien, Liam had walked back from the Black Rose to his hotel at the Omni Parker House, correct?
Yes, that's correct.
How was the walk back from the Black Rose to the hotel?
It was about 10 to 15 minutes, maybe even less, but it was fun. We talked. We kissed. Continued to chat.
And during that walk back, were you able to continue observing Liam O'Brien's physical appearance and hearing his voice?
Yes.
I'm going to show you something and ask you if you recognize what it is. Did your screen come up?
It did, yes.
Thank you. Do you recognize that video?
I do.
And what do you recognize it to depict?
That's Liam and I walking from the bar to the hotel.
I'd move to admit this into evidence as the next exhibit, Your Honor.
Is it on live?
Yes, it is.
Any objection?
I don't have it on my screen. I assume it's what's been previously shown. Thank you.
Any objection?
No objection.
That will be the next exhibit.
Thank you. I'll keep it in, if that's all right. May I publish it to the jury, Your Honor?
Yes.
All right, I finished playing the video. So at that point in the night, is it accurate that you had on and off been consuming alcohol, as well as food and water and other things throughout the afternoon?
Yes, that's correct.
And evening?
Yes.
Were you feeling any of the effects or any effects of the alcohol at that point?
No, I was feeling social, but I believe I'm a social person, but I didn't feel it physically, meaning I wasn't stumbling or anything like that.
The amount of alcohol that you had to drink over the course of that day, was that an unusually high amount of alcohol for you to drink if you were out in a social setting for the night?
No, considering that it was over the course of, more than 9 hours, no.
When you got to the Omni Parker house, did you use a particular door to enter the hotel?
Yes, it was the side, I believe it's the side entrance, referred to as the side entrance, on the side street.
May I approach, Your Honor?
You don't need to ask.
Oh, yes, thank you. Sorry. Yeah. I'm handing you a photograph, and I'll just ask you to look at it and tell me if you recognize what it shows.
Yes, this is Liam and I walking into the Omni.
I move to admit that as the next exhibit, Your Honor.
Any objection to the photograph? No objection. That will be marked.
So now exhibit 4.
Thank you. And may I publish this, Your Honor, as well? All right, now displaying what was just marked Exhibit 4. You said that was you and Liam entering the Omni Parker house?
Yes.
Once you got into the hotel, where did you go?
We went to the elevator upstairs.
Do you remember what floor of the hotel the room was on?
No, I didn't press the button. Wasn't paying attention to which button was pressed.
How did you get into the hotel room?
Liam had a key card.
Did you go directly to the room or did you stop anywhere on the way?
We walked to the room.
When you went into the room, do you remember if the lights were on already or were they turned on once you got inside?
There was one light on, but all the other lights were off.
Where was the one light that was on?
Excuse me. It was in the bathroom, which was right when you walk in to the room.
Can you describe the layout of the hotel room?
Yes, of course. So you walk in, to the right is the restroom, to the left is a mirror, or maybe a closet with a mirror on it. If you continue walking, you come into the actual room where there was 2 beds to the right, one close to a window, the other pushed against the wall.
I'm going to show you some photos and ask if you recognize what they depict.
All right, we're getting now into the hotel room, the beginning of the story, and this is when jurors are going to be absolutely focused because this is it. They're going to listen and judge her credibility. Let's bring in Marlo Greer. She is an attorney that represents victims of sexual assault, and it's very difficult. These cases are difficult.
Very.
What stands out about this case specifically to you?
I think we were talking a little bit about the DNA or the lack thereof. I think the jury's going to really grapple with that. It's always, these cases are hard in that I don't think this is about a consent case because he's not saying that she consented, right? He's just saying no, that it wasn't
He's
me,
claiming
I
he
wasn't
didn't
there.
do anything.
Right.
So, and that she's made up this crazy story, but why would you make this story up?
That's the thing that I have such a hard time with is, why would you make the story up? They don't even have the, oh, okay, she's just out for money, which is usually what people say, right? She's just out for money, that's why she's making this up. But they don't even have that here. It's just, she's making it up and she would put herself through all of this. I mean, she's on the stand and it's nerve-wracking when people do what we call depositions, where they're just sitting in a room with a couple people, let alone in a courtroom and talking to a jury. And why would you do that? I mean, why would you say, okay, I want to make this story up so that I can go to court and have people drag me through the mud? It's just, it's so hard for me to understand that that would even exist.
When we've got civil versus criminal, you represent a lot of these victims in the civil arena. Once we get to criminal and the standard is beyond a reasonable doubt, how hard is that when you've got essentially he said, she said? If we don't have DNA, there's not a lot of independent evidence, but this jury's got to believe beyond a reasonable doubt to convict.
They do, and they really have to believe her. And the description, she's talking about, tell me what the hotel room looked like, and we notice that he's scribbling down, and, are they going to cross-examine her on her memory and her credibility there? But they really do have to find her credible.
Yeah. Absolutely. Stand by, Marlo. We're going to get you to a break, and when we come back, we're going to have more of this testimony, all important, the alleged victim on the stand in the firefighter rape trial. And Matt Johnson is also going to give us an update to preview our newest live trial that's starting next Monday. Stay with us.
at packaging.com.
We're going to head back to court in Massachusetts in just a minute, but first we want to turn our attention to New Hampshire, where a new trial will start next week.
Yeah, we want to get you updated on this one as a preview, the Amber Alert murder trial of Dustin Duren. First, let's listen to a background on this case. Ashley Wilcott has more.
38-year-old Dustin Duren is charged with murder in the death of 31-year-old Caitlin Knopfziger, the mother of his children. Prosecutors say that on February 29th of 2024, Duren shot Knopfziger and took their 2 young daughters. Knopfziger's body was found in an apartment, and an Amber Alert was issued for the 2 children. Someone recognized Duren's car described in the Amber Alert and called 911. WMUR spoke to the Good Samaritans.
I was like, oh, white Subaru. I'm like, oh, vet plates. And I was like, Mom, that's the guy.
I did videotape him being put in cuffs, and there you can slightly see them taking the children out of the car.
Duren was pulled over and arrested. The children were in his car and were not harmed. Before his arrest, Duren had a YouTube page that is still up. He described himself as a gamer and a veteran, and posted videos playing the guitar. Duren claims he shot Knopfziger in self-defense to protect their children. He says she was about to kidnap them. Knopfziger died of a single gunshot wound to the head, and her family describes her as a loving mother whose spirit lives on in her 2 girls.
Let's bring in Court TV crime and justice correspondent Matt Johnson, who's here with us. What can you tell us about the arrest of this suspect, Matt?
Yeah, Ted, Julia, good afternoon. This case is one that rocked New England and made headlines across the country. Investigators discovered the body of Caitlin Knopfziger on February 29th, and by the next morning, police had issued an Amber Alert for Dustin Duren and his 2 daughters. They were just 1 and 4 at the time. The Amber Alert was all over the local news, highway signs, as you can imagine, and that's when some everyday citizens stepped up and spotted his car outside of a restaurant 160 miles south of the crime scene. They called police. WMUR TV interviewed them. Take a listen to this.
We just turned around and I told her to call 911.
I told the 911 operator, I said, I think he sees us. And it was a little scary at that time. You know, we did it as mothers, you know, as a parent and a grandmother and stuff. You know, that's what Amber Alerts are for, you know, to help. And we did it for the children.
Now, for your knowledge, alleged parent abductions don't always meet the requirements for an Amber Alert, but police believe that these children were in grave danger at that time after their mother was found executed in her home. Ted, Julia?
Yeah, tell us more, if you would, about the victim.
Yeah, we love to focus on the victim in these cases. 31-year-old Caitlin was a twin and originally from Minnesota. She loved being a mother, according to her family, who also posted this online, a tribute to her. Caitlin was small but mighty, quiet but fierce, and as brave as they come. She had many nicknames, Chai and Goose, to name a couple. Her loved ones would like her to be remembered by her spirit. The spirit of Chai is a whimsical wanderer, along for the ride, up for the adventure, and multi-talented powerhouse. The spirit of Chai and joy lives on in her 2 beautiful girls. On Monday, this murder trial is set to begin for her husband, Dustin Duren. That's expected to start with those opening statements. Now, he faces life in prison without the possibility of parole if he's convicted.
Yeah, and again, he's claiming that this was self-defense, that he had to shoot her because he was fearful.
That is
We'll
his
see.
defense, his right to
It's going to be a
defense.
good trial. Thanks, Matt. Let's head back to Massachusetts now for the Irish firefighter rape trial. Another good one for Terrence Crosby, the alleged victim, the accuser, still on the stand. Let's pick it up where we left off.
Your Honor, I would move to admit this USB as the next exhibit. It has 11 photographs on it.
Counsel, any objection? That will be admitted.
And may I publish the exhibit, Your Honor?
Yes. Admitted as.
Admitted as exhibit number 5.
Thank you.
All right, can you explain what we're looking at in this photo?
This is the entrance. So you're walking through the door to the hotel room, where the bathroom is on the right and the mirror, as I said, is on the left. And then if you walk in further, you see the remainder of the room.
All right, I'm going to show you the next photo on this USB. Is this a bit further into the room?
Yes. That is the bathroom on the right when you walk in.
So for the record, I'm on the third photograph on this USB. Is this also a photo of the bathrooms from another angle?
Yes, it is.
And I'm moving on to IMG 1333. Is this the kind of bedroom portion of the room?
Yes.
I'm just moving through the rest of the photos. This last photo, ending in 1340, what is that?
This is a view of the door from inside the room, where you see the bathroom's actually on the left and the mirror on the right.
Thank you. When you went inside that hotel room, did you notice if anyone else was in there?
There was no one else in there.
Were you aware if Liam was sharing a room with anyone else?
No.
What happened once you and he went inside the room?
We continued to kiss. We then had consensual sex that consisted of vaginal penetration, as well as I performed oral on him and continued kissing.
And when you say kissing, did Liam kiss you anywhere other than on your face?
No.
How much time would you say you spent in the room before that began?
I would say it was almost immediate. We had been kissing previously. We walked into the room and we continued to kiss and undressed.
And you say undressed. Where did your clothes go?
They were throughout the room in different places, predominantly though near the window by the further bed.
Where within the room was this happening?
Predominantly close to the window, and then in the bed closer to the window.
So the one that's further from the door?
Yes.
So looking at this photo from the last exhibit ending in 1332, it's the one further from the viewer's perspective in this photo?
Yes.
Okay.
Counsel, could you hold for a moment?
Thank you. Do you know now if Liam wore a condom?
He did not.
What happened after consensual sex with Liam ended?
I went to the bathroom. I then came back out to go to sleep, but Liam had fallen asleep in the bed further from the door, so closer to the window. And the way that I would describe it as a starfish, very spread out on the bed. So instead of getting into that bed, I got into the bed closer to the door. And then I fell asleep.
When you came out of the bathroom and got into that other bed, did Liam wake up at all?
No, he was snoring quite a bit, quite loud.
And from that point on, was his snoring sporadic or was it pretty continuous?
No, it was quite continuous.
Now, the following day was a Friday, is that right?
Yes, that's correct.
What was your plan for when you would leave the hotel?
I would leave when I woke up in the morning and then go home.
And you said you fell asleep when you got into that other bed.
I did.
Did you have any clothes on at that point when you fell asleep?
No, I did not.
Did your clothes remain kind of throughout the room, but primarily toward the window area?
Yes, that's correct.
The bed that you got into, that bed, that you referred to a moment ago, was that made or unmade when you got into it?
Sorry, it was unmade.
And did you?
I'm sorry, it was made.
Made. So,
yeah.
So it appeared that no one had been in it.
Correct.
Is that correct?
Yes.
Okay.
I'm sorry.
And did you sleep under the covers with the blankets covering you?
Yes, I had drawn the sheets back and gotten into the bed.
Okay, detailing those moments, saying that she believed the bed was made, no one was there, so she used that bed. Let's get a break. When we come back, she'll continue to tell her story, and we'll be listening. Stay with us.
Donna Adelson was part of a conspiracy to kill her former son-in-law, Dan Markell.
He's not going to survive.
Oh my God!
Dan saw Donna as dangerous.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins, season finale, Saturday night at 8 Eastern and Pacific. And during the finale, don't miss an exclusive preview for the new season of Interview with a Killer, only on Court TV.
Welcome back. Let's get you back inside of the Boston courtroom where a retrial is underway for a man who is charged with raping a woman. This all happened last year during a St. Patrick's Day parade.
Yeah, Terrence Crosby. He's an Irish firefighter. He was visiting Boston with his buddy, another firefighter, and they're marching with their brigade in the St. Patrick's Day parade. Well, things, according to prosecutors, turned into a night of drinking at the Old Black Rose. Crosby is accused of raping this woman at the Omni Parker Hotel. And Crosby's defense team is saying this is actually false. These are false claims saying that he didn't touch her, and he is maintaining his innocence. This is a married father of two back in Ireland, but he's been incarcerated since this began. There was an initial trial. Jury could not come to a unanimous verdict, so here we are now with a retrial.
Right, and the accuser on the stand again in this trial, and she is just starting to talk about the situation inside of this hotel room. She admits to consensual sex with the friend of the defendant and said she was sleeping in the other bed in the room, did not know that the defendant was also sharing that room. Let's pick it up where we left off.
How do you normally sleep? Are you a side sleeper, on your back, or something else?
I was sleeping on I slept on my back at that point.
What is the very next thing that you remember happening after you fell asleep?
I woke up to somebody on top of me, inside of me, in his penis in my vagina, on top of me, telling me, you like this, he couldn't give this to you, I'll give it to you, he's a loser.
Did you know who that person was?
Not at the time, no, but I knew it wasn't Liam because Liam was still asleep in the bed next to me.
How could you tell that he was still asleep?
He was continuing to snore, continuing to be in that same position. And, you know, after I had woken up and the next steps, he continued to be in that bed snoring.
Did he ever appear to wake up at all through the rest of the time you were in the room?
No.
When you woke up, and you said the person was inside of you, were you still on your back at that point, the same way you had fallen asleep?
Yes, I was on my back and he had his weight on top of me with his hands at my shoulders.
Other than his penis inside of you, were you able to feel any other part of his body on your body?
I felt his weight on top of me, but no, I wasn't trying to feel anything else.
Where was his face in relation to yours?
He was above me.
Was his face, what was its proximity to yours, if you remember?
I mean, so I was lying down, so at that point, maybe, I don't know, with his hands on my shoulders, I don't know, maybe a foot, but I'm not really good at math, so.
Okay. Do you recall what you were looking at when you woke up? Did you see a person's face or
His
a chest
face.
or?
I saw his face.
Did you notice anything about the person's voice when he said those things to you?
There was also an accent, an Irish accent.
What volume was the man speaking at?
I would say it was normal to a whisper.
Were you able to tell anything about his physical appearance?
No, I mean, not at that time. I could feel his weight, of course, but not at that time, no.
Could you tell if he had clothes on?
He did not, no.
When you woke up, was the man already penetrating you?
Yes.
Did you know if he had... did you know what else he might have done before you woke up?
No, and I don't know how long that was happening for.
What did you do once you woke up and realized this was happening?
It took me a minute, or not really an actual minute, but it took me a few seconds to really wake up and realize what was happening. I heard him say what he had said. I said, "What are you doing? Stop." I tried to push him off of me. I was not successful for maybe a few minutes. I then eventually was able to maneuver my way out of the bed. I fortunately was on the side of the bed, so I was able to get my feet on the ground and roll out of the bed.
What was the man doing during the time that you were trying to push him off of you and trying to get out from underneath him?
He was continuing to put his weight on me. He was continuing to penetrate me. He didn't stop.
Did he say anything after you said, "What are you doing? Stop"?
No, he said, that I like it, that he couldn't give it to me because he's a loser, which I had assumed was Liam he's referring to.
How did you try to push him off of you?
With my hands, at his, whatever I could reach at. And then I think when that was not successful, I knew I wasn't going to be able to push him off. That's when I started to squirm around to try to get out a different way.
What were you focusing on, or what stands out in your mind from that time?
I was focusing on getting out. I was focusing on getting to safety.
You said that you were eventually able to get out from under him. What did you do once you got away?
So because my clothes were on the other side of the room, I had to collect them. As I was collecting them, he continued to follow me around, trying to kiss me, had pushed me up against the wall. Fortunately, I was able to collect my belongings while continuing to move towards the door. I eventually was able to get into the bathroom, where I was able to get dressed. I knew that he was still at the door because he had jiggled the door. I took a moment to make a plan of escape to safety. And like is shown in the photos, when you're in the bathroom, if you turn to the left, the door is pretty close. So once I had my clothes on, I was able to exit the bathroom and exit the room.
How were you able to find where your clothes were in the room?
I remembered where I put them. I remembered vaguely where they were, but the bathroom light was still on. So while it wasn't, as bright as this courtroom, I could see around.
And was that also true when the man was on top of you and following you around the room?
Yes, correct. And at one point, we were right by the bathroom, where he had pushed me up against the mirror that was shown directly across from the bathroom, where the light was still on.
What were you focusing on at that point when the man was close to you in the room outside of the bed, when he was pushing you and following you around? Where were you looking?
I was looking to collect my belongings. I was looking to, like I said, plan my escape. I was looking to get away from him.
Could you still hear Liam at that point?
He was still snoring, yes.
You said that he pushed you up against that mirrored closet area. Where did he push you?
Against my chest as well. He did, I guess my breast and my chest. He did attempt to kiss my chest, as he, at one point as well, in that same vicinity of the room.
And what part of his body did he use to push you in your chest and breast area?
His hands, but I mean, his full body was against me at that time still. So I could still feel the weight of his chest, but his hands were the most obvious.
Difficult to listen to.
Very. Could be triggering for some of our viewers who are watching this and hearing this horrific situation she's describing.
Yeah, so out of a nightmare, out of a horror movie. Marlo Greer, you represent victims in sexual assault cases. What stands out to you listening to this alleged victim?
What really stands out to me is how many times has she had to tell this story. And after the last trial, she didn't give up. She's here, and she's retelling her story. I mean, and that's one thing, like, imagine putting yourself in her shoes, but imagine telling people about your last sexual experience in that amount of detail. It's not just, oh, okay, what happened? I woke to him on top of me. It's, this is where he was, this is where his hands were, this is where his body weight was. You know, what was he doing? I mean, how do you come out and say, what was he doing? And you could tell she really hitched, you know, she just said he wouldn't stop. And it's, the trauma of going through these stories is real, and it's not just the trauma of what happened at the time, it's going back through it again and again. And when clients come to my office to tell me this, we're what we call trauma informed. And so we let them tell their story as they are ready to. But here, I don't think you're ever ready for this.
Oh, absolutely not. You can hear, though, that she understands this process. She is someone who works in the legal field, and this clearly was important for her to take it this far. But how is a jury going to react to it? We will get you back in for more of this alleged victim on the stand, telling her story of what exactly she says happened inside of this hotel room. The defense, this man, he says it didn't happen like that at all, that he didn't even touch her. Welcome back to Court TV Live. I'm Julia Janae along with Ted Rollins. Thank you for being with us as we take you into this Massachusetts courtroom where a man from Ireland is on trial. He allegedly, according to prosecutors, raped a woman over the St. Patrick's Day holiday weekend last year.
Prosecutors say that Terence Crosby, a firefighter who was visiting from Ireland, raped a woman who had stayed the night in a hotel room that he was sharing with a friend. The 28-year-old alleged victim, who we're not naming, says she had consensual sex with Crosby's friend, a guy by the name of Liam O'Brien, but then woke up to Crosby on top of her and inside of her. His friend is not going to testify in this trial.
No.
We do know that.
Which is surprising because it seems like he would be a very important witness. Right now, we are listening to some very emotional testimony from the alleged victim. She's on the stand the second day so far in this trial, and she has just detailed how she woke up to find the defendant on top of her, telling her that he was better than her friend and she would like it and not letting her leave. Let's pick it up where we left off.
Had he put on any clothing at this point, or was he still nude?
He was still nude.
As that was happening, were you able to make anything out about his physical features?
No, to be honest, I didn't care. I wanted to get out of there. I knew that he was taller than Liam. I knew that he had hair. But more than that, I was not looking for anything else.
Were you able to tell anything about his race or his skin color?
He's white.
And you said that you were able to tell that he had hair. Were you able to tell if it was long hair, short hair, or something else?
I would say it was on the shorter side, but there was definitely hair as opposed to Liam, who was fully bald.
You said you were able to get into the bathroom. Did you lock the door?
I did, yes.
And you could hear some jiggling
Yes.
on the other side?
Yes.
Where was that coming from?
The doorknob was.
Was he saying anything while you were in the bathroom and he was on the other side of the door?
Not that I can make out, no.
In the bathroom, you said you got dressed and you were getting ready to leave. When you came out of the bathroom, where was the man?
He was right at the door.
Did he do or say anything to you at that point?
He continued to try to engage with me, but fortunately, the way that the room was set up, I was able to scoot past him, I would say. And like I said, I was not trying to listen to what he was saying.
I'm going to show the image from the hotel room photos ending in 1340. Does this photo depict the, how close the doorway to the bathroom is relative to the exit?
Yes.
And the mirror that's on the wall there, is that the area that you were talking about where he was pushing you?
Yes.
So after you left the bathroom, did you say anything either to Liam or to the man who was outside of the bathroom?
No, I didn't say anything to either of them.
After you left the hotel room, did you hear anyone or see anyone come out of the room after you?
No, but I wasn't looking back. I was just trying to get out of the hotel.
Do you have, and I know this can be difficult, but do you have any sense for how long you were in the room from the time that you woke up until the time you were able to get out?
I would say 10 to 15 minutes, roughly.
Were you looking at a watch at that time?
No, I wasn't, no.
Did you have anything with you at the hotel other than your clothes and that brown jacket that you talked about?
My phone.
Okay. But no purse or anything like that? Where did you go after you left the hotel room?
I walked into the hallway. and exited the hotel.
And what did you have on for clothes at that point?
The same thing I was wearing, but minus the sweatshirt. I had my pants, the shoes, and that brown jacket.
All right, I'm going to show you a photo. And you can tell me if you recognize it.
Yes.
What do you recognize that to show? Or who do you recognize that to show?
That's me exiting the hotel.
That's that this be marked as the next exhibit, Your Honor?
Any objection? No objection. The photo will be marked.
So that's exhibit 6. Thank you. May I publish this, Your Honor?
Yes.
All right. So we're looking at Exhibit 6. Do you know if you left the hotel using the same door that that you had used to enter?
I believe so.
What did you do as you were leaving the hotel?
As I was walking out of the, on my way exiting, I texted my friend and coworker, Daniel Jacobson.
You testified earlier that Daniel Jacobson was one of the coworkers who you had been with at the Black Rose. Is that right?
That's correct.
And so as you were leaving the hotel, why did you text Daniel Jacobson?
I wanted to explain to him that I'd just been raped and I needed to talk to somebody.
And so you sent him a text. Did you try to reach him any other way?
I called him a couple of times as well.
Was he the first person who you told about what happened?
Yes, he was.
Did you later provide a copy of that text message to the Boston police?
Yes, I did.
And did you also provide Daniel Jacobson's kind of contact page in your phone reflecting an outgoing call to him?
Yes, I did.
May I I'm sorry, Your Honor. I'm going to approach the witness and I'll ask if you recognize the documents that I'm showing you.
Yes, I recognize these.
And what do you recognize them to show? And for the record, there are 2 pieces of paper.
One is the text messages that I sent to him. The other is his contact showing my outgoing call.
I'd ask that these be marked together as the next exhibit.
Any objection to the 2 photographs? No. All right, those will be marked in sequence. And I'm going to give an instruction to be marked. Second.
Next message in Exhibit 7, the contact information of the exhibit.
So, jurors, I'm going to give you an instruction about this text message. The law permits this witness to testify, it allows to testify about statements she made to the witness, Peterson. It also allows him, if he were to call, to testify about the statements that he received from his. We call this first complaint evidence. You must first determine if the statements were made. Here we're talking about a statement that is made by text that's just been admitted as an exhibit. If you conclude that you made the statements, you may use the statements when you consider whether her trial testimony is truthful and reliable. You may not use the statements that she allegedly made to Mr. Jacobson as independent or direct evidence of facts alleged. Mr. Jacobson was not present for the alleged sexual assault, so he does not have direct evidence of the events. It's Ms. Kruger's testimony that you heard today that is the direct evidence of the alleged sexual assault. You must rely on her testimony in court for the details of the incident. In determining credibility, you may consider all the circumstances of this first complaint text. Those circumstances may include when the statements were made, to whom they were made, and does the substance of the first complaint text support or fail to support trial testimony.
Thank you, Your Honor. May I publish Exhibits 7 and 8? I'm starting with Exhibit 7. Looking at that, are you able to tell anything about the timing of when you sent those text messages to Daniel Jacobson?
Yes, it was at 2:18, I believe, a.m.
And can you read what you texted him?
I hate everyone. What the is wrong with people? I woke up and a guy was inside me telling me how much he knew I wanted it and how pathetic it was his friend couldn't give that.
Did Mr. Jacobson respond right away?
No, but it was 2:18 in the morning.
I'm showing you Exhibit 8. Is this the contact page for Mr. Jacobson in your phone?
Yes, it is.
And are you able to indicate where you see the outgoing call that you placed to him that morning?
Below it, so it says at 2:21 a.m. today.
Sorry, I'm trying to zoom in. Is it there kind of below where it says message, call, FaceTime?
Yes.
All right, that's huge information right there. When you have a victim who is outcrying, alleged victim in this case, but an outcry witness, someone that they immediately are saying, this happened to me. So that's huge for the prosecution to be able to get that in and for that to corroborate. It adds to credibility.
Absolutely. She's saying basically very tightly in that text exactly what she just said on the stand. Yeah. Let's get a break, but before we do, some new developments out of Florida where the family of Dan Markel is now speaking out after that bombshell sentencing hearing with Donna Adelson addressing the court. Both Donna and Harvey, of course, spoke at the sentencing hearing where they blamed everyone from the judge to the jury for Adelson's conviction in the murder for hire plot to kill FSU professor Dan Markel.
You know, the Markels didn't speak at that sentencing. They had already done a victim impact statement a month earlier, but now they are reacting to what they heard during that sentencing. Dan Markel's mother, Ruth, sent us this statement and says in part that during sentencing, our family listened in disbelief to the disrespectful and delusional statements made by both Donna and Harvey Adelson before Donna's sentencing for first-degree murder and other convictions of our son and brother Dan Markel.
Goes on to say, contrary to Donna's claims, she never mourned the loss of Danny's life, nor did she ever express concern for his sons losing their father. Testimony at her trial showed her callous indifference to his murder, including written evidence that she dismissed the very idea that the boys could be sad or even miss their dad. So Ruth Markel, and this is a portion of a full statement that we'll at some point have out on the Court TV website. She sent it to us, but clearly the Markels, as shocked as many of us listening to Donna and Harvey address the court during that sentencing. A reminder, Saturday night, Victim to Verdict wraps up this season, and the subject of it is Donna Adelson, 8 o'clock Eastern Time. Julia is all over it.
Don't miss it. New interviews, a lot of good information you worked on for bringing this out.
It's a great episode. We worked in some of the sentencing too, and if you wanted a full look at this case, we got it for you. 8 o'clock Eastern Time. Let's get a break right now. When we come back, we will head to Boston for more of the testimony of the accuser on the stand.
Tonight on Closing Arguments, Family Matters star Darius McCrary makes a bizarre court appearance facing felony charges. We'll dive deeper as our experts weigh in.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Donna Adelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
Is she telling the truth? That's the question that a jury in Massachusetts is going to have to grapple with, where a 28-year-old woman is accusing an Irish firefighter of raping her last year.
The alleged victim, who we are not showing or naming, says that she woke up to this man, Terrence Crosby, having sex with her in a hotel room. Crosby was sharing that room with his friend.
She's been detailing this on the stand for the second day, and she just spoke about who she contacted right after this happened. Right after she got out of this hotel room, she texted her co-worker to say what had happened. Let's pick up her testimony where we left off.
So after you sent that text message to Daniel Jacobson, and after you called him, and first, I'm sorry, you may have said this, but did he answer when you called?
No, he did not.
So after you tried to contact him and walked out of the hotel, where did you go?
I walked back to my house in the North End at that time.
Why did you go home?
Because I needed to get to the hospital. And I wanted to get to safety.
So what did you do at your house then before going to a hospital?
I changed into different clothes, and I called an Uber, and the Uber took me to Mass General.
What did you do with the clothes that you had been wearing inside the hotel?
I put them in a bag, and I brought them with me.
Why did you bring them with you?
Because I'd just been raped, and I didn't know if they would need them.
What hospital did you go to?
Mass General.
Where did you go within the hospital when you got there?
I went to the ER.
When you went to the hospital, do you recall meeting with a series of nurses and doctors while you were in the emergency department?
Yes, several.
And did you also consent to something called an evidence collection kit?
I did.
Was there a primary nurse and a primary doctor who you spent most of your time interacting with in the hospital?
Yes, but there was a lot of other people coming in and out at the time.
Do you recall if the nurse and the doctor asked you questions?
Yes, absolutely.
And did they do a physical exam?
Yes, they did.
Do you know if they put anything inside of your body as part of the physical examination?
Yes, they had swabbed various areas of my body for, I would suppose, DNA collection now.
Do you recall the nurse asking if you had any consensual partners within the past 5 days or 120 hours?
Yes.
Prior to having consensual sex with Liam at the Omni Parker house, did you have any other sexual partners in the 5 days leading up to that?
No, I did not.
While you were at the hospital, did you also consent to having your blood drawn?
I did.
And as part of that process, did the nurse ask you about any medications that you were prescribed?
Yes.
And were you prescribed any medications at that time?
Yes, I was.
What medications?
Vyvanse and I think it's Ludrazone.
Okay. And anything else?
I think I had another one that I just don't recall the name of.
Were you on any type of oral contraceptive or anything at that time?
Yes, I had birth control.
What is Vyvanse?
It's an ADHD medication.
And what does Vyvanse help with for you?
My ADHD.
Back in March of 2024, were you taking it, or did you just have a prescription for it?
I was taking it.
How long had you been taking Vyvanse?
Quite a while, at least a year, if not more.
And on this particular day, were you taking it as prescribed?
Yes, I took it that morning, which is how I always take that medication.
And the other medication that you mentioned, you said it started with an L, but I didn't quite catch what it was. What time of day did you typically take that medication?
I take that one in the evening, or before bed.
And do you know what that medication is prescribed for?
It helps with anxiety and or depression, but it makes a person drowsy, which is why I take it at night. So I didn't go home that night, so I didn't take that medication that night.
Okay. But were you normally taking it outside of not taking it that night?
Yes.
Do you know how long you had been taking it for?
Months.
Had you ever drank alcohol before, after taking those medications?
Yes.
And did you notice any side effects of that?
No.
Did you notice anything different that night from when you had drank alcohol in the past, when you weren't taking those medications?
No, it felt the same as any other outing.
And you mentioned that you had skipped taking the second medication, the one that you normally took in the evening, because you didn't go home. Had you ever skipped that medication before?
Yes, I have.
While you were at the emergency department that day, did you also meet with detectives from the Boston Police?
Yes.
Was that toward the beginning or toward the end of your time at the hospital?
Maybe halfway.
How long were you at the hospital for? Do you know? Let me ask it a different way. When you left the hospital, do you know, was it still night? Was it still during the overnight period, or was it later on?
I think it was around 11.
So we're talking about Friday morning at this point, right? When you met with the detectives, is it fair to say you had already been at the hospital for some hours?
Yes.
Where did you meet with them?
In the ER, in the room that I'd been placed in.
Was it one detective or more than one?
There were several. I think a police officer first came, and then detectives came.
Did they ask you questions about what happened?
Yes.
And did you answer their questions?
I answered all questions that were asked.
Do you remember them taking those photos of your phone that we just saw as Exhibits 7 and 8, the text message and the contact sheet for Daniel Jacobson?
Yes.
When your conversation with detectives ended, did you understand that you would be speaking with them again?
Yes, I did.
After you left the emergency department, and sorry, I should have asked, did you complete the evidence collection kit and stay until you were discharged from the emergency department?
Yes, I did. I completed all of that. They prescribed me various medications for potential sexually transmitted infections, and then they sent me right to infectious disease after being discharged from the ER to speak with, I think, a nurse practitioner there. Where within
the hospital was infectious disease? Was it within the emergency department still or somewhere outside?
No, it was, the MGH, everything's connected, but no, I did leave the ER and had gone upstairs to the infectious disease department.
Did you leave the hospital with any medication?
Yes, I had to take medication, HIV preventative medication.
How were you feeling when you left the hospital that morning?
Exhausted, sad, but just ready to get home.
And did you go home after you left the hospital?
Yes, I did. I called an Uber, and I went back to my apartment.
Did you go to work that day?
I did not. I emailed my bosses and explained that I needed to take the day off.
Do you recall meeting with detectives again the following day?
Yes.
The Saturday?
Yes, I do.
Did they show you a photo?
They did.
And did you recognize who was in the photo?
I did.
Do you remember writing any notes on the photo that they showed you?
I signed my signature, and I believe I dated it as well.
And why did you sign it and date it?
They had asked me to do that to identify Liam.
Okay, I'm going to show you a photo. Do you recognize who's in that photo?
Yes, that is Liam.
And do you recognize the writing that you see on the or next to the photo?
Yes, and I, in addition to signing it, I also put my initials and the time of day and the date.
I move to introduce this as the next exhibit, Your Honor.
Any objection? No objection. That will be marked.
So mark exhibit 10.
Thank you. May I publish exhibit 10, Your Honor? All right, so Ms. Kramer, you said the person in this photograph is Liam?
Yes, that's correct.
Do you recall having additional meetings with detectives and members of the district attorney's office in the time between when that happened and leading up to trial?
Yes, there were various meetings.
And have there been a number of different meetings where different people were asking you different questions about these events?
Yes, absolutely.
We have one moment, Your Honor. Nothing further. Thank you.
All right, let's bring in Philip DeBay. Philip, what is your take on this case?
Wow, just my head is spinning, frankly. There's a lot of things going on, but one of the most tragic things that I see, that we don't really see this so much in Europe, is the pretrial detention. You have a man here held on $50,000 bail. And I got to tell you, Ted and Julia, after years of being in the justice system, a $50,000 bail is chump change. And I think it's tragic that nobody in his orbit was able to post that so that he could stand trial from out of custody. It's so much easier to prepare. Now, having said that, he is definitely accustomed to the Irish way of meting out justice. And in the United States, we have the scheduled bail system where the dollar amount is set based on the crime itself, whereas in Ireland, the judges set the bail based on a balancing of factors like the record, the seriousness of the charge, whether or not they're a flight risk, and all of that stuff. So the fact that he had such a low bail here tells me that he is of very modest means in Ireland, that he was unable to post it. Now, from a body of evidence standpoint, she is coming off quite credibly. She is traumatized by this event. But the problem that I think the Commonwealth of Massachusetts is going to have is that the forensics do not necessarily align with the testimony. And I think the reason why is that as the DNA starts coming in, they're not going to have a match of him. She had no injury. Nothing that I'm aware of, no redness, no marks, no bruises. And in fact, even the penetration that purportedly occurred with her and Mr. O'Brien didn't really show any type of trauma or injury. So it's going to be a tough case.
Philip DeBay, we can always count on you to have the defense view of this, and this is one of those cases where it is going to come down to the credibility of this victim and what the evidence shows. We also understand from our producer that's there in the courtroom that the defendant's wife is there inside of the courtroom. Yesterday she was not, but it sounds like she is there today supporting him.
Could affect the jury. Let's get a break. When we come back, the cross-examination. How do you handle an alleged victim of this type of assault? We'll find out next. All right, I head back to Massachusetts now, where we have been watching the testimony in the Irish firefighter rape trial of the accuser, the woman that claims that she was raped by this man, Terrence Crosby, a 38-year-old Irishman who is on trial now for the second time. This is a retrial.
Yeah, because the first jury could not reach a decision. It has to be unanimous for these 12 jurors. And we know, according to prosecutors, that Crosby was visiting Boston with fellow firefighters at the time. He was there to be in a St. Patrick's Day parade, sharing a hotel room with a friend. The alleged victim on the stand says, yes, she did have consensual sex with the friend, but then after the friend went to sleep, and so did she says she woke up to the defendant inside of her. She is now under cross-examination by the attorney representing this firefighter. Let's pick it up where we left off.
Cross-examination, please.
Morning.
Morning.
Now, you've spoken about what you say happened in that hotel room last year on March 14th, going to March 15th several times now, including today, right?
Correct.
And you texted Daniel Jacobson as you were walking out of the Omni Parker shortly after 2 a.m. on March 15th, right?
Yes, that's correct.
You gave a statement to Nurse Carly Littlejohn at MGH in the emergency department in the morning of March 15th, right?
Yes.
You spoke with a nurse practitioner, Richard Ahern, at MGH that same morning after you were discharged from the ER, right?
Yes, I spoke with several people.
While you were in the emergency department, you spoke with Boston police officer Roxana Kozub, right?
Yes, I don't recall her name, but yes, I spoke with several people that day.
And then with Boston Police Detective Joseph McDonough and Sergeant Dana Barrett, right?
Yes.
That was a recorded interview, right?
I believe I was informed it was recorded, yes.
And you spoke with Detective McDonough again the following day, March 16th, right?
Yes.
And that was for another recorded interview at the police station, correct?
Yes, where I identified Liam.
And you emailed Detective McDonough some additional details on April 8th of 2024, right?
Yes.
Gave a further statement to ADA Murphy and Detective McDonough on May 27th of this year, right?
To be honest, I don't recall that it was the 27th. As I said, I've met with several people at several dates.
Okay. And then another statement to ADA Murphy and ADA Mendez just this week on October 15th, right?
Yes, I spoke with them on October 15th.
Fair to say, between all of that, you've been in contact with the DA's office throughout this case, right? You also spoke with victim witness advocates Nicole Costa and Kara Hayes during the pendency of this case, right?
Yes, I have.
The victim witness advocates and the ADAs have kept you apprised of what was going on, right?
In what way?
Just the progress of the case, what's going on with the investigation, upcoming dates, things of that nature.
Yes, they provided me with dates as to when I would be needed and such.
And they helped you get ready for trial, right?
We had meetings, yes.
Got you ready for your testimony today, right?
We spoke about testifying, yes.
Okay. And you discussed your testimony?
Yes.
And did you watch videos?
Yes, the videos that were shown.
And you saw and talked about things that you might not have otherwise seen or remembered from that night, right?
I don't agree with that.
Well, did you discuss what I might ask you today?
So why don't you be more specific?
Sure, certainly. In preparing for your testimony and meeting with the ADAs, did you discuss what prospective questions I might ask you?
Are you talking about recently?
Yes, Your Honor.
Okay, because you went through a number of...
My apologies, Your Honor.
...reports in a year and a half.
They had spoken to me about what cross might look like, yes.
I'd like to take some time to go through your prior statements, okay?
Okay.
So starting back with Daniel Jacobson, you texted him right after you alleged you were assaulted by my client, right?
Yes, with the text message.
And you texted him words to the effect that you woke up and a guy was inside of you, talking about how pathetic it was his friend couldn't give that, right?
Yes, that was shown on the text message.
And you didn't give any further details, did you?
No, because it was a text message that I was trying to get, and I called him as well.
Tried calling him once?
I believe it was one that, but only showed once. So
So you did testify when ADA Murphy was questioning you that it was more than once, right?
Yes, because I thought that it was, but as we saw in that, it only showed once.
Right. So it was just once, right?
Yes.
Okay. And he didn't pick up, right?
No, he did not. At that time.
Fair to say you were still intoxicated at that point?
No.
Is your testimony today that at 2 in the morning on March 14th, you were not intoxicated?
Sorry, let me clarify. I guess what do you mean by intoxicated? I had been drinking, but I didn't, as I said, I wasn't stumbling. I walked back to my apartment.
Well, let's take it slowly then. And I apologize, I believe I said the 14th, I mean the morning of March 15th. Your testimony is that you were not under the effects of alcohol.
No, that's not what I said.
I'm asking that question.
No, I had been drinking, so yes.
So is it your testimony that you were sober at that point?
I was coherent.
I'm not asking if you were coherent, I'm asking if you believe you were sober.
I don't believe I was 100% sober.
Okay. And you don't believe you were intoxicated?
No, that's not what I meant.
I'm asking, you don't believe you were intoxicated?
No, I know I was under the influence of alcohol.
All right, we're of course not showing the accuser here to protect her identity, but our teams that are there inside of the courtroom are letting us know that she is getting very emotional and crying during this testimony where she's being cross-examined about whether or not she was intoxicated and whether she was sober. This is difficult for her.
Yeah, I mean, a good answer there would have been, you know what sobers you up real fast is getting raped in a hotel room. But she's obviously having trouble with the cross. It's going to break. More after this.
Tonight on Closing Arguments, Family Matters star Darius McCrary makes a bizarre court appearance facing felony charges. We'll dive deeper as our experts weigh in.
Closing Arguments, tonight at 8/7 Central, only on Court TV. Next week.
Covering the country's biggest trials before we bring you inside the courtroom. Plus, the most compelling true crime cases in our daily spotlight.
Opening statements with Julie Grant. Mornings at 8/7 Central on Court TV.
Let's head back to Massachusetts. The accuser on the stand, cross-examination.
When you were brought into the emergency department, you met with Nurse Carly Littlejohn, right?
Yes,
And she performed an evidence collection kit and examined you, right?
she did.
And that exam was at approximately 6 a.m., right?
I had been there for quite some time. I'm sorry, I don't actually know what exactly the time was of the kit itself.
Okay. As part of that exam, you gave her a history of the alleged incident, right?
I did, yes.
And you indicated penetration of your vagina by penis, right?
Yes.
You also said you were unsure of whether there was any penetration of your mouth, right?
With the defendant, yes.
Well, I'm just asking what you told Carly Littlejohn. Do you remember her filling out a form as part of the evidence collection kit?
Yes, I do.
Okay. And so my question is, in response to being asked to fill out that form, the question she was asking from that form, is it true that you said you were unsure of whether there was any penetration of your mouth?
At this time, I can't say for sure.
Okay. Is it accurate that you told Nurse Littlejohn that your alleged assailant did not use a condom?
I believe so, but as I said, that was all.
Is it also true that you told her you were unsure if there was ejaculation vaginally, orally, or externally?
At this moment, I cannot say 100% sure. I told her what happened.
And so you gave her a brief statement as to what happened, right?
Yes, I did.
Isn't it true that you told Nurse Littlejohn that you had a date and went back to his hotel?
Yes.
But it wasn't a date, was it?
Well, we had hung out for quite a bit at that time. I guess it depends what you define as a date, but...
Well, there was no pre-planning of it, right?
No, but
And you weren't in a dating relationship, right?
No, but you don't have to be in a dating relationship to go on a date.
You also told her that an unknown male was inside of you saying he couldn't show you a good time, right?
He couldn't give it to me, I believe is what I had said.
Okay. Different from what you told Daniel Jacobson, though, right, in that text message?
Paraphrasing, they are the same.
And you also told Nurse Littlejohn that you pushed him off and attempted to get your clothes, right?
Yes.
That he followed you around, pushing you up against walls, attempting to, quote, keep hooking up, right?
Yes.
You told him to get away, dressed, and walked home, right?
Yes.
At that time, and in that statement to Nurse Littlejohn, there was nothing about lights being on or off in the room, right?
I don't believe it was asked.
There's nothing about going into the bathroom, right?
Again, I don't believe it was asked. I just was answering the questions that she was asking me.
She asked you if he followed you around the room?
She asked what happened after that. She wasn't asking the lighting situation.
So you gave certain information that you thought was important, right?
At that time, yes.
Okay. But nothing to Nurse Littlejohn describing what he looked like, right?
No, but I didn't think that mattered at that time.
Nothing about what he was wearing, right?
No.
Okay. Nothing about identifying marks, birthmarks, tattoos, scars, piercings, right?
No.
Nothing differentiating him from the man you came to know as Liam O'Brien, right?
I wasn't asked to describe him.
And toxicology testing was also part of the exam, right?
Yes, it was, that I consented to.
And as part of that, you gave some medical history, right?
Yes.
And I believe ADA Murphy asked you about the prescriptions you were taking, right?
Yes.
And you told Nurse Littlejohn and you testified to this jury that you were taking Vyvanse for ADHD, correct?
Correct.
And you've told us and Nurse Littlejohn that you were taking Latuda, right?
Yes, I believe that's one of the names of it, yes.
Okay. And today you told the jury that that was for anxiety or depression, right?
Yes.
But in a prior proceeding, you told us that, or excuse me, told, Your Honor, can we approach? Just
yes.
Circle back and repeat the question. You told this jury today that you were taking Latuda for depression or anxiety, correct?
Yes.
And in a prior proceeding, didn't you testify that you were taking it for sleeping?
I said I believe it was for sleeping. However, anxiety and sleeping kind of go simultaneously. So,
when those prescriptions were prescribed, did your prescribing doctor give you any warnings about consuming alcohol while taking those prescriptions?
yes.
And were you warned about any side effects or drug interactions that might occur?
Yes.
And were you warned that they could increase the effects of alcohol if you took them while you were drinking?
Yes.
In addition to the prescriptions you were taking for ADHD and anxiety, did you previously receive any treatment for those issues?
Yes.
As part of that previous treatment, did you and was it a therapist?
Objection. Sustained.
As part of that previous treatment, did you ever address how ADHD or anxiety impacts you?
Objection. Sustained. So, jurors, that's an example of an objection that's sustained. There's no answer, so the question itself is not evidence.
After your discharge from the emergency room, you were seen by nurse practitioner Ahern, also at MGH, right?
Yes.
And he gave a history to him too, right?
Yes.
Did you review your medical records?
We have to hit a break. More from the alleged victim on the stand after this. You're watching Court TV. Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us this afternoon. We are beginning this hour in Massachusetts. It's day 2 of testimony in a case against a firefighter from Ireland who's being accused of rape, Terrence Crosby. He was 38 years old when he was visiting Boston with fellow firefighters to walk in the St. Patrick's Day parade last year. Prosecutors say that while he was staying at a hotel, he raped a woman there. And the alleged victim, who we've been hearing from on the stand, she has decided to remain nameless in this, and she testified at Crosby's first trial that ended in a mistrial, and she's testifying today that yes, she did have consensual sex with another firefighter, a friend of the defendant's named Liam, but she said he was also rooming with Crosby, something she didn't know, and when she fell asleep, she woke up to Crosby raping her. The defense says that he is not guilty and that he didn't touch the victim in this case. Let's get you back into the courtroom now. We're picking it up with the accuser's testimony, and she's under cross-examination by the defense.
Would you agree that you told nurse practitioner Hearn that you remember having a drink, then waking up with a man sexually assaulting you?
Yes, because that's what happened.
And directing your attention actually back to when you first arrived in the emergency room and the police were called. You met with Boston police officer Roxana Kozub, right? And that was at or about 7:55 in the morning?
As I don't know the exact time. It was a lot of meeting people, I don't know the exact time.
You gave her a description of events from the night, right?
Yes, I answered the questions that she had asked.
Still not sober, right?
I am unsure.
Your Honor, can we approach?
Not at this time.
Do you know what legally intoxication is?
Objection. Sustained.
As part of your treatment at MGH, you consented to a blood draw, correct?
I did, yes.
You're aware that your blood draw indicated a .135 blood alcohol concentration, correct?
I came to learn that, yes.
And fair to say you'd agree that it would take several hours for all the alcohol to leave your system if you had a .135 blood alcohol concentration?
Overruled, if you're able to answer that.
I'm sorry, could you repeat the question?
Would you agree that it would take several hours for all the alcohol to leave your system if you had a .135 blood alcohol concentration?
I don't know exactly how many hours, but I would assume it would take some, yes.
So is it fair to say that if you had a .135 blood alcohol concentration, you were still intoxicated?
Objection. Overruled. You may answer that if you can.
I don't know what you mean by intoxication. I mean, the blood alcohol levels is what it is. I understand that, but that doesn't mean I consented to everything, or I did consent to everything that they told me. I was able to consent to treatment. I wasn't falling. I just don't know what you mean by intoxication.
Well, you weren't sober, right? You had a .135 blood alcohol, right?
Right, that's absolutely correct.
Okay. So turning back to your interaction with Officer Kozub, you told her that you were assaulted and pushed the male off you while the other male was sleeping next to you, right?
Yes, as I've stated a couple times, yes.
Okay. And you told Officer Kozub that the person who assaulted you wasn't in the room earlier, right?
Yes.
You told Officer Kozub you managed to run out of the hotel room, right?
Yes.
You didn't actually run, though, right?
Running out of the hotel room was a figure of speech.
Okay, you walked out of the hotel room and down the hall, right?
Yes, I got out of there as fast as I could.
Okay, you walked through the lobby and out of the hotel, right?
Yes, trying to get out of that situation where I'd just been raped.
Okay, you didn't stop and say anything to the concierge?
No, I didn't know them.
Didn't stop and call the police?
No, because I wanted to get to the hospital.
You walked home, though, right?
I did.
Okay. And so, again, having just gone through the fact that you had a .135 blood alcohol at the hospital hours later, is it fair to say you were still feeling the effects of the alcohol at that point in the evening when you left the hotel?
The effects of that I was not sober, yes, but I was able to, as I said, I was able to do all of those things by myself.
Okay. Turning back to after you met with Officer Kozub in the ER, Detective Joe McDonough and Officer Dana Baird arrived in the emergency department sometime after 9 a.m., right?
And I'm sorry, I don't know the exact times, but
Do you have a general frame of reference of how long they arrived after you met with Officer Kozub?
I know that I left the hospital around 11:30.
Okay, so is it fair to say it was hours, not minutes?
Yes, absolutely.
Okay. And they conducted an audio recorded interview with you, correct?
Yes.
And you discussed the evening beginning with arriving at the Black Rose, right?
Yes.
And you told them you had a few drinks, right?
Yes.
You didn't tell them the specifics with regard to that, though, right?
I wasn't asked specifics. I was just giving them the narrative.
Okay. And you didn't get into anything else that had happened earlier in the day, correct?
No.
Okay. You were asked about the timing of supper, though, right?
If you remember.
I don't remember at this time if that was specifically asked.
All right. Is it fair to say you didn't tell the detective what you had had to eat?
I don't know at this time, but if it wasn't asked of me, I don't think I would have shared with them.
Now, if you recall, yesterday you were shown some videos at the Black Rose, right?
Yes.
And you told the jury that you ordered food there, right?
I did.
I believe you said it was a lettuce-wrapped burger and fries, right?
Correct.
Okay. And in looking at the video, the plate's on the table throughout the night, right?
Yes, I was grazing, I would say.
Okay. So you agree then that you didn't eat all of what you ordered, right?
In one sitting, correct.
Well, you were only there for one sitting, right?
Meaning, well, no. In grazing, I mean, it was on the table. So as I was moving around, I went back to. So I wasn't sitting down at one specific point and finishing it. I would go back.
Sure. But, so even with you walking around the bar, nobody came and took your plate away. It wasn't cleared, right? It's there in the video, right?
Right. Yeah, because I wasn't finished with it.
And fair to say, up to that point, when you ordered at the Black Rose, you had just had hors d'oeuvres and appetizers throughout the day, right?
Lots of them, but yes.
And that was to go along with at least 5 or 6 drinks before you got to the Black Rose, right?
Yes, between 5 hours, 6 hours.
Did you have anything to drink between Big Night Live and State Street Provisions?
No, I did not.
Okay. Now again, turning back to your interview with Detective McDonough and Officer Barrett in the ER, you told them you went back to the Omni Parker with Mr. O'Brien, right?
Correct.
Well, or at least you told them you went back with your consensual partner, right?
Yes.
Because you couldn't remember his name at that point, right?
Yes. I mean, I'm assuming he had told me his name, but I don't always pick up on everyone's names when they introduce me. It's so difficult.
Well, you testified about dancing and drinking and talking with him all night, but you didn't remember his name, right?
It's kind of embarrassing when you don't remember the person's name the first time to ask them again.
Well, you spent several hours with him and then went back to his hotel with him. You didn't pick up on his name or feel that was appropriate to ask him again?
What do you mean by appropriate?
Well, you said it's embarrassing, but you had a night-long, let's call it engagement with him, and you didn't know his name for the entirety of that night. Is that right?
Objection. Or you may answer that.
I think sometimes when somebody introduces themselves to me, I forget to listen to their name, and so it is embarrassing to acknowledge that. So when someone's already told me their name, yes, it is embarrassing to ask them their name again, but it didn't. The conversation was still enjoyable. We still had a good time.
Is it fair to say you didn't know or recall his name until the police told you what it was?
Yes, I think that's fair to say.
Okay. Do you recall if he ever told you his last name?
I don't recall when.
Do you recall if he did at all?
I don't know. Between all of them, I'm not sure.
Cross-examination seems like it is difficult for the alleged victim on the stand. Our team that's there in the courtroom has said that she's been emotional when she's describing what happened to her. She's been crying and wiping away tears, and that the jurors are very attentive during this, but they are split in terms of note-taking. Some are taking notes, some are not. The defendant's wife, with her fingers laced, is sitting there inside of the courtroom in the gallery. Let's get to our break. When we come back, we're going to hear more of this cross-examination where the defense attorney is going to ask her about the text message that she sent to a friend right after what she says happened in that hotel room.
Tonight on Closing Arguments, Family Matters star Darius McCrary makes a bizarre court appearance facing felony charges. We'll dive deeper as our experts weigh in.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Donna Edelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
Welcome back to Court TV Live. We are watching together day 2 in Boston, the Irish firefighter rape trial for Terrence Crosby. He's a firefighter from Dublin who is charged with raping a woman in Boston in a hotel. This happened in March of last year. There have been 2 trials in this case. Prosecutors say that the accuser had consensual sex with Crosby's hotel roommate, a friend of his, and that the friend fell asleep in a separate bed from the accuser. The accuser says she woke up, though, to Crosby raping her, and that's the story that she has told on the stand. We're listening to her now be challenged on cross-examination. The defense attorney for Terrence Crosby has been asking her about whether or not she was still intoxicated once she woke up, and her blood alcohol level was over a 0.1. Let's pick it up where we left off with more of her testimony.
If he had in fact done so, do you even know if he had would have known if he had given you a true name?
No, I wouldn't have known the same if it was lying to me.
Do you recall if he told you if he was married or single?
He did not specify. But I assumed that if he was talking to me and we were having consensual sex, that he would be single.
But you didn't know. You assumed? Is that right?
Yes, because if somebody's approaching me,
so
I think they would be single. But I don't ask specifically, are you single?
Okay. Do you recall if he told you how long he was going to be in town?
I knew that he was there for the parade, and so a few days, but I don't recall the exact date of when he was leaving.
Okay. Do you recall if you had a conversation about using protection or safe sex?
No, we did not.
Okay. None of these details came up in that first interview, though, right? In the emergency department?
Which interview?
The first interview with the police in the emergency department.
Do you understand the question?
Liam wasn't my rapist, so why would we be talking about those things?
I still need you to answer the question. You can't answer a question with a question, unfortunately.
I'm objecting to the initial question.
Why don't you ask another question with an objection? I'll rule on it. But don't instruct the witness.
My apologies, Your Honor. Thank you, Your Honor.
Jurors, please disregard that statement directed at the witness. Okay, go ahead.
Thank you. Okay, so moving on. You told the officers that you had consensual sex with a man whose name you couldn't remember, right?
Yes, that's correct.
And you didn't say anything about Mr. Crosby or anyone else being in the room when you arrived, did you?
He was not in the room.
Or that he immediately left upon your arrival, correct?
He was not in the room.
You didn't recognize Mr. Crosby as one of the people that you had met at the Black Rose, right?
I had met a lot of people, and I wasn't paying attention to him.
Well, in viewing the video yesterday, you saw that Mr. O'Brien introduced him to you, correct?
Yes,
and he was one of maybe 3 or 4 people wearing Dublin Fire Brigade clothing, correct?
Yes, but he was irrelevant to me at that time.
So it didn't stick out in your mind at all that this person that you're spending the evening with introduced you to one of his colleagues who was similarly dressed?
I knew that they were similarly dressed,
okay,
but I was not interested in him.
So you didn't remember meeting him at all, right?
I met many people. I don't remember specifically meeting him.
Okay. And yesterday you saw the video where you in fact hugged Mr. Crosby, correct?
Yes, I hugged several people.
And you don't recall hugging him at the Black Rose?
I recall hugging many people. I don't recall specifically hugging him.
And that hug that you gave to Mr. Crosby on the video, even if you don't recall it, you saw it, correct?
Yes.
You're aware that he was leaving and that's why he came over to say goodbye to Mr. O'Brien and yourself, is that right?
I don't know that I remember his intent, or knew that his intentions were to leave.
You didn't see him at the Black Rose any longer that evening, correct?
I wasn't looking out for him.
Okay. All right, and so it's your testimony that you don't remember him being in the room that he was sharing with Liam O'Brien at the Omni Parker house when you arrived?
I didn't know that they were sharing a room, and there was nobody else in the room when we got in there.
Okay. And that's what you told all three officers up to that point during those meetings with the officers at MGH, right? That there was no one in the room, right?
I believe so.
Okay. And you told the detective you were assaulted after you fell asleep, correct?
Yes.
And that you woke up to someone inside of you, right?
Yes.
Did you know where you were when you woke up?
Yes.
Okay. Now, you told the detective the person assaulting you was making reference to his friend being asleep, right?
Yes.
And you told the detective he was pushing you around the room trying to kiss you, right?
Yes.
And you would agree it's not a very big room, right?
There's enough room to be pushed around.
It's just a single room, correct? There's not a living room attached to it. It's not a suite, right?
Correct.
Okay. And so it's your testimony that the commotion of pushing you around the room trying to kiss you didn't wake up Mr. O'Brien, right?
He was snoring quite loudly. I don't know that anything would have woken him up.
Okay. And again, in this recorded interview with Detective McDonough and Officer Barrett, you didn't say anything about the lights being on in the room at that time, though, right?
It wasn't asked.
Okay. And you didn't tell them anything about being in the other bed, right?
I don't know in that specific interview if I told him that. No, I don't know.
Okay. You didn't tell them anything about yourself being nude?
Again, I don't know if it was asked, but I can't specifically say at this time when I shared what with them, because I had several.
That's okay. There's nothing that you testify, or I apologize, nothing that you told them at that time about being under the blankets or the covers, right?
At that specific time, I don't know. I don't know when I shared that.
Okay.
And as I said, I answered every question that I was asked.
And in this first recorded interview, you told the detective you had 2 drinks at the Black Rose, correct?
I don't know, but it was roughly 2 drinks.
Okay. And you've testified that it was two hard seltzers and a shot, right?
Yes.
Okay. I believe you also testified yesterday that you had 2 hard seltzers at the table, you had a server, but you were also going to the bar, correct?
Yes, that's where the shot was.
Okay.
And water.
Okay. So, if that recorded interview does in fact say that you had 2 drinks, then your testimony here doesn't quite match that, right?
Sustained. Next question.
Is it fair to say you had lost track of how many drinks you had that day?
No.
Is it fair to say you might have misremembered how many drinks you had that day?
Are you talking about whether she's misremembered as she's testified? I don't understand the question. Ask me another question.
Did you, in a previous proceeding, testify when asked if you had lost track of how many drinks you've had, say by 1 or 2?
I was giving rough estimates.
But it's true that that's how you testified previously, correct?
I don't recall specifically saying that. But what I mean is, it's, by 1 or 2, I was giving rough estimates.
Let's see if I can clarify. I asked you if you had lost track of how many drinks you had, and you said no.
Are you going to ask a question about a prior proceeding?
Yes, Your Honor.
Well, why don't you show it to her?
Thank you, Your Honor.
While they work on that, let's bring in criminal defense attorney Colleen Kelly. Colleen, thanks so much for being with us. The notes that we're getting from inside of this courtroom is that while the alleged victim is testifying at this point, her face is flushed. She's wiping away tears with a tissue. She's a pretty sympathetic witness, I would think. But what do you think about how the defense attorney is handling this witness, his tone and the way he is asking the questions?
Well, he's doing his job, and he's doing his job in that he always is going to have to question a witness's memory and their credibility. So, to that effect, he's challenging statements that she's making in court and how they differ from things that she said before, things that she left out, but she is coming across as very credible. And I also think that he might be stepping over a line that perhaps I wouldn't cross. He's almost trying to shame her. He's pointing out that she went home with this other man or to the hotel and that she was having sex with him and didn't even know his name. And I think, frankly, that's crossing a line that might make the jury not really appreciate it, especially if we have any female jurors on there, and particularly younger female jurors.
We do have several female jurors in this panel. The notes that we're getting is that there are some who are taking notes, some that are not. One seemed to be a bit, according to our producer that's in there, from their vantage point, annoyed with the way the defense is doing the questioning, tightening their jaw, taking notes, but continuing to listen to all of this testimony. And I'm glad you mentioned victim shaming or victim blaming. There is a line when it comes to these cases. What other things do you think the defense has to be careful of getting in the bounds of? He's already spent a lot of time talking about intoxication and her blood alcohol level at the time that she made it to the hospital.
I can see the jury getting annoyed with his questioning. I myself am getting a bit annoyed. You know, he's asking a lot about her intoxication level, and I think she's really giving good answers. She clearly is not going to admit that she was so intoxicated that she cannot remember. And I think her answers are appropriate in that, you know, what do you mean by sober? I wasn't perfectly sober. What do you mean by intoxicated? I was aware of my surroundings. So every time he's asking these questions, and he's asking similar questions, and she's giving an appropriate answer, I think he really is pushing it further into the area of annoying the jury. I think everyone on the jury, or you know, most people on a jury understand how alcohol affects our behavior, how it affects our judgment, how it affects our memory, and they have an idea of how many drinks she did have. So I think he's just belaboring the point.
Yeah, this cross-examination is going to continue. Colleen, stand by. What's coming next is the defense attorney is going to ask this witness whether she lost track of how many drinks she had. Plus, Matt Johnson is going to join us live with a preview of our next live trial here for defendant Dustin Duran, and it starts on Monday. We'll get you prepared for that. Stay with us. Welcome back to Court TV Live. We will get you back inside of the courtroom for that case against Terrence Crosby in just a moment, but we do want to get you an update on our newest live trial. It's set to begin next week, called the Amber Alert murder trial. The defendant here is Dustin Duran. He's accused in the 2024 shooting death of his girlfriend, Caitlin, and then he's accused of also running off with their 2 children, and that's what triggered the Amber Alert. Let's bring in Court TV crime and justice correspondent Matt Johnson, who is here in studio with us to tell us about this case. When we have Amber Alerts, Matt, we always hope that someone is found when they come up on our phone, that there's information that helps lead to children being recovered. But tell us about this case.
Yeah, absolutely making headlines. And it was very chilling for people in New Hampshire and also just the Boston area. This is a tragic case about a mother being executed in an apartment building, followed by a dramatic manhunt for her accused killer. Prosecutors say 38-year-old Dustin Duran shot and killed his girlfriend, Caitlin Nafziger, at their apartment in New Hampshire on February 29, 2024. The next morning, police issued this Amber Alert for Duran and his 2 young daughters that he shared with the victim. They were just 1 and 4 at the time. He was later arrested after everyday citizens paid attention. They spotted his car and called police. Local station WMUR interviewed them. Listen to this.
We just turned around and I told her to call 911.
I told the 911 operator, I said, I think he sees us. And it was a little scary at that time. You know, we did it as mothers, you know, as a parent and a grandmother and stuff. You know, that's what Amber Alerts are for, you know, to help. And we did it for the children.
Now, his defense is going to claim that he shot Caitlin in self-defense to protect those kids because he says that he thought that she was about to kidnap them. So it's a bizarre case, and that's what we can expect in those opening statements.
And I wonder what we're going to hear from the defense to try and back up this claim. Right. What more do we know about Caitlin?
Right, so the victim, she was Caitlin. She was a twin. She was from Minneapolis, close to her family, and just 31 years old at the time. Her family posting this online. Take a look. Caitlin was small but mighty, quiet but fierce, and was as brave as they come. She had so many nicknames, including Chai and Goose, to name a couple. Her loved ones would like her to be remembered by her spirit. The spirit of Chai is a whimsical wanderer, along for the ride, up for the adventure, and she was a multi-talented powerhouse. The spirit of Chai and Joy lives on in her 2 beautiful girls. Again, on Monday, this trial kicks off for Dustin Duran. It's expected to start with those opening statements. He faces up to life behind bars if convicted. He's facing multiple charges: first-degree murder, second-degree murder, endangerment of children, fleeing from police. So this is going to be one to watch.
Matt Johnson, thanks so much for monitoring that for us. We'll have that for our viewers on Monday. For now, let's head back to Massachusetts. We are watching together the Irish firefighter rape trial for Terrence Crosby. He's accused in the rape of a woman who was in a hotel room with his friend. She says she did not consent to waking up and finding him on top of her. She is under cross-examination right now by the defense. We're not showing her face or using her name, but she is being asked about the drink she had at the bar when she met her friend.
I'd asked you if you had lost track of how many drinks you had. You answered no. And then I asked you, is it fair to, if you had testified differently in a prior proceeding? Is that fair to say?
Yes.
Okay. Now, in that recorded interview, you also told the detective that you thought you had left the Black Rose at approximately 11 p.m., right?
Approximately, yes.
Okay. And in watching the video yesterday, it's clear that that was actually after 11:30, right?
Yes, approximately.
Well, the video actually shows that it's after 11:30. You would agree, right?
Right, but when I said approximately 11, it was because around 11.
Okay. You described Mr. O'Brien for the detective, but again, didn't know his name, right?
Correct.
You told the detective you didn't exchange contact info or social media, right?
Right, we did not.
And
but I didn't expect to be leaving at 2:18 in the morning.
And in this recorded interview, you went on to tell the detective that during your encounter with Mr. O'Brien, you wore a condom, correct?
I don't know.
And again, that's a recorded interview, right?
I believe that, yes, they were recorded.
And your testimony today is different, right? Today you told the jury that he did not wear a condom.
That's correct.
And in a previous proceeding, you testified that you were unsure, correct?
Yes.
You told the detective that the person who allegedly assaulted you did not wear a condom, right?
At what time?
During that first recorded interview at the hospital.
I believe so.
Okay. You would also describe that person as also being Irish with a similar height but not balding, right?
Yes.
And you said the man who allegedly assaulted you was completely naked, right?
At which?
During that first recorded interview. And today, right?
He was.
Okay. And then that first interview concluded, right?
I believe so.
Okay. So the next day was March 16th of 2024, right?
Yes.
And you went to Boston Police Department A1 for a further interview, right?
Mm-hmm. I did.
And this time you met with Detective McDonough and Detective Byron, right?
Yes.
Okay. You again denied seeing anyone in the room when you and the man you would later come to know as Mr. O'Brien arrived back at that hotel room, right?
Yes.
You seem pretty sure about that, right?
Yes.
Denied it multiple times at this point, right?
I have.
Okay. The detective, again, this was another recorded interview, right?
I believe all of them were recorded.
Okay. So the detective even asked more than once, clarifying that you knew no one was in the bathroom, right?
Yes.
Okay. You said no one else was there, correct?
Yes.
You were shown the video from the Black Rose, right? By the detectives?
Which video? Sorry, which video?
You were shown video of the Black Rose by the detectives, is that right?
Yeah, at one of our interviews, yes.
Okay. And so you identified yourself and Mr. O'Brien in the video, correct?
I did, yes.
And at that time, you didn't recognize anyone else from the video, correct?
I recognized groups of people, but not anyone specific.
Okay.
No one stood out to me.
And you told the detective you weren't sure you could ID the person that you allege assaulted you, right?
That's correct.
Today you told this jury that you were looking at his face, right?
I had seen his face, but I was not trying to look at his face. I was just trying to get out of that hotel room and out from under him.
Okay. So you've now had, to this point, 2 interviews with the police, right?
At which point? I'm sorry.
Between the morning of the 15th and the 16th?
Yes.
Okay. In neither of those interviews did you say anything about the bathroom light being on, right?
I don't believe I was asked about the bathroom light.
Okay. And you still haven't told the officers to this point in either of those 2 recorded interviews about you being in the other bed away from where Mr. O'Brien was sleeping, right?
Again, I don't believe I was asked about those details.
And in those 2 recorded interviews, or at least one of the 2, you had said the person who allegedly assaulted you was close to your height, right?
About my height, yes.
Okay.
But as I said yesterday, I'm not the best at height.
And that's the first time that you had mentioned you're not the best at height, right? It was yesterday?
Yes.
Okay. And you've testified in prior proceedings and never mentioned that before, right?
Because I wanted to clarify.
Okay. Regardless, you didn't tell the detectives that the person who assaulted you was 4 to 5 inches taller than you, though, right?
No, but I told them he was taller than Liam and not bald.
Well, you said about the same height as you, correct?
Approximations, yes.
Okay. You said he was completely naked but hadn't mentioned any scars, tattoos, or birthmarks, right?
I was absolutely not looking for any of those things.
But he was fully naked, correct?
I wasn't examining his body. Yes, he was naked, but I wasn't looking for any of those things. I just wanted to get out of that room.
You weren't asked in those interviews and didn't talk about where you were earlier in the day or night before the Black Rose, right?
I don't believe I was asked, so if I wasn't asked, I don't.
Okay. And Similarly, you weren't asked and didn't talk about how much you'd had to drink at those prior locations either, right?
If I didn't talk about those, I wouldn't have said that, yes.
Okay. And the detectives hadn't asked how much you'd had to drink in total over the course of the day, right?
I don't know if that was one of the questions.
Okay. Again, you didn't tell the detectives about what you had eaten prior in the day either, right?
I don't believe so at that time.
Okay. And when the police showed you the video at the Black Rose, did they show you leaving at 11:34 and not 11 as you had guessed?
I said approximately 11, but yes, it says 11:34.
Did they show you shaking Mr. Crosby's hand?
Yes.
Did they show you hugging Mr. Crosby before he left?
Before he moved away from the table, yes.
Well, there's no question now. Next question.
But you didn't remember any of that prior to seeing the video, correct?
I don't remember the shaking and the hugging.
Right.
I remember shaking hands and hugging a lot of people, but as I said, this person was irrelevant to me at that time.
Is it fair to say you were pretty intoxicated while you were at the Black Rose?
No.
The defense there getting the alleged victim to confirm that she met this firefighter who's on trial prior to the incident, that she shook his hand and hugged him. And it was the video evidence that proved that. She didn't initially share that with police, but she now is saying on the stand that she didn't remember him. He didn't stand out to her at all. What is going to happen next in this cross-examination? We'll see on the other side of this break. Stay with us.
Tonight on Closing Arguments, Family Matters star Darius McCrary makes a bizarre court appearance facing felony charges. We'll dive deeper as our experts weigh in.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Donna Edelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins, season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
Will a second jury be able to reach a decision? We are watching together day 2 in the Irish firefighter rape trial in Boston, Massachusetts. The defendant, Terrence Crosby, he is standing trial for the second time on charges that he raped a woman in a Boston hotel. The first jury ended in a hung jury case. The firefighter from Dublin, Ireland, he was in Boston to march in the St. Patrick's Day parade when the alleged attack took place. The accuser has taken the stand and shared disturbing allegations that she was asleep when she woke up with him on top of her and him not stopping. He was inside of her and then pushed her up against a wall. She says that he told her that he was better than her friend, his friend rather, the friend that she did have consensual sex with. She's on the stand now under cross-examination, and she's being grilled about how much she knew about this defendant prior to this incident. Let's go back in.
When the police showed you the video at the Black Rose, did they show you leaving at 11:34 and not 11 as you had guessed?
I said approximately 11, but yes, it says 11:34.
Did they show you shaking Mr. Crosby's hand?
Yes.
Did they show you hugging Mr. Crosby before he left?
Before he moved away from the table, yes.
Objection. Well, there's no question now. Next question.
But you didn't remember any of that prior to seeing the video, correct?
I don't remember the shaking and the hugging.
Right.
I remember shaking hands and hugging a lot of people, but as I said, this person was irrelevant to me at that time.
Is it fair to say you were pretty intoxicated while you were at the Black Rose?
No.
Now, if you're leaving at 11:34 as the video shows, and we did see some evidence of your arrival today at the Omni Park House, is it fair to say that's about 20 minutes from the time you left to the time you got up to the room?
Yes.
Okay. And you don't remember seeing Mr. Crosby again 20 minutes later in his room at the Omni Park House when you arrived, correct?
No.
Okay. You told the detectives at least 2 times no one else was there, right?
Yes.
Is it fair to say you don't remember a lot of things from that night?
No.
The next time you talked to law enforcement about that night, is it an email to Detective McDonough on April 8th of that year, right?
I don't know the exact date.
Did you send an email to Detective McDonough in April of last year?
Yes.
Okay. And is that the first time you told him that when you went to pick up your clothes and went in the bathroom that your alleged assaulter tried to push his way in?
He had asked me to provide a narrative. He wasn't asking specific questions at the time, so I tried to include information.
So that was new information for Detective McDonough at that point, right?
Yes. Because that was the intention of the email.
Okay, but the email didn't include anything about the bathroom light being on before you went in that night, right?
I don't, honestly, I'm sorry, I don't remember the specific email.
Okay.
I remember sending it. I don't remember the actual contents. I haven't looked back at it since then.
Okay, I may come back to that, but for now, I'll move on. Do you recall whether you said anything about being in a different bed or under the blankets at that point?
In the email?
Yes.
As I said, I haven't reviewed that email since I sent it.
Okay. But you did testify about those details to this jury, right? So fair to say those details came later, right?
Yes.
Okay. And some point after that, you prepared to give testimony in the grand jury, right?
Yes.
And is it fair to say you had Detective McDonough's email and an invitation to give him any other information that might be helpful?
He provided me his contact information, yes.
Okay. You didn't email him again with any other details, though, right?
No.
Okay. And you appeared before the grand jury on April 23rd of last year, is that right?
I believe so, yes.
And that was about 5 weeks after the alleged assault, right?
Yes.
And prior to that, you met with ADA Murphy to prepare, right?
Yes, she explained to me what to expect at grand jury.
Okay. Did you meet with Detective McDonough again, too?
He was at our meeting.
All right, that actually is the point where they took a break inside of the courtrooms. Let's bring in criminal defense attorney Colleen Kelly, who is with us. Colleen, she is having to detail this now on the defensive because she's under cross-examination. You know, we don't want victims to feel like they are not believed when they are telling the truth, but the system, it puts them really through the ringer, especially when you're hearing all the time she's had to testify.
Yes, and she clearly is having a difficult time. But obviously, from the defendant's point of view, she's not telling the truth. Now, I'm not hearing the defense attorney say that she's lying, that she's making this up, that she's falsifying this report on purpose. What he seems to be implying through his questions are that she doesn't remember things correctly. She doesn't remember because she had been drinking. And I do think it's odd, and it does point to her memory, that she did, in fact, meet the defendant at the bar, hugged him, shook his hand, and then later, when he was the person that she alleges raped her, she can't identify who it was. And I don't even mean just by name. She can't say, oh my gosh, this was the guy that I met earlier at the bar. This was the friend of the man that I went home with. So that does indicate that perhaps her memory is not perfect.
Why is there no DNA, Colleen? Why do you think? Why don't we have conclusive DNA and only inconclusive unknown male DNA?
And that's an interesting question, too. And you could see the defense attorney asking questions about that. Was this person wearing a condom or not? You said yes. You said you didn't know. Was the other person wearing a condom? And I don't think that we have a really clear answer on what her position is. But the reason why that's important, and they will have an expert presumably testify about how much DNA is left behind when someone is wearing a condom or not wearing a condom.
It's going to be a big part of this case. Colleen Kelly, thank you so much for all of that analysis. More of the alleged victim on the stand after this.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott, of course, honored to be with you this Friday. We are in Boston, Massachusetts this hour, where a jury is hearing day 2 of testimony in the Irish firefighter rape trial of Terrence Crosby. The defendant was visiting Boston to walk in a St. Patrick's Day parade, and now he finds himself on trial for allegedly raping a woman at a nearby hotel. Crosby's first trial ended in a mistrial after the jury could not reach a unanimous verdict back in June. If he is convicted this time around, he faces up to 20 years in prison. Let's get you back inside the courtroom. We are picking it up with testimony from the alleged victim. Now she's on cross-examination by the defense.
Shortly before we took the morning break, I was asking you about an email you had sent to Detective McDonough. I'm going to approach with a copy of that email.
Yes, you don't need to ask.
If you could just take a look at that, see if you recognize it, and then review it.
Yes, I recognize that.
Thank you. I had asked you a number of questions about that email, and I believe you had testified that you couldn't remember. Does that refresh your recollection, having reviewed that?
Yes, it does.
Okay. And so that email doesn't contain any information about whether the bathroom lights were on or off, right?
No, it does not.
And it doesn't contain any information about which bed you were in or whether you were under the blankets, right?
No, it does not.
Okay. So those details came later, right?
Yes, and further interviews with further questions.
So you prepared to give testimony in the grand jury, right?
Yes.
And you appeared before the grand jury on April 23rd of 2024, right?
Yes.
That was about 5 weeks after the alleged assault, right?
Yes.
And prior to that, you met with ADA Murphy to prepare, correct?
Yes, to talk about what to expect.
Okay. And I believe I asked you already, you testified that you did meet with Detective McDonough as well, right?
Yes, he was at some of the meetings. Yes.
Okay. And so in those meetings, you gave additional details that you hadn't previously shared during your recorded interviews with the police or in that email, right?
Right, when other questions were asked to me, I answered those.
Okay. So in the grand jury, you testified about going to Big Night Live and State Street Provisions, right?
Yes.
ADA Murphy asked you if you were eating and drinking, right?
Yes.
She did not ask what or how much in the grand jury, right?
I don't believe so.
Okay. And again, in the grand jury, when you went on to testifying about going back to the Omni Parker Hotel, you said nothing about anyone else being in the room when you arrived, correct?
Because no one else was in the room.
And, well, you testified that there was no one else in the room at the grand jury as well, right?
Right.
Or at least you couldn't remember someone being there, right?
No, because there was no one else in the room.
Okay. You were also asked about whether Mr. O'Brien had worn a condom in the grand jury, right?
Yes.
And whereas in the previous recorded interviews you had told the police he had, now in the grand jury you're telling them that you couldn't recall, right?
I don't recall exactly what I said in the grand jury.
Okay. Today you're sure he was not wearing a condom, correct?
Yes.
And in the grand jury was the first time you testified or told anyone that Mr. O'Brien was starfished across the bed, right?
I believe so. That was one of the answers to the question that was asked of me.
And in the grand jury was the first time you said that you had gone to sleep in the other bed, right?
Similarly, was a question that was asked of me, so I answered it.
And you hadn't previously mentioned that in your interviews with the police, right?
No, I was asked very specific questions in those interviews with the police, and that fact did not come up.
And in the grand jury was also the first time that you testified or spoke about the fact that you were naked in the other bed, right?
Similarly, it was the first time that I needed to share that information.
And you hadn't mentioned that in your prior recorded interviews or the email to the police, correct?
Correct.
Similarly, about getting under the covers, first mentioned it in the grand jury, not in prior interviews with the police, right?
Correct.
And then again, in the grand jury, you testified about being assaulted and the alleged assaulter talking about Mr. O'Brien being a loser, right?
Yes.
Not exactly what you had told Mr. Jacobson previously, right?
Not exactly, but the same concept.
And then you testified in the grand jury that after you were able to get up, you started collecting your clothes from around the room, right?
Yes.
Was that before or after your alleged assaulter was supposedly chasing you around the room?
Sorry, could you...
Well, you testified that after you were able to get up, your assaulter was chasing you around the room. You've also testified that you collected your clothes from around the room. I'm just asking, did you try to collect your clothes before he chased you around the room?
Once I got up, he followed me absolutely around the room. So while I was collecting my clothes, I was being followed by him.
So he was following you while you tried to collect your clothes?
Correct.
Okay. And Mr. O'Brien never woke up during this period, correct?
No, he was snoring very heavily the entire time.
Okay. And you testified in the grand jury that the bathroom light was on so you could see, right?
Yes.
But you hadn't mentioned anything in those prior interviews about the bathroom light, correct?
Similarly, as I mentioned, that was the first time that the question was asked of me.
And you still in the grand jury didn't say anything about identifying marks, tattoos, scars, birthmarks on your alleged assaulter, right?
As I said earlier, I wasn't looking for any marks on him.
I'm just asking if you testified to any of that in the grand jury.
No, I didn't notice any marks or scars.
Okay. But in the grand jury, you did testify that he was supposedly naked, right?
Yes.
Okay. You had another interview and statement with the ADAs and Detective McDonough on May 27th of this year, right?
I believe so.
In that statement, you told ADA Murphy and Detective McDonough you turned on the bathroom light after you and Mr. O'Brien finished having sex, right?
I'm not sure.
Okay. Is it true that yesterday you testified that that light was already on?
Yes.
Okay. Okay, and because of that, you testified that you could clearly see the person who allegedly assaulted you, right?
I could.
Okay. And even though you could see him, again, you didn't testify to anything about identifying marks, scars, tattoos, birthmarks, right?
As I mentioned, I wasn't looking for those. And turning the light on, he wasn't in the room prior to me going to sleep. So the light was on when I woke up to him raping me.
So the light remained on when he was naked and not on top of you, correct?
Yes.
And you could see him, correct?
Yes, but like
But you never testified or gave statements about him having birthmarks, scars, piercings, tattoos, right?
Like I said, I really was not looking for any of those things. I wanted to get out of there after he had raped me.
And then you had one further interview with the ADAs on October 15th, this past week, right?
Yes.
And that was the first time that you guys discussed specifics of your interactions with Mr. O'Brien in that hotel room last March, right? In terms of what sexual activity you engaged in?
Consensual sex.
None of your previous statements to the police or the DAs, did you mention whether Mr. O'Brien was single or married, right?
Overruled if you're able to answer that. You understand the question?
No.
So you gave two statements to the police that were recorded. You've had numerous interviews and statements with ADA Murphy and Detective McDonough. You've testified in the grand jury. In none of those prior proceedings did you testify or give a statement as to whether or not Mr. O'Brien was single or married, right?
Right.
Okay. Similarly, if you knew whether he had given you his true name, right?
Yes.
Okay. Did you ever give them any... You never gave them any statement as to how intoxicated you believe Mr. O'Brien to be, correct?
That was never asked.
And you never previously told them whether you discussed safe sex or birth control, right?
Again, never asked.
You told ADA Murphy and ADA Mendez in this most recent October 15th statement that upon returning to the hotel room, you and Mr. O'Brien began kissing, right?
Yes.
That he touched and kissed your breasts, right?
Yes.
You told them that you performed oral sex on him, right?
Yes.
You told them, that you then had vaginal intercourse, right?
Yes.
Do you recall whether he removed your clothing or did you?
It was mutual.
Do you recall if you had sex with Mr. O'Brien more than once?
No, we did not.
Do you recall if he engaged or attempted to engage in any other sex acts during your encounter?
He did not.
Did you talk afterwards?
I went to the bathroom, and when I came back, he was asleep.
So immediately after finishing vaginal intercourse, you went to the bathroom, and when you came back, he was asleep?
Correct.
Okay. At any point, either before or after having sex with Mr. O'Brien, did you discuss the fact that he had a roommate?
No.
And it's your testimony that he fell asleep before you, correct?
Yes.
And the only other person that could confirm all of this is Mr. O'Brien, right?
Yes.
Okay. So, having looked back at all your various statements, you are suggesting to this jury that the hotel was lit, right?
Yes.
That you were asleep in the other bed, which was fully made when you arrived, right?
Yes.
And you were under the covers, right?
Yes.
You are suggesting that Mr. Crosby entered the room without you noticing.
I was asleep. Yes.
You're suggesting that Mr. O'Brien didn't see or hear him enter the room?
Because he was asleep, so yes.
And you're suggesting that Mr. Crosby didn't turn out the light?
I woke up and the light was still on and he was inside me, so no, he did not.
So you're suggesting that he noticed you in his bed, right?
Yes.
And that although you were under the blankets, you were naked, right?
Yes.
And that he took the sheets back off to expose you without awakening you, right?
I was asleep, but yes, that's what happened because when I woke up, he was inside of me.
And you're suggesting that he positioned you in a manner such that he could insert himself into you, right?
I slept on my back. I sleep on my back, so yes.
And again, this is all happening without Mr. O'Brien awakening, right?
He was snoring the entire time.
And then you're suggesting that he did actually insert himself and began having intercourse with you without you waking up initially, right?
Absolutely.
And you're suggesting that once you pushed him off, you noted he's slightly taller than you?
Yes.
But it's not someone that you recognized as someone that you shook hands with or hugged at the Black Rose, even though you could clearly see him in the light, right?
Again, he was irrelevant to me at the Black Rose. I met a lot of people. He did not faze me at that time.
And you deny that he was in the hotel room when you arrived, right?
Yes, I do.
But you're saying that he was naked and followed you around the room, right?
Yes.
Again.
Counsel, how much do you have left? Been through this.
Not much, Your Honor. This is actually wrapping up. So again, suggesting to this jury that you didn't notice any bodily marks, scars, tattoos, right?
I was not looking at his body. I didn't care. I needed to get out of there.
But you could see him, right?
Sustained. We've been through this.
Understood, Your Honor. You didn't try to wake Mr. O'Brien?
No, I wanted to get out of there.
You didn't run out of the room?
I did not literally run out of the room, no. Okay. But I got out of there as fast as I could in the given situation.
Okay. You didn't speak to any hotel staff, right?
No, I didn't know anyone. I wanted to get home and get to the hospital.
Is it true you walked home still feeling under the influence of alcohol?
Objection. Sustained. We've been through this. New material, please.
Fair to say you have gaps in your memory from that night, right?
Objection. Sustained. Please answer this.
it fair to say you didn't remember the name of the man that you had gone back to his hotel with?
Objection sustained. Okay, the next question needs to cover new material where the cross-examination is over.
You didn't remember the floor of the hotel you were on, right?
That's correct.
You didn't remember the number of the hotel room, right?
I wasn't paying attention to the hotel room number.
So it's fair to say you weren't paying attention to a lot of the details that might matter, right?
Sustained.
That's all, Your Honor. Thank you.
That's it. Sidebar.
All right, before we head to break, I want you to see on your screen the clock, 5 minutes, 2 seconds, because we're now on verdict watch in the caught in the crossfire murder trial against 16-year-old Paris Larry Jr. Larry is accused of being involved in a shooting that killed a woman who was just taking out the trash following a cookout. We, of course, will bring you that verdict live when it happens. In the meantime, when we come back, we will have more of the accuser's testimony in the Irish firefighter rape trial for Terrence Crosby. So stay with us here on Court TV Live.
I'm going to ask you a lot of intensely personal questions. How do you explain it? The worst crime anyone can imagine. Do you feel like you took the fall for this murder? Tell me in your own words, what happened? Let's get started.
Interview with a Killer. New season premieres Saturday, October 25th. Only on Court TV.
Back now to Boston and the Irish firefighter rape trial of Terrence Crosby. The 38-year-old was visiting Boston with fellow firefighters to walk in the St. Patrick's Day parade last year when prosecutors say he raped a woman at a hotel. Now, his first trial ended in a mistrial. Now, he's on a second go-round, the prosecution wanting him convicted. We want to get you back into court now. The accuser is now facing redirect by the prosecution.
When you were being asked questions at the hospital by the nurse about what acts were, what happened to you, did you know what had happened to you before you woke up?
No, because I was asleep. I didn't know how long he was inside of me until I woke up, so I don't know what else happened.
So you don't know if he had attempted to penetrate your mouth or any other part of your body?
Correct.
And you haven't seen the medical records documenting your treatment from that day, correct?
Correct.
So are you aware of any paraphrasing or statements that your medical providers chose to include in their documentation?
No.
Regarding the different meetings that you had and the interviews that you had, do you remember every single question that you were asked by every different person?
No, there was a lot of them.
When you first met with detectives in the hospital, do you know if that meeting was more or less than 30 minutes?
It was pretty short.
And what about the next day, on March 16th, the day that you identified that photo of Liam? Do you know if that meeting was any more than 8 minutes long?
No, it was short, very short.
So that meeting on March 16th that was referred to as the interview, that was not a full interview, is that fair to say?
Yes.
Was your testimony at the grand jury the first time that you gave a lengthy statement about what happened to anyone in law enforcement?
Yes.
And at grand jury, was there a more detailed set of questions than you had initially been asked by detectives?
Yes, absolutely.
As you were leaving the hotel that morning, why didn't you stop and ask the other strangers in the hotel for help?
Because they were strangers. I wanted to get as far away from there as possible. I also wanted to get to the hospital.
When you were being questioned by the nurse at the hospital, did you understand her to be asking questions for purposes of medical treatment or asking questions for purposes of identifying the perpetrator?
Medical treatment. She was a nurse.
And while you were at the Black Rose on the night of March 14th, did you anticipate being quizzed at a later criminal trial about the number of drinks that you had?
Absolutely not.
When you met with detectives for that short meeting on March 16th, where you identified Liam in the photo, you testified to having seen some of the Black Rose videos. Do you know if those videos were the same videos that you saw yesterday? Meaning, did you see the entire clips that you were seeing or that you saw yesterday?
No, I mean at different points I saw different videos.
So do you know specifically what portions of the videos from the Black Rose were shown to you during that March 16th meeting with police?
No.
Nothing further.
You described those meetings with detectives as very brief, not really interviews. Did the detectives ask you to rush or to wrap things up quickly?
They asked specific questions, and they only had specific questions for me.
Did they ask you to tell them anything that might be important?
Did they ask that specific question?
Or some words to those effect, yes.
They asked very specific questions.
But did they ask you to tell them anything that you thought might be important for them to know?
I don't know if that exact question was asked.
Did they give you their email addresses and ask you to share anything important with them?
Yes, Detective McDonough did provide me this email address.
Okay. And as you sit there today, is it fair to say your memory was better then than it is today? Is it fair to say your memory of events last year in March is better then than it is today, over a year later?
Yes.
Okay.
But
thank you. That's all.
Let me bring in right now trial attorney Mackenzie Joy Brennan. Mackenzie, of course, thank you for being on with me today. It's hard to hear. I find that this alleged victim in her testimony, she's emotional, she's upset. I think it's traumatic to have to recount what she says happened. How do you feel about her credibility and the information she's providing to the jury?
I mean, you can never account for the jury. So I'll preface everything with that. Obviously, the first trial ended in a mistrial, so there's some difference between what was seen there and what I think we are seeing now, which is she's incredibly credible. I'm not convinced by the defense's strategy here, which seems to be very nitpicky to the point that even the judge admonished him, and leans heavily on victim blame. Things like, how many drinks did you have? Why didn't you know the name of the man that you went home with? Things that have very little bearing, in my opinion, on whether this is credible. And whether the jury agrees, we'll see.
And the victim blaming, I understand exactly what you're saying. That's a fine line. And if a defense attorney crosses that line and does it, most likely the jury won't look on that favorably. But B, I want to mention we are live streaming all of this on YouTube. And there are our Courties chatting. And they're the Cool Kids Chat Club. A shout out to them because I've been joining and watching and listening and seeing the comments. And one of the things raised is the lack of any other evidence. We know what she says happened. She did all the steps that you're supposed to do in a case like this. She called a friend to get immediate help. She went to the hospital. She got a rape kit, all of these things, but there's no conclusive physical evidence that points to the defendant. Do you think that might be one of the reasons the first jury ended up in a mistrial?
Oh, I'm sure it is. You know, if you've done many of these cases and you know what the commonalities are and what some of the explanations are, to me, it is absolutely not dispositive. I mean, she got away before her alleged attacker had a chance to finish. That, to me, fully explains why there might not be a full DNA profile. My understanding is that there were 2 partial profiles, which that supports her account that, you know, there were 2 people who had intercourse with her that evening. To me, that almost is evidence supporting the outcome that she says happened. But I do understand that if you don't have a complete DNA profile, that's concerning. But, you know, this is the nature of sexual assault cases. Often the nature of the crime is that it's such an intimate interaction. And this is the kind of evidence that you're looking at. Credibility, what steps did people take? Credibility of the alleged attacker too, that is what you're working with in cases like this.
Yeah, often it is the word of the alleged victim that it relies on. Okay, stand by, Mackenzie. We'll be bringing you back in a little bit. Right now, before we head to a break, we have an update out of Florida. We're just 2 days after, Donna and Harvey Adelson shocked the courtroom and used her sentencing hearing as a platform to really just air their grievances, not only against the judge and jurors, but they also had a lot to say against Dan Markel's parents. His family, therefore, has now issued the following statement addressing their comments. Here's what it reads. It is deeply unfortunate that Harvey used his time before the court to challenge our family's account of our relationship with Ben and Lincoln. We will set the record straight, as we have in court and elsewhere. Our family was cut off from contact with the boys for 6 full years. It goes on to say this: beyond her crimes, Donna scorned Danny, drove deliberate wedges between him and Wendy, and disparaged him to his own sons. Her display of emotion before the court was not remorse for Danny's death, but sorrow for the consequences she now faces for causing it. Donna is spending life without parole behind bars for Markel's murder, and tomorrow night at 8 p.m. Eastern, you do not want to miss. Court TV's Ted Rowlands breaks down the matriarch mastermind murder trial in the season finale of Victim to Verdict. It is something that will open your eyes. That's at 8 p.m. Eastern right here on Court TV. Coming up next, we'll hear from an ER nurse who conducted a rape kit on the accuser in the rape trial against Terrence Crosby. That testimony is up next. Stay here with us on Court TV Live.
got out of there as fast as I could.
Okay. You walked through the lobby and out of the hotel, right?
Yes, trying to get out of that situation where I'd just been raped.
Okay. You didn't stop and say anything to the concierge?
No, I didn't know them.
Didn't stop and call the police?
No, because I wanted to get to the hospital.
You walked home, though, right?
I did.
Welcome back to Court TV Live. I'm Ashley Wilcott. Thank you so much for being with us. It is day 2 of testimony in the Irish firefighter rape trial in Massachusetts. Terence Crosby, a firefighter from Dublin, Ireland, is charged with raping a woman at a Boston hotel in March of last year. Prosecutors say the accuser had consensual sex with Crosby's hotel roommate and fell asleep in a separate bed. The alleged victim says she woke up to Crosby raping her. Let's get you back inside the courtroom. On the stand now is an ER nurse who treated the alleged victim. And remember, you may hear the audio drop out at times. This is because of a court order to protect the identity of the accuser.
Could you please introduce yourself to the jury and spell your first and last name for the record?
Yep. Hi, I'm Carly Littlejohn. It's C-A-R-L-Y, last name Littlejohn.
How are you currently employed?
I'm currently employed as a registered nurse at the Mass General Emergency Department.
In what department or area of specialty?
In the emergency department, emergency medicine.
How long have you been a nurse at Mass General Hospital?
I've been a nurse since November of 2023.
Prior to becoming a nurse at Mass General, did you hold any other jobs in the medical field?
I did. I began as an EMT in 2017. I later progressed to get my paramedic licensure in July of 2020. I was employed as a paramedic on the ambulance from 2020 to 2024, and I also worked as a paramedic in the emergency department of Mass General beginning in April of 2023.
So beginning in April 2023, you worked at Mass General Hospital, but first as a paramedic and later as a nurse?
That's correct.
What is your educational background?
So as previously mentioned, I got my EMT certificate. I also have my paramedic licensure. I graduated from Syracuse University with a degree in biology in 2018. And then I graduated with a Bachelor's of Science in Nursing in 2023 from Mass General Institute of Health Professions.
In addition to the licenses and certifications that you already mentioned, do you hold any others?
Yes, I do. I hold BLS, so Basic Life Support, ACLS, Advanced Cardiac Life Support, NRP, Neonatal Resuscitation Program, PALS, Pediatric Advanced Life Support, TNCC, Trauma Nurse Corps certification.
In March of 2024, you were employed as a nurse at Mass General Hospital, is that correct?
That's correct.
And on March 15th, 2024, did you participate in the medical treatment of a woman named...
That's correct.
Along with a physician in the emergency department, did you perform what's referred to as an evidence collection kit on Ms.
I did.
In your role as an emergency department nurse, had you been previously trained in how to perform an evidence collection kit?
Yes, I have.
Within the kit itself, are there also step-by-step instructions for medical providers?
There are.
As part of that evidence collection kit, did you ask Ms. a series of questions?
Yes, I did.
Did you also conduct a head-to-toe physical examination?
Yes, I did.
Did you document that in forms that are contained within the evidence collection kit?
Yes, I did.
Did you make notes regarding your treatment of Ms. that day?
I did.
How did you do that?
I did them within the examination kit as well as in the electronic medical record.
When you say examination kit, like the evidence collection kit?
Yes, that's correct.
Okay. Have you seen a copy of Ms. record of treatment from March 15th of 2024 at Mass General Hospital?
Yes, I have.
And when you saw it, did you see your notes contained within it?
Yes.
Where did you first meet with Ms. in the hospital that day?
I first met with her in the urgent section of our emergency department in room 22.
Did you speak with her about having an evidence collection kit performed?
Yes, it's necessary to obtain consent before performing the kit.
And at that time, did you understand that you would later be performing the kit, or were you planning to page a different nurse to do that?
So we started off by paging the nurse, but all nurses in the emergency department are qualified to perform a kit as well.
So you knew that there was either possibility?
That's correct. Yep.
You said that a patient needs to consent to having an evidence collection kit performed. Is there a consent form within the kit?
There is.
What do you tell a patient about the timing of an evidence collection kit or anything else about the kit prior to performing it?
Yeah, so prior to starting, I kind of run through the steps of the kit. I explain what we're going to be doing, that we're going to be doing a head-to-toe physical exam and also the evidence collection, which does involve swabs of just external and internal swabs as well. And I kind of talk them through everything and obtain their consent. And I'm sorry, was there another part of that question I'm missing?
Do you tell them anything about the timing, like how long the kit might take?
Typically the kits take 4 hours, and you're with the patient for 4 hours, and you cannot exit the room once you start the kit.
Does a patient have to meet certain criteria to be able to provide consent for the kit?
Yes, they do.
And what are those criteria?
They have to be medically cleared and able to consent to the exam. So medically cleared just determines that there's no life-threatening injuries we would need to treat prior to performing the exam, and also that they're able to consent to the exam as well.
How do you make that determination that they're able to consent?
Just that they're talking with clear speech, they're alert and oriented ×3, they're able to form a linear thought pattern, they're making eye contact, they're able to walk and talk on their own, and it's not just a decision I make, it's also part of the collaborative team with the emergency room doctor as well.
You said alert and oriented ×3. Can you explain to the jury what that means?
Of course. So you know who you are, you know where you are, you know what date, time it is, and you know like what's going on essentially.
How do you assess that?
So a couple different ways. So you can just talk to the patient, like usually anybody who works in the medicine can just talk with the patient, determine that they're able to answer your questions clearly, coherently, that they have like a straight way of thinking, like a linear thought pattern. Also, you can ask them directly, do you know your name? Do you know where you are? Do you know what the date and the time is? And also just by general like interactions with the patient as well.
In this case, did you determine that Ms. was capable of consenting to the evidence collection kit?
Yes, I did.
And did you in fact perform the kit on Ms. in the emergency department at that time?
Yes, I did.
Where in the hospital was that examination conducted?
In room 22 in the urgent department.
Do evidence collection kits come with a particular number assigned to them?
Yes, they do.
How do you know what the number is?
So it's listed on the outside of the box, and there's a big like sticker, a bunch of stickers that are uniquely identified that go on each and every page of the kit as well.
I'm going to show you a photograph and ask if you recognize what that photo depicts.
Yes, I do.
What is it?
So that's the outside copy of the evidence collection kit, what we fill out on the outside of the box.
And you see the sticker there reflecting that unique number that's assigned to that kit?
Yes, I do.
Well, what is the number assigned?
So there's two numbers. So the one up here is the toxicology kit that's included, and then there's a second number. The second number, do you want me to read it out loud?
Sure.
Okay. The second number is MA07395.
Each evidence collection kit is a box, is that right?
That's correct.
And it contains forms and envelopes?
It does.
In this case, did you use the forms contained within the kit to document your examination of?
Yes, I did.
Looking at Form 3, is this a form on which you summarized a statement that Ms. made to you about what had happened?
Yes.
Whose handwriting is that?
That is my handwriting.
And can you read what you wrote?
Yep. So, patient had date, went back to his hotel, awoke to unknown male inside of her for unknown amount of time. Patient states she remembers him saying, quote, he, in parentheses, date, couldn't show you a good time, end quote. Patient states she pushed him off of her and tried to get up to find her clothes. Patient states he followed her around the hotel room, pushing her against walls and furniture, attempting to keep hooking up. Patient again pushed him off and told him to, quote, get away, end quote, dressed and walked home.
So that whole paragraph, is that all a quote from or only the statements that are in quotation marks?
Only the statements that are in quotation marks. It's a general summary.
I'm going to show you a separate form within the records called Form 2A. I'm going to try to zoom in. I know the font is a little bit small, at least for me. Whose handwriting is on this form?
That's my handwriting.
And where are you as you're posing these questions to Ms.
I'm standing at the patient's bedside.
Coming up, more testimony in the Irish firefighter rape trial against Terrence Crosby. Plus, we're going to head to California, where Jake Haro has now pleaded guilty to the murder of his own 7-month-old baby. My thoughts from the bench up next. Stay tuned.
Tonight on Closing Arguments, Family Matters star Darius McCrary makes a bizarre court appearance facing felony charges. We'll dive deeper as our experts weigh in.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Donna Edelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
Let's quickly turn to California, where the father of missing baby Emmanuel has now pleaded guilty to his infant son's murder.
How do you plead to the charge in count 1 of the amended felony complaint of violation of Penal Code Section 187A?
I'm guilty.
Okay. And for clarification for the record, that's going to be in the second degree?
Yes.
Sir, do you admit that you committed a violation of Penal Code Section 187, Subdivision A, a felony, in that on or about August 5th of 2025 through and including August 14th of 2025 in the County of Riverside, State of California, you did willfully and unlawfully murder baby doe, initials EH, a human being? I admit.
Jake Haro sobbed in a California court yesterday as he admitted to abusing and murdering his defenseless 7-month-old son. Baby Emmanuel's remains have still not been found. His wife, Rebecca Haro, was in court too, but pled not guilty, and she is scheduled to have her preliminary hearing on charges of murder and filing a false police report on November 3rd, the same day that her husband, Jake, is scheduled to be sentenced. Now for my thoughts from the bench on this case. This case disgusts me even more than other child murder cases we've covered. Why? Because the father, Jake, who's now pled guilty, he has a history of child abuse against another one of his own children. It was only 2 years ago that he was convicted of child cruelty against another infant daughter who, according to law enforcement, is now permanently bedridden as a result of his abuse. And in that case, the judge gave him probation instead of any prison time. I agree with the district attorney who later called that decision an outrageous error in judgment. Because if he abused a child once, he will do it again. And now his child had paid the ultimate price. He should not be let out of prison. He should testify against the mother, and he should immediately disclose the whereabouts of that poor baby boy's body. Those are my thoughts from the bench. I want to take this opportunity to bring in, still with us, trial attorney Mackenzie Joy Brennan. Mackenzie, it disgusts me, it frustrates me. There's so many different adjectives I could use, but let me ask you about the fact that, and number one, he pled. That's a good thing in our system, that he owned up and admitted that he murdered his child.
Yeah, boy, I agree with you on all those fronts. I keep going back and forth as to whether I think the mother is more or less involved than he is, because obviously she has pled not guilty, but she must be involved to some extent because she made that 911 call. She said that he was with her when whatever happened. So she must be involved to a certain extent, but then on the other hand, he does have this history. So of the two of them, I would believe more easily that he had more to do with it. But boy, just thinking about being whoever was involved in sentencing him to probation in that first case, and that's where this gets us. I think with things like child abuse, there should be no tolerance for let's try again without some showing of reform, without completing a course at the very least, that there's some concrete proof that you're not going to do this again, that you're a different person.
And let's talk about the wife, because I believe they both fully know what happened and were involved in some capacity. I have no doubt the mother of the child knew and was involved, but that's my opinion. Putting that aside, she's innocent until proven guilty, but that's what I think. Putting that aside, that's why I think he needs to testify against her, because otherwise she could easily say, Mackenzie, I didn't know, I wasn't there, I had nothing to do with it. He did it, he's already pled to it. I think that's a good defense if she goes that route.
I think you're right, and I'm sure that it's kind of a race against time on both sides. I do wonder if he agreed to this in some sort of, prisoner's dilemma type scenario, and that it may be reflected in sentencing, or some promise was made behind the scenes. Obviously, we did see him involved in some searches early on, and so that makes me wonder if that was part of an agreement, and I also wonder if he was being candid when he brought them on those searches, or if he knows.
And unfortunately, we're out of time. Thank you so much, Mackenzie, for joining us. Coming up next, Kelly Craft joining me for more of the Irish firefighter rape trial. Stay tuned.
990-6156. That's 800-990-6156. Call now.
Welcome back to Court TV Live. I'm Ashley Wilcott.
And hi, everyone. I'm Kelly Craft. Thank you so much for being with us this afternoon. And we are in Boston, Massachusetts, where it is day 2 of testimony in the Irish firefighter rape trial for Terrence Crosby.
The 38-year-old was visiting Boston with fellow firefighters to walk in the St. Patrick's Day parade just last year when prosecutors say he raped a woman at a hotel.
The alleged victim, who has decided to remain nameless, testified at Crosby's first trial that she had consensual sex with another firefighter who was rooming with Crosby that night. She says they fell asleep in separate beds, but later awoke to Crosby raping her.
And let's get you back into court now. We are picking it up with more testimony from the ER nurse, Carly Littlejohn. She is still on direct examination by the state.
So looking up at the top section and making your way down, can you just explain generally what types of information the form is designed to collect?
Yep, it's just general patient information like age, gender, race, when the exam was completed, the time it was completed, and where it was done.
Okay, so looking at section C, weapons/force used, is that your X mark there next to hold down/body weight?
Yes, it is.
And in the section directly below that, acts described by the patient, there are a number of X marks there, and next to some of them, it's marked unsure. Had Ms. told you that she had been asleep initially when the events began?
Yes, that's correct.
And so was she able to tell you what had occurred while she was asleep?
No, she was not. That's why it's marked unsure.
So moving to Form 2B within the records, is there a section on this form, specifically within Section A, pertinent/recent health history, where you document if the patient had consensual sex in the past 120 hours or 5 days?
Yes.
And do you know what the purpose is of that question, or what the significance is of that time frame?
The significance is that is approximately how long a evidence collection kit can be obtained for. So if it had been outside that window, it wouldn't be relevant for evidence collection.
Okay. And if a patient reports to you that she has had multiple episodes of consensual intercourse within that 5-day period, would you document all of them or just the most recent one?
All of them.
She's answered. Next question, please.
And in this case, what was reported to you about whether Ms. had consensual sexual intercourse in the past 5 days?
It was reported she had one event of consensual intercourse, which ended approximately 7 hours, as documented.
7 hours prior to you posing the question?
Yes,
Okay.
correct.
Moving to Form 4 within the evidence collection kit, is this the form on which the physical examination of Ms. was documented, or the initial part of the physical examination, I should say?
Yes.
Whose notes are there in the upper left corner?
Those are mine.
And can you read what you wrote there?
Yep. Patient, so PT means patient, well appearing, tearful and anxious, otherwise appears healthy.
And are these your notes further down below the body maps and on the second body map as well?
Yes, they are.
Can you explain what each of those notes indicates?
Yep. So 1 and 3 are both pointing to the vaginal area. The PA next to line 1 says pain to vaginal area, and there's indicated that there's no photograph. And then with the same pointing to the same area of the body, Line 3 says LA, which means laceration, and there's a laceration to the external vaginal opening, and there's no photograph. Line 2 was the line drawn to the head, just pain to the head with no photo.
You mentioned that there's a collaborative team that makes the initial decision about whether the patient can consent to having the kit be performed, and that included the physician.
That's correct.
Were you also working alongside a physician when performing this part of the kit, the physical examination?
Yes, I was.
And who was that physician?
Dr. Lindsay Walsh.
Looking at Form 5 within the records, is this a form that documents the pelvic examination that was part of the evidence collection kit in this case?
Yes.
Were you present for the pelvic examination?
I was.
Who performed the actual exam?
Dr. Lindsay Walsh.
So I'm scrolling down and I note the notation there where it says at the bottom, the location number on diagram is 1, and then small tear without active bleeding at posterior foreshed. Who made that note, if you know?
Dr. Lindsay Walsh.
Did you yourself take any additional swabs from Ms. body beyond the swabs that were taken during the pelvic examination?
Yes, I did.
Where did you take those swabs from on her body?
I would have to see the document to recall.
Is this a list of all of the available steps within the evidence collection kit with notations about which steps were actually performed in this case?
Yes, it is.
Can you tell me who made those check marks, if it was you or Dr. Walsh or someone else?
I made those marks.
And next to step 10, does it note that additional swabs were taken taken from?
Yes.
And let me ask you a different way. Did Dr. Walsh take all of the internal swabs in this case?
Yes, Dr. Walsh did all the internal swabs and I did all the external swabs.
Okay. I'm going to ask you as well if there were steps within the kit that you did not perform that you noted on here.
Yes.
And can you explain what those were?
So step 7A and 7B, foreign material collection, I did not do that. Also, she did not give us her underwear that was worn during the exam. And there were no bite marks to swab, so I did not obtain that. I did not obtain the pubic hair combings or the anal swabs or smear. And then there's some extra clothing listed below that I didn't collect as well.
So is it accurate that her bra was taken, her shirt was taken, and her pants were taken?
And her underwear that was worn immediately after. Yes.
Oh, thank you. Up above,
yeah,
under step 8?
Yeah.
Okay.
Yeah.
Thank you.
Yep.
Looking at Form 2B, I have some other questions for you about that.
Okay.
Can you explain what is documented in Section B on this form?
Yep. So it's asking if the patient has changed their clothes and if they have bathed or showered. They haven't. They did change their clothes, but they did not bathe or shower.
And in Section D, acts described by the patient, there's a question about prolonged or forceful touching of the patient's skin by the bare hands or fingers of the person. What did you note there?
I wrote yes, and then it says describe location. I wrote chest/breast.
And in speaking with a patient about what happened to them prior to their arrival, do you know what the significance is of asking them whether there was touching anywhere else on their body?
It's for additional DNA collection. We'll swab those areas if the patient consents.
So was a swab taken of Ms. Chest or breast area?
I believe so, but I would have to look at the documents to make sure.
Do you know if that's noted specifically within the records or only within the kit itself?
It might be within the kit itself. It might be under additional swabs.
Okay. Within the kit itself, is there room to make notations on the envelope that contains each of the different types of swabs?
Yes, there is.
How did the evidence collection process end in this case?
The evidence collection process ends with filling out the final form, just making sure you have all your documents in order. And then it ends with putting all the specific swabs back into their specific containers, off of the drying rack into the specific containers, folding them up, putting them in the specific envelopes that they go in, and then all the envelopes go back into the kit, and then it is sealed. And then the kit is picked up by our resource nurse and locked up until the police come and retrieve it.
I'm going to show you what was marked Exhibit 10 with the court's permission.
Yes.
We are going to take a break here, but I do want to mention, you see the verdict clock is up. This is Wisconsin versus Paris Leary Jr., the caught in the crossfire murder trial. Kelly, it's almost 1 hour, so it's pretty quick or pretty new that they've been out there deliberating.
Yeah, jury instructions took a long time in that case.
Yes, they did, and I think they have a lot to talk about because we know shots were fired, but it's a little confusing as to who fired what shots.
Yes.
All right, stay with us. Coming up, we'll have more testimony in the Irish firefighter rape trial, and you're on Court TV, your front row seat to justice.
Tonight on Closing Arguments, Family Matters star Darius McCrary makes a bizarre court appearance facing felony charges. We'll dive deeper as our experts weigh in.
Closing Arguments tonight at 8/7 Central, only on Court TV. Next week,
covering the country's biggest trials before we bring you inside the courtroom. Plus, the most compelling true crime cases in our daily spotlight.
opening statements with Julie Grant. Mornings at 8/7 Central on Court TV.
Welcome back to Court TV Live. Let's head back to Boston for the Irish firefighter rape trial of Terrence Crosby.
The defendant in this case is 38 years old, and he was visiting Boston with fellow firefighters. They were walking in the St. Patty's Day parade there last year when prosecutors say he raped a woman at a hotel. His first trial ended in a mistrial. We want to get you back into the courtroom now. We'll pick it back up where we left off. This is the ER nurse who examined the accuser. She is on the stand.
You testified earlier that that's a photo of the top of the evidence collection kit itself.
Yes.
Do you see where it's noted on there what time the kit was boxed up and secured?
Yes, I do.
Where is that?
It's under Place Kit and Secure Area. It says placed by Kristen Gilmore. That's our resource nurse. And date 3/15/24 at 8 a.m.
Okay. Is that here in the area that I've circled?
Yes.
Okay. Does the outside of the kit also indicate if it was picked up by the police?
Yes, it does.
And does it reflect the timing of that as well?
Yes, it does. It says 9:41 a.m. on 3/15/24.
Is that here where I've circled?
Yes.
Do you know how much time you spent with that day? Are you able to tell without looking at the record itself of the timeline?
I would say she came, I believe, into the department around 3:30 in the morning, and then I was with her until the kit was secured at 8 o'clock in the morning. So I was with her pretty much for that entire time period.
And during, well, actually, let me ask you, do you know if there's also a section of the medical record that documents the timeline of your, I guess, assignment to as her nurse?
Yes, there is.
While you were performing the kit, were you seeing any other patients?
No, it's policy that we give up our whole assignment. So like the patients you're assigned to, other nurses will take them over, and then you are not to exit the room while you're completing the exam. So you're with them face to face for at least 4 hours.
Is that at least in part so that you're not contaminating any part of the kit?
Correct.
And so for that length of time, when you were interacting with her, what was her demeanor like when you spoke with her?
She was tearful. She was tearful but coherent, appropriately anxious about the situation, but very coherent. And
objection, Your Honor. There's not a question pending. Next question.
Did you notice any slurred speech?
I did not.
Did she answer your questions appropriately?
She did.
As a registered nurse in the emergency department, do you ever see patients who are intoxicated either by alcohol or drugs?
Every day.
Based on your interactions with her, did you have any concerns that her faculties were impaired by alcohol or other substances?
I did not.
What is your practice regarding documentation if you do encounter a patient who's demonstrating those signs?
I document it in the timeline when I document how they appear. I would document something along the lines of patient appears intoxicated or not able to answer questions appropriately, and she was neither of those, and able to answer questions.
Thank you. I have no further questions.
Good afternoon.
Good afternoon.
So you testified that you began working as a nurse at MGH. Was it in April of 2023?
No, November of 2023.
November of 2023.
Yes.
Apologies. So you were a fairly new nurse at the time, right?
That's correct.
And you indicated that in order for or any person to give consent, they'd have to be clinically sober, right?
Yes.
Okay. And that's not a term of general understanding, right? That's a clinical term, right?
Correct.
Okay. And so someone who's intoxicated can be alert and oriented ×3, right?
They could.
And someone who's intoxicated could, in fact, answer the types of questions that you asked, right?
They could, but it's not just one question. It's more of your general impression of the patient as well. It's a big scale. It's not just black and white.
Sure. And you had access to her electronic medical record, right?
I did.
And you're aware that she had a .135 BAC, right?
Not at the time, I was not.
Did you become aware of the fact that she had a .135 BAC in reviewing her electronic record?
Objection. Overruled. You may answer.
During my pretrial meeting, yes, I did.
Okay. So, if you're now aware, or became aware at some point that she had a .135 BAC, is it fair to say it's possibly intoxicated and still be found clinically sober?
I would say that could be true, yes.
ADA Murphy just went over the forms that you filled out as part of your evidence collection kit, right? Indicated that she was unsure about oral penetration, correct?
Correct.
Okay, and nothing in the documentation says anything about being asleep, right?
I believe it does.
You noted that she was unsure because she was asleep in your documentation?
I believe if I could view the record that it did say that, yes, while she was asleep. But I can double check.
Okay. Could she have indicated that she was unsure for other reasons, such as being intoxicated?
She could have, but it's just my job to document what the patient tells me. It's not my job to make assumptions.
And she indicated she was unsure about ejaculation, correct?
Correct.
And she said the person did not use a condom, correct?
I don't recall. I'd have to review the chart.
And you noted an injury, a vaginal tear, correct?
Correct.
And you don't know how that occurred, correct?
I can only say that it maybe occurred during the assault because it was documented during my assessment of the patient.
Well, that would be speculation, wouldn't it?
Technically, yes, but I'm just documenting what I'm seeing during my examination.
So it also could have happened because of the consensual sex that she talked to you about, correct?
It could have, but like I said, I'm documenting it based on my medical assessment and for no other reason.
It sounds like you're speculating, not documenting. Is that fair to say?
Overruled. You may answer.
Can you repeat the question, please?
It sounds as though you're speculating as to the reason rather than simply documenting. Isn't that fair?
I'm not speculating. I have no bias against this patient. I'm just documenting what she's telling me and what I'm observing.
But she didn't tell you how that injury occurred, correct?
She told me it happened during sexual intercourse.
How could she have known that if it could have happened from consensual sex?
I don't know, counselor. I'm just documenting what the patient is telling me.
So she told you that the person who assaulted her caused a vaginal tear?
I don't recall exactly what she said to me.
You also noted pain in the vagina, correct?
Correct.
And again, personally, you can't determine how that came about, correct?
I cannot.
Okay. Same for the head pain. You documented that, correct?
Correct.
But you're not aware of what the cause of that is, correct?
Correct.
And I believe Ms. Murphy pointed out that you used quotes in Form 3 for the narrative. Is that right?
That's right.
Okay. And in this instance, you made a note of a quote from Ms. Creamer, quote, "He couldn't show you a good time," correct?
Correct.
That's the only quote you documented, right?
I believe there's 2 quotations in that summary.
Well, the other wasn't that he's a loser or my friend can't do this for you, correct?
Correct.
You would have recorded that if that had been said, right?
If it was relevant, yes.
Well, you said you record what the patient tells you.
I do.
Okay. You weren't present at the incident that was describing for you, correct?
No, I was working in the emergency department.
And so you don't personally yourself know what happened at that time, correct?
I do not.
And you did not witness anything in terms of what may or may not have happened earlier in the evening, correct?
No.
Thank you, that's all.
I'm going to show you Form 3, the narrative that you referred to earlier. Looking at the first line of the handwritten statement, do you see any indication on there as to whether told you that she had been asleep?
Your Honor, could we approach for a moment?
This is a page from Exhibit 1.
Yes, it is. It's Form 3. Could you just read that first line to yourself and let me know or just answer the question that I asked previously about whether there's an indication that she had been asleep?
There is. I write awoke, which determines she was asleep.
Thank you. Nothing further.
Thank you.
I just have one more. There's another question.
Okay.
And with regard to what ADA Murphy just showed you, it said awoke. It didn't say anything about was unsure because she might have been asleep when the oral penetration occurred. Is that right?
It just says awoke.
So it's non-specific, right?
Non-specific.
Thank you.
Let's bring in defense attorney, former head prosecutor Bob Bianchi to help talk about this case with us. Now, Bob, thank you, of course, for joining both of us. I have to ask you about this idea that the defense just planted, which is that she could be intoxicated, but at the same time still be clinically sober. Tell us your thoughts about that piece.
Judge, I was having difficulty as a prosecutor understanding, or as a defense lawyer even, he did a good job at bringing that out. In other words, that she was capable of consenting with a high BAC. But by this, I thought he was going to go towards that the witness was not credible because the witness found that she wasn't intoxicated, and yet she had a 0.13, which could explain teary-eyed, red eyes, a lack of memory, things that we typically would see like in a DUI case or anybody who's under the influence. So I don't know whether or not the defense lawyer's holding that powder for to argue in summation. But I guess in this particular case, he's trying to say she had enough wherewithal that this expert witness didn't even feel that she was under the influence. And certainly somebody who is under the influence could still be alert and oriented ×3 and in fact ×4. And I can tell you that as an EMT, and we all know that. That's the person, place, time, and event. Clearly under the influence, you can do those things. Right. The question is whether or not the level of intoxication robbed you of your ability to consent.
Right. And in this case, I don't think it sounded like anything she said indicated that it had.
Yeah, I mean, it's just such an interesting case. You know, Bob, one of the things defense counsel is talking about and has kind of tried to put out there is maybe she was a habitual drinker. And so because she was used to, her body was used to consuming large amounts of alcohol, maybe that is why she was able to present so clearly with, even though having the high BAC.
Yeah, look, I just don't know how the case is going to shake out, but that's a great point. People can have a high level of tolerance. Their enzymes are burning alcohol off at their liver at a very, very quick rate. And yet they can wake up the next day and have no memory of really what happened, or a distorted memory. That is your classic blackout. So maybe that's where they're going. A lot of times you can present an expert. You'd have to put a person on to say, this is the level of capability of drinking, and this is what the consequence could be. And the defense is arguing down the road. Of course, they're saying there was no sex at all, but they're basically saying she really doesn't have a memory of what really did occur. And I have to be honest with you guys. I've had cases where this has been said and it was wrong, and cases where it's been said and it turned out to be true, that the victim had a sense of something but later admitted, I really don't remember what happened.
Yeah, this case is so interesting. So let me ask you about this. When you were a prosecutor specifically, when you have a case like this where you have the story of the alleged victim, and it is consistently told, it's what she told the police, it's what she says in court. She had this 4-hour exam, which I would suggest is not comfortable for anyone to go through. She does all these things, but you don't have the forensic physical evidence to say it was clearly this defendant who did this to her. How do you assess that as a prosecutor?
Okay, well, listen, every prosecutor wants objective corroborating evidence in any sex crimes case. This is one of the biggest issues that you deal with as a prosecutor. You want to either get a statement, a confession, physical evidence, DNA, electronic records. But if you don't have all that, in fact, we have a mutual friend, Judge, that tried a case just before COVID where there was none of that. And the prosecutor's argument was, look, I just believe her, and I believe the jury will believe her. And a lot of people are shocked at that. You mean to tell me it just could be he said, she said? Absolutely. And if the jury believes that person beyond a reasonable doubt, you could be convicted of it. In that particular case, the jury did not believe it, and the person was found not guilty. So as a prosecutor, you've got to be, at least for me personally, I was always giving the benefit of the doubt. I know people may get flustered at this, to the defendant, to ensure that I never made a mistake in a case and prosecuted and convicted somebody who may in fact have been innocent. I don't like the idea I don't have corroborating evidence in a rape case.
Yeah, I mean, this one, it's he said, she said, and also the roommate being there, and the defense counsel has brought up no indication that he was jumping up and saying, oh, wait, hold on, what's going on here?
Yeah.
So, I don't know. We'll continue to follow it. Bob, thank you so much. Appreciate your insight. And coming up, we're going to have a new witness. That witness is going to take the stand in the firefighter rape trial we have been watching. Plus, Court TV's Matt Johnson, he's going to join us live next for a preview of our newest live trial for defendant Dustin Duran. And that's starting Monday. Stay tuned for that.
we go back to court in Boston, we want to turn to New Hampshire, where a new trial starts next week.
This is called the Amber Alert murder trial of Dustin Duren, and he's accused of shooting his girlfriend to death and then running off with their 2 children.
As we gear up for that trial to begin next week, let's take a closer look at the details of this case. 38-year-old Dustin Duren is charged with murder in the death of 31-year-old Caitlin Knopfziger, the mother of his children. Prosecutors say that on February 29th of 2024, Duren shot Knopfziger and took their 2 young daughters. Knopfziger's body was found in an apartment, and an Amber Alert was issued for the 2 children. Someone recognized Duren's car described in the Amber Alert and called 911. WMUR spoke to the Good Samaritans.
I was like, oh, white Subaru. I'm like, oh, vet plates. And I was like, Mom, that's the guy.
I did videotape him being put in cuffs, and you can slightly see them taking the children out of the car.
Duren was pulled over and arrested. The children were in his car and were not harmed. Before his arrest, Duren had a YouTube page that is still up. He described himself as a gamer and a veteran, and posted videos playing the guitar. Duren claims he shot Knopfziger in self-defense to protect their children. He says she was about to kidnap them. Knopfziger died of a single gunshot wound to the head, and her family describes her as a loving mother whose spirit lives on in her 2 girls.
Let's go ahead and bring in Court TV crime and justice correspondent Matt Johnson. Hi there, Matt. What are we expecting in the opening statements?
Kelly, Judge Ashley, nice to see you both. So we can expect some powerful opening statements on Monday that will remind this jury of how it all started with a frantic search for those children in an Amber Alert. Prosecutors expected to focus on the breakdown of the relationship between these 2, Caitlin and the defendant, accusing him of planning of killing her with a single shot to her head and then fleeing with their children, triggering that statewide Amber Alert. His defense, however, is expected to say that he shot Caitlin in self-defense to protect their children because he thought that she was going to kidnap them, which indicates that we might see the defense put on a case in this and possibly call this defendant to the stand.
Tell us about the charges that Duren is actually facing, Matt.
Right, so he has been in custody since his arrest, and he's 38 years old, facing a number of charges, including first-degree murder, second-degree murder, reckless conduct, and endangering the welfare of the children. The trial starts on Monday with those opening statements. He faces up to life in prison without the possibility of parole if he's convicted.
Matt, thank you so much for that update, and can't wait for that trial to begin. Okay, well, before we go back into court, we want to remind you the deliberations clock, you may have noticed, it has stopped. This is in the murder trial against Parise Larry Jr. So an hour and 23 minutes. The jury is currently viewing exhibits of the crime scene and will bring you the verdict as soon as it happens.
Now we want to head back to Massachusetts, though, for the Irish firefighter rape trial for Terrence Crosby. On the stand now is a detective with the Boston Police Department. Direct examination by the state or the Commonwealth. Let's go back in.
The testimony you shall give to this court during the issue now, pending between the Commonwealth and the defendant shall be the truth, the whole truth, and nothing but the truth. So,
Thank you.
You may be seated.
He's one of the steps on the way. Thank you.
Ready, counsel?
Thank you. Good afternoon.
Good afternoon.
Could you please state your first and last name and spell both for the record?
Sure. My first name's Joseph, last name McDonough, Joseph, last name McDonough.
How are you employed?
By the Boston Police Department.
How long have you worked for the Boston Police Department?
I joined the Academy December 2010.
And what assignments have you held within the department since you became a police officer?
So when I first graduated, I worked in District B2, then I worked in A7, which is East Boston. Then I worked in West Roxbury, and then I went back to B2 until about 2021.
For police purposes, do you divide up the neighborhoods of Boston by like an alphanumeric code?
Yes.
And what is B2, which you referenced?
Sure. So B2 is Roxbury, some parts of Dorchester. A7, again, is East Boston, and then E5 is West Roxbury.
What is your current assignment?
I'm assigned to the sexual assault unit.
How long have you been assigned as a detective there?
I believe it was either late February or early March 2022.
As a detective in the sexual assault unit, what are your responsibilities?
Sure. To respond to incidents of rape, indecent, we talk to witnesses, we speak with victims of sexual assault as well.
Is the sexual assault unit a citywide unit, or is it specific to a certain neighborhood?
A citywide.
So if you have to go out to do an interview of a witness or do other work on a case, do you do that on your own or with a partner?
To gather video, something that can be done by myself, but usually talking with witnesses and victims, suspects, we usually do that together.
Is your partner another detective in the sexual assault unit?
Yes, we have another detective, but we also have a detective supervisor as well.
Where is that unit located?
989 Commonwealth Avenue in Boston.
Is there a name for that building?
Yes, it's the Family Justice Center.
On Friday, March 15th of 2024, who was your partner within the sexual assault unit at that time?
So that day, it was Sergeant Detective Dana Barrett.
So what did you do after learning that?
We responded. I think it was sometime just after 9 o'clock that we arrived at the hospital.
Where did you go within the hospital?
We went to the emergency room.
Where was she within the emergency department at that point?
She was in a private, single occupancy room within the ER department.
Were other members of the Boston Police Department already present?
Yes, there was a uniformed officer at the time, Roxana Kazub, that was also there prior to me getting there.
What was she doing when you arrived?
She took the initial report for the sexual assault.
And is it standard practice within the department for a patrol officer to handle the initial response, but notify the sexual assault unit if they learn that there's a reported sexual assault?
Yes.
So is it the patrol officer who's doing an interview, or do they notify a sexual assault unit detective to respond for that purpose?
So at first they would gather details confirming that it was a sexual assault, and they would alert us to then respond and speak to the person further.
So they gather enough information to know what kind of detective to summons?
Yes.
Who was present for that conversation?
Again, myself and Sergeant Detective Dana Barrett.
Do you know how long you spoke with her for?
I believe it was 22 minutes.
And are you able to tell because the interview was recorded?
Yes.
And have you reviewed a copy of that recording?
Yes.
What was your purpose that day?
To gather further information to, again, further the investigation to attempt to identify this person who sexually assaulted her.
When you arrived around 9 a.m., did the fact that she was still in the midst of getting medical treatment impact the length of your questioning?
Yes.
Did you anticipate being able to speak with her again later?
Yes.
What was her demeanor like when you spoke with her?
So she was sad, crying, and during portions of the interview there were brief pauses during the interview.
Did you ask her some questions about what had happened?
Yes.
Did you have any trouble understanding her answers to your questions?
No.
Did her answers appropriately correspond to the questions that you asked?
Yes.
While you were speaking, did you take any photographs of her cell phone?
Yes.
For what purpose?
To memorialize the communications between her and another person.
We're going to slip in a quick break. Stay with us for more of the Irish firefighter rape trial up next.
Tonight on Closing Arguments, Family Matters star Darius McCrary makes a bizarre court appearance facing felony charges. We'll dive deeper as our experts weigh in.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Donna Edelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
Welcome back. Now we're going to go back to day 2 of testimony in the Irish firefighter rape trial that's taking place in Boston, Massachusetts.
Terrence Crosby is standing trial for a second time on charges that he raped a woman in a Boston hotel. His first trial ended in a mistrial.
And as a reminder, we are not airing the name of the accuser, so you may from time to time hear the audio drop, and that's when her name is mentioned in court. So let's go back in for more testimony from Boston Police Detective Joseph McDonough.
I'm going to put Exhibit 7 on the screen. Do you see the notation at the top of the text messages regarding the time?
Yes, 2:18 a.m.
Was that timestamp relevant to your investigation?
Yes.
How so?
It was believed that after the incident took place, she had then texted Daniel Jacobson, so we believe that that she left the hotel then.
And do detectives typically have a role in gathering evidence collection kits from the hospital once they're complete?
Yes.
In general, what happens to an evidence collection kit once a police officer picks it up?
Sure. We're notified whether it's a reported kit, and in this case it was reported, and then sometimes we pick up unreported kits, and essentially we take custody of it, and it is brought back to the Family Justice Center. We enter it into our Mark 43 report writing system, and it's given an evidence label. It has a correspondent CC number that's unique to each report. And then if it's unreported, it gets stored at the lab. If it's reported, then it's examined by the Boston Police Crime Lab.
And when you say unreported, are you referring to cases where someone goes to the hospital and has an evidence collection kit done but opts not to speak to the police?
That's correct.
In this case, did you pick up the kit while you were at the hospital that morning?
Yes.
Do you know what time you picked it up?
I think it was right after we concluded the interview.
And do you know if that's documented anywhere on the kit itself, the timing of when you picked it up?
Yes.
Where is it typically documented?
Usually on the face of the box, so it comes in a white cardboard box, and then it's secured by the nurse or the doctor, whoever performed that procedure, and then they usually write the time on there.
The time of when you picked it up.
And then when I pick it up, I write my name, the time, and I essentially sign for it.
Did you later submit that kit, the kit in this case, to the Boston Police Department Crime Laboratory for testing?
Yes.
Was she able to give you the name of the man who she had consensual sex with?
No.
Did the next steps in your investigation involve trying to identify who those men were?
Yes.
Why did you go to the Omni Parker house?
We learned that that was the location of where the sexual assault happened.
Where's the Omni Parker house located?
60 School Street. It's on the corner of Tremont Street and School Street. In Boston, I'm sorry.
And are you aware, or were you aware at the time, if the Omni Parker house had cameras inside?
At that time, no, but we responded to confirm, and they did.
In general, do you know where the cameras are located within the hotel?
Yes, it's in the common areas. I believe there's several in the lobby, the entrances on School Street, but also on individual floors.
What did you do once you got to the Omni Parker house that day?
We spoke with security there and an attempt to look at video from hours before.
Where did you go in order to do that? Where within the hotel?
Yeah, so the security area is on that lower level of the hotel. I actually met somebody in the lobby, and they were able to bring me down there, and we went into the security booth, and we were able to review video based on our timeline.
Within the security booth, are there screens where you can review video that's been recorded from within the hotel?
Yeah, I think it was just a computer screen. There wasn't any like TVs or anything.
Okay.
All right, we're going to break here for lunch.
A break there in court, so let's go ahead and bring in defense attorney and former head prosecutor Bob Bianchi. Bob, listening to Detective McDonough on the stand, so his role in all this was to identify the person who allegedly assaulted the accuser. So he's kind of going through the process, talking about looking at surveillance video, because the accuser, couldn't ID the person.
Yeah, so I mean, it's another problem in the case, right? So there's not going to be much dispute in my mind, and I don't think they're disputing that he was there. So presence, of course, mere presence at the scene of a crime is not indicia of guilt, and that's what the defense is arguing in the case. But that's going to be a strong fact for prosecutors that, in fact, the person doesn't have an alibi that they were someplace far away, but was, in fact, in that close proximity. So what are they doing there, and why is it? I mean, this is the argument of prosecutors, that she would decide to come forward and say, I had consensual sex with one person, but not another. So, I mean, again, it's not a perfect case. And as a prosecutor, I would need to be, and I've tried a lot of cases as a prosecutor where the facts were weak, but I genuinely believed in the guilt of the defendant, and I proceeded and secured convictions. I would hope that that's what the prosecutor's doing here, and they're going to have rough spots and rough patches throughout all of this, but at the end of the day, the jury could find her credible and convict this defendant.
In about the last 10 seconds, last time it was a mistrial. If there were a mistrial this time, if you were the prosecutor, would you try it a third time or not?
No, I wouldn't. If it's a credibility issue at this point in time, if two juries are hung and can't come to a conclusion, I would use my relationship with the victim to say, listen, we did the best we could. It's better just to move on. That would be my opinion.
Okay. Thank you, Bob, for joining us today.
Bob, thank you. Coming up, more of the Irish firefighter rape trial against Terrence Crosby. Stay tuned. And welcome back to Court TV Live. I'm Kelly Craft, in tonight from Michael Ayala.
And I'm Judge Ashley Wilcott. Thank you for being with us. We will get you back to court in just a moment. But first, we are in verdict watch in the caught in crossfire murder trial of 16-year-old Paris Larry in Wisconsin. You can see the clock is up. The jury has been deliberating for approximately 1 hour and 43 minutes.
Less than an hour ago, the jury did ask to see some pictures of that crime scene, including the bullet strikes, as well as a chart of evidence referenced during closing arguments. The judge did grant that request. So Larry, he faces life in prison if he is convicted of shooting and killing Tatiana Zek. This was back in May of 2023. She was outside, they had a cookout, and she was just taking out the trash. Larry was 14 at the time, and he is one of 2 people charged in this case.
That's right. His co-defendant, Antonia Johnston, pleaded guilty back in January, and he is scheduled to be sentenced at a later date. He also testified against the defendant.
Larry unexpectedly took the stand yesterday in his own defense after previously telling the judge that he was not going to testify. Larry told the jury that he fired his gun because he was in fear for his life. We will continue to monitor deliberations and bring you the verdict when it does happen.
And now we want to take you back to Massachusetts for day 2 of testimony in the Irish firefighter rape trial. Terrence Crosby, who's a firefighter from Ireland, is accused of raping a woman at a Boston hotel in March of last year. Crosby shared a room at the hotel with a friend.
And that friend and the accuser met at a nearby restaurant and then returned to the hotel to have consensual sex. The alleged victim told police that she got into the other bed, fell asleep, and then she was awoken by the defendant raping her. She testified for a second day today, and she was walking the jury through the details of what exactly took place that night.
And right now, there's a detective on the stand. He is with the Boston Police Department testifying about the case. Now, we are under court order not to show the accuser or mention her name, so at times you will hear the audio drop when her name is said. Let's go back in.
All right, Detective McDonough, before we continue with the questions that I had for you about going to the Omni Parker house, I want to go back just briefly to your meeting with at the hospital on March 15th,
Yes.
2024. Did you write a report regarding the statements that Ms. made to you with the report dated March 17th, 2024?
Yes.
Did it summarize the information that you had received from her to that point?
Yes.
Understanding that there was a separate recording of a statement at the hospital?
Yes.
At the hospital on March 15th, did Mr. inform you and Sergeant Detective Dana Barrett that she had gone to sleep in the other bed of the hotel room other than the one that she and Liam had consensual sex in?
Yes.
And did she also tell you on March 15th that she had done so because Liam was in a starfish position on the bed?
Yes.
And did she also tell you that when she had gone to sleep in that other bed in the hotel room that she was under the covers?
That's correct.
So when you went to the Omni Parker house on, this would be the 15th, correct, after leaving the hospital?
Yes.
You said that you went to the security booth and you were reviewing video. What were you looking for in the video?
For leaving the Omni Park hotel.
And what time frame were you working off of?
The communication with Daniel Jacobson, so from 2:18, maybe 2:17 a.m.
So by using that timestamp, you used that as a kind of time frame to go back and look for video of her departure?
Yes.
And how is it that you were able to view the video in the security area?
With consent, I guess they just allowed me to look at the footage that I requested.
And were you eventually able to locate and view video that showed leaving the hotel?
Yes.
And were you also able to locate and view video that showed her in different areas of the hotel during the relevant time period?
Yes.
And did that include arriving at the hotel?
Yes.
And going to the 6th floor?
Yes.
And leaving the 6th floor?
That's correct.
And were you able later on to obtain copies of that video directly from the Omni Parker house?
Yes.
The video of Ms. arriving at the Omni Parker house, did it document the time that she arrived?
Yes.
And what was that time?
That she arrived was approximately 11:53 p.m. on the 14th.
And did she arrive alone?
She arrived with another male.
And did the video show that other male who she arrived with?
Yes.
And did you later identify that person as Liam O'Brien?
Yes.
Were you also, well, you said that you were able to locate video of Mr. leaving the hotel?
Yes.
Do you know what time that video was from?
I believe it was either 2:15 or 2:16 on the 15th.
Have you viewed those videos since that day?
Yes.
All right, do you see the list of files on the screen in front of you?
Yes.
And do you recognize what those are?
Yes.
Just from the titles that you see. What are they?
They're different camera angles within the Omni Parker Hotel.
And do they cover the time period when Ms. was in the hotel on March 14th into the 15th, 2024?
Yes.
And do they represent what was provided to you by the Omni Parker House in connection with this investigation?
Yes.
Was there anyone in this video who you took notice of as you were reviewing it at the Omni Parker House?
Yes. Both Liam O'Brien and Ms.
As you were looking for video of, were you, how did you know who to look for? Were there any, I'll leave it at that. How did you know who to look for?
Based on the description, and she also gave us her description in the interview.
Her description of the person who she had gone back to the hotel with, you mean?
Yes, but also including her clothing.
I see. And also from meeting with Ms. at the hospital, you knew what she looked like, right?
Yes.
What part of the hotel is this that we're looking at?
This is the School Street entrance. Yeah, it's the School Street entrance.
Was there also a video of their arrival from other camera angles inside of the hotel?
Yes.
Is this just inside the door to the hotel that we saw in the last video?
Yes.
And what is the timestamp there?
This is 11:52.
And just to orient the jury to where this camera angle is, where is this?
So walking through the revolving door, there's a set of stairs. This is the set of stairs going into the lobby of the Omni Parker Hotel.
Okay. And what is the timestamp here?
Right now it's 11:51.
Okay. Were you able to determine what floor and Liam O'Brien had gone to after they entered the hotel there at 11:52 p.m.?
Yes.
What floor?
The 6th floor.
And did you locate video showing their arrival on the 6th floor?
Yes.
Are you able to tell from the video where and Liam O'Brien are coming out of?
Yes.
And where are they coming from?
That's the elevator.
Did you also locate video that documented Mr. departure from the 6th floor approximately 2.5 hours after her arrival?
Yes.
And did you locate video of her actually exiting the hotel through the School Street door?
Yes.
And again, that set of stairs leads to the exit of the hotel, is that correct?
Yes.
What was the significance of those videos, particularly the ones from the 6th floor, to your investigation?
It led me to believe that both Liam and went to hotel rooms block 602 to 620 within that floor.
Was that based on the direction that they walked toward on the video?
Yes, so they took a left at that sign at the end of the hallway. There's a sign that directs people to go which way for which rooms, and they turned left. And again, that's for rooms 602 to 620.
Did you then take any steps to try to narrow down which specific room that they went to?
Yes. After learning that they went to rooms 602 to 620, I spoke to the hotel and I was able to obtain a room ledger for those for all rooms between 602 to 620, and I understood that there was 2 rooms that had 2 occupants.
And did you focus on the 2 rooms that had 2 registered occupants?
Yes.
What were those 2 rooms?
It was room 620 and then 610.
Did you get the names of, or I'm sorry, you said that there was a ledger that you received for all of the rooms 602 to 620. Did that ledger contain the names of the registered guests?
It did.
What were the names of the guests in room 610?
It's Terrence Crosby and then Liam O'Brien.
And what about 620?
One was the last name McElroy and the other one was O'Toole. I apologize, I don't remember their first names.
But you got their first names at the time?
Yes.
And what did you do once you had the names of the guests in room 610 and 620?
So I spoke with somebody from our Boston Regional Intelligence Center who was able to put me in contact with somebody from HSI, and I provided some names from that ledger to that person, and they were able to send me an email with 4 passengers contained within that email.
And that was specifically for the occupants of rooms 610 and 620?
Yes.
Is that correct?
We need to take a break here. The detective continues his testimony about video that paints a timeline of when the accuser and the friend of the defendant were inside the hotel.
Also, the attorneys for accused assassin Luigi Mangione call for the indictment against him to be dismissed. But that's not all they want. And find out why they are calling out President Trump regarding the case. Keep it here on your front row seat to justice.
I'm going to ask you a lot of intensely personal questions. How do you explain it? The worst crime anyone can imagine. Do you feel like you took the fall for this murder? Tell me in your own words, what happened? Let's get started.
Interview with a Killer. New season premieres Saturday, October 25th. Only on Court TV.
Before we get you back to court, here are a few other cases that Court TV is tracking. In New York, lawyers for Luigi Mangione have asked a federal judge to either dismiss the indictment or take the death penalty off the table. His defense team has also said the Trump administration is making Luigi Mangione a pawn to further its political agenda.
And in Kentucky, Joshua Gross, the stepfather charged in the death of 10-year-old Jaden Spicer, has filed a motion to lower his $1 million bond. Gross is facing multiple charges and will be back in court next Friday.
In New Hampshire, trial begins Monday in the Amber Alert murder trial. Dustin Duran is accused in the 2024 shooting death of his girlfriend, Caitlin, then running off with their 2 children, triggering an Amber Alert.
And in Florida, jury selection begins for a woman accused of killing rising rap star Julio Fulio as part of an ongoing gang war. To get you caught up on the case against Alicia Andrews, here's Court TV field reporter Cody Thomas with more.
26-year-old Charles Jones, better known by his stage name Julio Fulio, was a rapper from Jacksonville, Florida.
Girl, you crazy, pay for that abortion. Triple cross, go against the gang, then it's straight extortion.
Jones was in Tampa, Florida in June of 2024 celebrating his birthday, posting his location on social media several times. In the early hours of June 23rd, police responded to a shooting at a Tampa hotel where Jones was pronounced dead.
At 4:15 in the morning, Jones began to head to a hotel on McKinley. One of the suspect vehicles is seen following the victim. However, instead of following them into a parking lot, they stage across the street. At 4:38, 3 shooters exit a vehicle and walked in the direction of the hotel. They murdered Jones with a handgun and 2 rifles.
Investigators have now apprehended 5 suspects. The most recent one, Davion Murphy, was captured in January. Law enforcement released this smiling image of him from the arrest. Investigators also say the suspected shooters are affiliated with gangs that are rivals to Jones's gang in an ongoing feud.
These individuals took extreme measures to try to cover their actions, but they were no match for our investigators.
All 5 suspects who are in custody face first-degree murder and conspiracy charges, with 22-year-old Alicia Andrews as the first one on trial.
Again, jury selection gets underway on Monday, and our Court TV cameras will be there to bring you the trial when opening statements and testimony begin.
We want to get you back now to more testimony in the Irish firefighter rape trial that's taking place in Massachusetts. A detective with the Boston Police Department is still on the stand. And reminder that if you do hear the audio drop out, it's because we are not allowed to mention the accuser's name.
I'm handing you a 3-page document. Do you recognize what it is?
Yes.
What do you recognize it to be?
This is the email I received in response to that phone call with HSI.
Move to admit this as the next exhibit, Your Honor.
Any objection? No objection. All right, that will be marked. Where is the email from? It's usually an acronym.
I'm sorry, what is HSI?
It's Homeland Security Investigations.
Thank you. Okay, so showing you what was just marked Exhibit 12, the first page. Is this one of the occupants, or the registered occupants of room 620?
Yes.
And the name is above the photo in this email, is that correct, for each of the 4 photos?
Yes.
And I'm sorry, it begins on the bottom of the first page, but continues on. The second name listed is Terrence Crosby, is that correct?
Yes.
And on page 2, do you see photos of who you later learned to be Terrence Crosby at the top of the page?
Yes.
And beneath that, do you see photos for Liam O'Brien?
Yes.
And at the bottom of page 2, Peter McElroy, was he another registered guest of room 620?
Yes.
And are the photos of him on the third page of this email?
Yes.
For each of these individuals, did it show that they all arrived on March 14th from Ireland?
Yes.
Do you know when you received those photos and that information?
From that email?
Yes.
That was on March 15th.
So the same day that you spoke with
Yes.
initially at the hospital?
Yeah, I think it was a little later. I think it was somewhere around 2 p.m., something like that.
And so did receiving those photos help you to narrow your focus on a particular person as you work to identify who had gone back to the hotel with?
Yes.
How so?
Well, so the Liam O'Brien appeared to be the same person in the video going back to the hotel room with.
And so as a result of that, did that help to narrow your focus on a single hotel room within room block 602 to 620?
Yes. It helped me focus on room 610.
Joining us this hour to discuss is criminal defense attorney and former assistant prosecutor Franz Borgart. Franz, thank you so much for joining us both. I haven't yet gotten your opinion on this case. As the evidence unfolds, we know there was a mistrial the first time. We know the victim has now testified, alleged victim, and she'd given the police a statement. She participated in the sane rape kit. She did all of these things, yet there's no forensic evidence in this case that says it's the defendant that raped her as she alleges. How difficult does that make the case for the prosecution?
Well, Judge, you just made a good defense closing argument to how this could be reasonable doubt. All these accusations and no forensic evidence doesn't mean she's lying, because she could be absolutely telling the truth. But you would expect, this is what they're going to argue, Judge, that you would expect some kind of physical forensic evidence. And in the absence of that, how can you know beyond a reasonable doubt that she was in fact raped? Now, it's different if the defense is consent. That's a different issue. But in the absence of forensic evidence, it becomes the true he said, she said. Now, let me be clear. You can get convicted on an allegation alone without the forensic evidence. It's just in 2025, jurors typically expect to see some kind of physical forensic evidence. That evidence is not only what is alleged, but what she is testifying to.
Yeah, that's a good point.
And Franz, this is a retrial, and after that first trial, the prosecutor did decide to try this case again. And one of the things when I was doing some research on the case that was said after the mistrial was this perception of women. And you have a victim who met some guy out at the bar, went home with him, and had consensual sex with him. And so you have this situation where some people might be looking upon that and saying, well, you know what? Maybe she got herself in this bad situation. We don't know what happened. Then there's no DNA pointing to this guy. So we don't really know what happened here.
So that is an argument. However, the world we're living in now, most of us believe that consent can be withheld at any point. You can change your mind. You can say no. And look, just by associating with somebody, just by hanging out with somebody, just by going on a date with somebody, doesn't mean that consent was freely and voluntarily given. So, that may be in the back of jurors' minds, Kelly, but I think it's one of those tricky things that you don't want to argue that as a defense attorney, because it makes you kind of tone deaf in the modern world.
So I was looking at live stream chat when we were showing this trial. We are all day today live. And in that chat, one of the things that a lot of people raised in this case was the fact that I lost my train of thought. Franz, I do this by the end of a Friday. It's been a long week. But here's where I was going with that, is that the defendant in this case fled. from our perspective, right? He's from Ireland, though. He took an earlier flight right after he talked to the detectives. And I think here we'd say, well, he obviously knew that he did something wrong. He was taking off early. On the other hand, you think he's from another country. Detectives questioned him. Maybe he was smart to say, nope, I'm going back home. Does it mean anything to you?
Well, both sides are going to make an argument that either one, it wasn't flight, or two, it absolutely was flight. And this is, and guys, I don't know that this is flight with a capital F in the sense that it really shows guilty conscience as much as manner of life. This is just, I mean, an earlier flight doesn't necessarily mean anything nefarious. I mean, by extension, he had a flight. So, and if he's not being told to stay, if he's not being told, hey, don't leave the country, if he's not being told you're not free to go, then frankly, I don't know if this moves the football past the finish line. It is a fact, but it's an arguably defensible fact at that.
I believe his flight was scheduled for several days later, but Franz, with what you were saying, yes, he was told, according to the articles and the research, he was told that he was free to leave. So he's finding himself in a situation. He wants to get back home to his wife and family there. And so he's like, let me get on this earlier flight.
Yeah, I think it's very believable either way.
Either way. Franz, thank you so much. We're going to step aside. And on the other side of the break, the detective is going to continue the testimony about this case. So keep it here on Court TV, your front row seat to justice.
Welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Kelly Craft, in tonight from Michael Ayala. Thank you for being with us. We are getting you back to our coverage of the Irish firefighter rape trial of Terrence Crosby. It's taking place in Massachusetts, and this is the second time that he is being tried for allegedly raping a woman at a Boston hotel last year.
Crosby's first trial was held back in June, and that trial ended in a mistrial. The alleged victim claims that Crosby raped her in his hotel room, which he shared with a roommate. And according to police reports, the accuser said she went to the hotel with the roommate and that she had consensual sex with the roommate, but that after falling asleep, she claims she awoke to the defendant Crosby raping her.
We'll pick it back up with testimony from a detective with the Boston Police Department. And a reminder, we are under a court order not to mention the accuser's name, so audio will be dropped if that happens.
Is that because Liam O'Brien was the registered guest in room 610?
Yes.
Do you know if he was the only registered guest in that room?
He was not.
Who else was that room registered to?
Terrence Crosby.
While you were at the Omni Parker house that day, did you also receive any information related to door activity for rooms 602 to 620?
Yes. Now focusing on room 610, we were able to get room lock interrogation activity for room 610, and it does show activity during that time when Liam O'Brien as well as Mr. Crosby arrived, and activity after leaving.
And did you, how did you initially see that information at the Omni Parker house that day?
So it was brought up on a computer. Again, I think they had to manually either export or retrieve that from the actual door, but we were able to get it from security, and they showed me a screenshot of just room 610 for those few hours, and they were able to confirm that there was some activity within that room.
And did you take a photo of that?
I did.
Show me the photo. What do you recognize it to be?
This is the screenshot. I'm sorry, this is the photo that I took from the security at the Omni Parker Hotel. That shows the door interrogation logs activity.
And based on that information, did that inform next steps in your investigation?
Yes.
I need to introduce that as the next exhibit, Your Honor.
Any objection? There is an objection, Your Honor. All right. Why don't we mark it for identification? We'll mark it later.
Okay.
So, jurors, this is marked for identification. It has a letter, which means it's not a fully admitted exhibit yet.
Did you learn whether there was door activity during the relevant time frame for any of the other rooms in room block 602 to 620?
There was not.
While you were at the Omni Parker house that day, were you able to review any other lock interrogation records, or was that is what's in that photo all that you were able to see that day?
So on March 15th, that was all I was able to view, but we had received confirmation that there was no other activity in any other room.
Okay. So in general, what are lock interrogation records?
So it, from my understanding, it is what registers activity from the door, whether a key card was used, whether the deadbolt was used, whether the door was opened from the inside. and what specific key card was used.
So is it fair to say that based on your review of the video evidence at that point, that the time frame that you were looking at was 11:52 p.m. until 2:16 a.m.?
Yes.
And does that represent the time frame when it was inside the hotel?
Yes.
Before we take a break, we are continuing to monitor that clock as the jury continues deliberations in the caught in the crossfire murder trial of 16-year-old Paris Larry that's taking place in Wisconsin. The jury has been at it for about 2 hours and 21 minutes.
And just minutes ago, the jury asked the judge for clarification on count 13. Now, this count is related to bodily harm to another victim in the case, Emmanuel Santos.
So on the verdict form, the count says injury by negligent use. So after discussing with the attorneys, the judge did decide to rewrite the charge in neater handwriting and then send it back to the jury.
Larry faces life in prison if convicted of shooting and killing Tatiana Zek back in May of 2023 as she was taking out the trash. Larry was 14 years old at the time. Of course, Court TV will continue to monitor deliberations and bring you the verdict when it happens. Right now, we need to take a break. When we return, we will get you back to more testimony in the Irish firefighter rape trial in Massachusetts. Keep it here on Court TV Live.
Tonight on Closing Arguments, Family Matters star Darius McCrary makes a bizarre court appearance facing felony charges. We'll dive deeper as our experts weigh in.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Donald Edelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rowlands, season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
Welcome back to Court TV Live. Let's get you right back to testimony in the Irish firefighter rape trial in Massachusetts. A detective with the Boston Police Department is still on the stand.
And just a reminder, we are not allowed to mention the victim's name, so if you hear the audio drop, that is why.
Did you receive a copy of the lock interrogation records from the Omni Parker house for each of the rooms in room block 602 to 620?
Yes.
And did you also receive a copy of the booking information for rooms 610 and 620?
Yes.
And did the booking information include information about who the registered guests were in each of those two rooms?
Yes.
And did it include information about the length of stay and when guests had checked out and that sort of booking information?
It does, yes.
I'm going to show you some files, and I'm going to ask that they be marked for identification. Do you see the file folders listed there?
Yes.
And what do you recognize them to be?
One file is it's details of the rooms that's labeled folios. That again has the details of who was occupying that room as well as the length of this day, and then the lock interrogations is actually the activity on each room.
All right. I'd ask that this USB be marked for identification. After you gathered that information at the Omni Parker house, relative to room 610 being the only door in that, or the only room in that room block that had door activity during the relevant time frame, did you go anywhere else?
Yes. Knowing that, again, that I went to the Black Rose. That's where we went next to get video as well.
Did you meet with anyone at the Black Rose who was able to assist you with getting video?
Yes.
Who did you meet with?
I met with Sheldon Cohen.
Who is Sheldon Cohen?
He is one of the managers there, and from my understanding, he does all the videos for that company. I believe they own several bars and establishments within that area.
Can you describe your meeting with him from that day?
We were able to view the activities within the Black Rose. We were able to view it, but then we were also able to get that video from Sheldon Cohen a little later that evening.
Later that evening, did he provide the videos on a USB to another detective within the sexual assault unit?
Yes, I believe it was either 8 or 9 o'clock that night we were able to gather that video.
Let me show you something that was previously marked as Exhibit 2. All right, so by looking at the file names, are you able to recognize these to be the Black Rose videos that Mr. Cohen provided to the Boston Police Department that day?
Yes.
And I'm going to ask you a couple of questions about the camera angles within the bar within the Black Rose. Is it your understanding that essentially the entire public area of the restaurant is covered by the camera angles that are included here?
Yes.
And so the cameras that cover the interior of the Black Rose are named D03, D04, D06, D10, and D16. Is that correct?
Yes.
And they're all internal cameras, right? There aren't. There's no video from the outside of the Black Rose.
That's correct.
Did you review the video from the Black Rose the day that you received it?
Yes.
And again, that was that same day, that March 15th, that
Yes.
Friday?
Yes.
Did you see video of the Black Rose?
Yes.
And did you notice anyone in particular who she appeared to be interacting with in those videos?
Yeah, there were, yes.
And based on the evidence that you had reviewed thus far, who did you believe that person to be?
That person was believed to be Liam O'Brien.
Okay, I'm going to play some video from the Black Rose. I'm going to ask you some questions. Sorry for the delay. So playing camera angle D06 from the Black Rose. Where did you identify in this video?
She's at that first table, just to the, I guess the first brown-colored table.
Okay, I'm going to pause it. If you could circle where you see her.
Sorry, it's not.
That's okay. Your screen might not be as forgiving as mine.
Yes.
Is that who you identified as from the video?
Yes.
Okay. And is it what is the time frame for most, if not all, of these videos?
I believe I asked for times period between 10 and 12 a.m. going into the 15th.
Okay. Do you understand that some of these videos were pared down from the original to end after the departure of any relevant parties from the Black Rose?
Yes.
So do some of the videos end at somewhere closer to 11:30 or 11:40?
Yes.
You said that you in these videos saw her interacting with a particular man, with who you identified as Liam O'Brien. Is that right?
Yes.
And were you able to see video of them dancing and interacting throughout the night?
Yes.
All right, we have some breaking news. 2 hours, 33 minutes. We have a verdict in the case we have been watching out of Wisconsin. This is the Larry trial. So the jury has been at it for just a short time, Judge Ashley, but we'll soon find out what they decided.
Yeah, numerous charges, and I have to tell you, I feel like when they came back fairly recently and wanted a clearer instruction on an injury that happened to a victim, I felt like they must have already reached a verdict on the other charges. I don't know that. That was just my sense, and of course, we don't know what that verdict is, Kelly, but I do think 2 hours, 33 minutes after hearing the evidence and that sudden change of mind by the defendant to testify on his own behalf.
Yeah, he had initially told the judge that he was not going to testify, and so that was kind of a surprise to all of us when he decided to take the stand. Whether it's the right choice, who knows, but why don't we go ahead and bring in criminal defense attorney and former assistant prosecutor Franz Borger to discuss this case. This is the situation, Franz. The defendant at the time was 14 years old. He is now 16 years old. During his testimony, he said that he shot because he feared for his life. What do you think is going to happen here? What do you think the jurors are going to come back with?
This one's tough because we're supposed to take the accused, especially in a situation where he may or may not have been acting in self-defense, where he is in his life, what he saw, what he experienced, what he reasonably believed. And you know, a 14-year-old may have a reasonable belief of fear and harm that's different than, say, a 40-year-old. I also believe that it's harder to convict young people of these kind of crimes when you know that they were 14 at the time, by an adult standard, so to speak. So I'm looking for a compromise here. I'm suspecting it's going to be something less than the top. I don't know that he will be acquitted, but I can see a juror or jurors compromising. And by compromising, I specifically mean, Kelly, I specifically mean like saying, hey, I don't want to do the top, but maybe we should do something lesser. And that could happen in this one.
How much of a difference does it make that we don't know whose bullet actually killed the victim, because there were multiple shooters? We know one of the co-defendants did plead guilty, and he then testified against Paris Larry. How much does that weigh into the decision in your mind, Franz?
So, in the vacuum of a law school classroom, it may not matter. But to a juror who may say, well, wait a minute, how do we know it was this bullet? Mm-hmm. You could argue law of principles, Judge, but I don't know that that's going to be something that a jury hitches its horse to. I think that could be an issue. I just don't know that they're going to outright acquit him.
You know, Franz, when I take a look back at the notes from the case, I believe what he said on the stand when the prosecutor asked him, so shot 3 shots in the air, and the prosecutor asked him, well, so one of your shots could have been the one that killed Tatiana. And I believe he said yes, yes, yes.
Well, and that's the problem, right? That's the downside of him testifying, is he gets to articulate what he experienced, what he was feeling, the fear. The flip side is he also admitted to shooting a firearm, and he also testified that, hey, maybe he was the one who shot and killed Tatiana. That's problematic. It makes him to a certain degree, it makes him sympathetic. But I just don't, guys, I just don't think he crosses the acquittal finish line.
And what do you think about the fact that, oh shoot, I did it again, Franz. There was something I wanted to ask you about the particular defendant being 14 years old, hearing him testify in his own voice. I was surprised he changed his own mind, but he did testify. He was fearful, and I think that's the reason he wanted to get on the stand. But, you know, context, seeing them all day long together, hanging out. The prosecution showed all of this video. So let's do this. I think that we need to take a break here. I just wonder how much this context matters to a jury. Franz Borgard, I'm so sorry we're out of time. Thank you so much for being with us tonight, as always.
Ahead next hour, we're going to bring you that verdict in the Caught in the Crossfire murder trial. And we'll also get you back to court, where testimony wraps up in the Irish firefighter rape trial in Massachusetts. Keep it here on Court TV, your front row seat to justice.
be there too, with support you can count on every step of the way.
And welcome back to Court TV Live. I'm Kelly Craft, in tonight from Michael Ayala. We will get you back to court in just a moment, but first in Wisconsin, the jury has reached a verdict in the caught in the crossfire murder trial of Parise Larry. The jury deliberated for about 2.5 hours. We are on a 15-minute delay, so we will bring you that verdict as soon as we can. Now, Larry faces possible life in prison if he is convicted of killing 20-year-old Tatiana Zek. In New York, there are new filings in the case against accused assassin Luigi Mangione. That's another case we're following. His attorneys are asking a federal judge to either dismiss the indictment against him or take the death penalty off the table. Mangione is accused of shooting United Healthcare CEO Brian Thompson to death last December. Also in Kentucky, Joshua Gross, the stepfather charged in the death of 10-year-old Jaden Spicer, wants his $1 million bond lowered. He faces multiple charges, including complicity to murder, as well as tampering with evidence. Now, we want to take you back to Massachusetts. This is day 2 of testimony in the Irish firefighter rape trial. Terrence Crosby, who is a firefighter from Ireland, is accused of raping a woman at a Boston hotel. This took place, allegedly, in March of last year. Crosby shared a room at the hotel with a friend, and that friend and the accuser met at a nearby restaurant, and then they returned to the hotel to have consensual sex. The alleged victim told police that she got into the other bed, fell asleep, and then she was awoken by the defendant raping her. A detective with the Boston Police Department is now testifying about the case, and we are under a court order not to show the accuser or mention her name, so at times you may hear the audio drop.
I'm going to play a clip from camera angle D10, beginning at 22:31. I'm going to pause it here at the 10-second mark. Do you see the person who you were able to identify as Liam O'Brien?
Yes.
And understanding that your screen might have an issue, the person who I circled there, is that who you identified as Liam O'Brien?
Yes.
And as you saw the video from the Black Rose, did you compare his appearance to the 4 photos that you had received from that email from HSI?
Yes.
And did you also compare his appearance to the video that you reviewed while at the Omni Parker house?
Yes.
So after you reviewed all of the video, at this point now that you had the Black Rose video, did you believe the man that she had gone to the hotel with was Liam O'Brien?
Yes.
Is it correct that that's the Saturday after you, the next day after you met with her at the hospital?
Yes.
And what was the purpose of that meeting on March 16th?
I wanted her to ID Liam O'Brien and identify herself in the video as well.
How long was that meeting?
I believe it was 8 minutes.
And what was the purpose of that meeting? To be a full interview?
No.
You said you wanted to her to identify who you thought was Liam O'Brien?
Yes.
And so during that meeting, did you show her any photographs?
Yes.
What photo did you show her?
The only photo I had of Liam O'Brien, which came from, again, HSI.
What happened when you showed her that photo?
She was able to identify Liam O'Brien as the consensual partner.
Did you have her indicate that identification in any way?
Yes, I had her sign the photo and date, and I think she wrote the time as well.
All right, I'm showing you what was previously marked Exhibit 9. Is that the photo that you showed her along with her notation of her name and date and time?
Yes.
Did you show her anything else during that meeting?
I believe I showed her some video as well.
What video?
I believe from the Black Rose.
Why did you show her video from the Black Rose at that time?
To identify herself, and maybe if she identified anyone else in that video.
Did you locate any video that showed a person walking in the direction of room 610?
Yes.
All right, so just to orient us here, this is a video from the 6th floor from the exhibit containing Omni Hotel videos. Do you see what the timestamp is at the beginning of this video?
Yes, 11:50 p.m. on the 14th of March.
So the person who just came out of the elevator, is that the person who you identified as the person walking toward room 610 at 11:50 p.m.?
Yes.
I'm actually going to move ahead about 3 minutes in the video. But is it fair to say that no one else exits the elevator until 11:53 p.m.?
That's correct.
So we've moved ahead to 11:52:54 on the timestamp. And within this video, about a minute and a half later, do you see someone coming from the direction of room 610?
Yes.
Now, did the clothing worn by the person who just walked down the hall and sat in the chair, did that clothing become relevant to your investigation?
Yes.
How so?
Clothing is one way we are able to track, or I guess follow, individuals from different locations or from different camera angles.
And so did you notice anything about that person's clothing or shoes?
Yeah, so the shoes have a white sole with some white laces, but also that sweatshirt, I believe it has some writing on it as well.
In a later interview that you conducted with Terrence Crosby, did he identify himself as the person sitting in this chair in this video?
Yes.
All right, I'm going to continue playing the video from the 11:54:59 timestamp. All right, Detective McDonough. So that video ended at the 11:57 p.m. timestamp on March 14th. Did you continue reviewing video to track Terrence Crosby's whereabouts during that time frame?
Yes.
And so we just saw a video of him sitting in that chair, correct?
Yes.
And then did you see him doing anything else in the video at about 12:47 a.m.?
I believe he leaves that area and he's gone for some time, but then he returns and sits back in that chair.
In another case we're following, this one in Georgia, some disturbing developments where the parents of a 6-month-old baby are charged in his death. Police say Antonio Pierce is facing a slew of charges after his baby boy, Nakai's body, was found 3 days after being reported kidnapped on Sunday. Police say the baby's body was found wrapped in a trash bag with blunt force trauma to the head. A Clayton County detective says police never believed his story.
When officers arrived, they spoke with Antonio Pierce, who reported that he had been robbed at gunpoint and that as suspects fled, they took his 6-month-old child, Nakai Pratt, from his car seat and left in an unknown direction. As detectives began investigating, inconsistencies with Mr. Pierce's account quickly emerged. Based on evidence gathered, investigators determined that foul play was involved and identified Antonio Pierce as a suspect in the disappearance of his son.
What was it about his initial narrative of what happened to the baby that made you guys suspicious?
He had inconsistent statements. He was caught in a lot of lies throughout his interview process.
Police also charged the baby's mother, Nicolette Pratt, with obstruction and giving false statements to police. Both parents have been denied bond. These are some images from Pierce's Facebook page, posing with cars and jewelry. Police say Pierce is a drug dealer who claimed the kidnapping happened in an apartment he was using as a stash house south of Atlanta. And he claimed armed gunmen stole $6,500 in cash and 3 pounds of marijuana. Late Tuesday, police found Nakai's body behind the apartment complex. The victim's twin sister is now in state custody. We do need to take a break, and we're going to wrap up testimony in the Irish firefighter rape trial when we come back. And the jury has reached a verdict in the caught in the crossfire murder trial of Clarice Larry. That one's taking place in Wisconsin. We are still waiting for all parties to enter the courtroom, and we are under a court order delay of 15 minutes. But we will bring you the verdict as soon as we can. Keep it here on your front row seat to justice.
Tonight on Closing Arguments, Family Matters star Darius McCrary makes a bizarre court appearance facing felony charges. We'll dive deeper as our experts weigh in.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
We are still awaiting the verdict to be read in the Caught in the Crossfire murder trial. That one is taking place in Wisconsin. While we wait for that, we want to get you back to testimony in the Irish firefighter rape trial that's taking place in Boston. A detective with the Boston Police Department has been wrapping up his testimony. We do have a reminder that we cannot air the accuser's name, so you may hear your audio drop when that happens.
Okay, so now I'm playing that 6th floor video from a timestamp at 12:47 a.m. Is that what you were referring to about him going in the elevator?
Yes.
Now I'm going to move ahead about 7 minutes to 12:54 a.m. The direction where Mr. Crosby just walked, do you know what's further down that hallway?
I believe it's the other side of the hotel rooms that are to the right of that sign. So I think it's in this big U. Yeah, so I think that's another way to get to all the other rooms on the other side of the block.
Does Mr. Crosby, in the video, remain seated in that chair until approximately 1:55 a.m.?
Yes.
I'm going to skip ahead to the 1:55 minute mark. All right, so Detective, was the timing of Mr. Crosby's movements at 1:55 a.m. relevant to your investigation?
Yes.
And why was that?
The door interrogation logs also reflected activity of somebody keycarding into room 610.
At what time?
At 1:55, sorry.
Is there any other activity either for room 610 or for that room block in general for the next 20 minutes or so?
No.
So in the next 20 minutes, do you see Mr. Crosby again on this video?
No.
I'm going to jump ahead about 20 minutes to 2:16 a.m. Was that approximately 1 minute before she's recorded on video leaving the hotel via the School Street door?
Yes.
And according to the timestamp, is it about 2 minutes before she sent that text message to Daniel Jacobson?
Yes.
In reviewing additional video from the Omni Parker house, did you attempt to locate video of when Terrence Crosby had arrived at the Omni Parker house that night?
Yes.
And were you able to locate video of his arrival at the hotel that evening?
Yes.
Playing from the School Street door video, the 11:49:05 timestamp. I'm pausing here at 11:49:15. Is this the person who you believe to be Terrence Crosby entering the Omni Parker house?
Yes.
Is that the person who you noted walking toward that room block containing room 610 at 11:50 p.m.?
Yes.
All right, so I'd like to go back to the Black Rose video, having gone through the Omni Parker house video at this point. Have you reviewed the Black Rose video with an eye toward documenting Terrence Crosby's movements and his appearance that night.
Yes.
And in a later interview with the defendant, did he identify himself for you in video from the Black Rose?
Yes.
So from about 10:38 p.m. on, does Mr. Crosby sit with and interact with one person in particular?
Yes.
And who is it?
I don't know who that female was.
Understanding you don't know her name, do you know by seeing the video who she is? Not her by name, but like what she's wearing. Are you able to see who he's spending most of that time interacting with?
Oh, yes. Yes.
And as he's talking with that woman, do they end up kissing at one point?
Yes.
This woman in the black shirt here next to Mr. Crosby, does other video show him dancing and talking with her throughout the night until her departure?
Yes.
All right, so that's at 10:50 p.m. when that video just ended. About 15 minutes later, does video show Mr. Crosby going outside with that same woman, but then returning alone approximately 10 minutes later?
Yes.
Detective, at 11:12 p.m., is this when you observed Mr. Crosby re-enter the Black Rose without that same woman on the video?
Yes.
And after he comes back inside, does Mr. Crosby end up leaving the Black Rose on his own approximately 12 minutes later?
Yes.
And at this point in the video, do you see another interaction between Mr. Crosby and...
Yes.
Discuss defense attorney and former assistant district attorney Marie Pereira. Marie, thank you so much for being with us tonight. Watching this case out of Boston, you know, the defendant in this case, he says that he never even touched this woman. What's your takeaway from what we've been listening to so far?
I think the prosecution has a problem, and respectfully, I'm not saying that the rape didn't happen, but the lack of his DNA on her is a problem, because the first person she admits to consensual sex with, it's my understanding, they found his DNA. So if she's claiming that Mr. Crosby attacked her and didn't use a condom, penetrated, why is his DNA not on her body? That's a problem. It doesn't mean that it didn't happen, but the lack of DNA makes it a completely circumstantial evidence that requires some type of corroboration, credibility of the witness, and that is a big problem. And I think that's why they had a mistrial before, because when you think about a sexual assault, you think about DNA. She had physical tears to her personal area, but no DNA. Those tears could have been from rough sexual interaction. We don't know. It's a problem for the prosecution. But again, it doesn't mean it didn't happen.
Marie, so when we heard from the ER nurse, they talked about doing the rape kit, that they asked her some questions about who were her partners in the last 5 days. If she had had any consensual sex in the last 5 days, her response to that was one person. She had consensual sex with one person. And then when we talk about the DNA, so there's 2 DNA profiles found, but that one is with the man, consensual sex, but that other one did come back as inconclusive. The prosecutor still decided to try this case, got a mistrial the first time, and Marie decided to try it again. Would you have tried it again?
No, because the same problem still exists. You can't undo your facts. Prosecutors and defense attorneys, they're not magicians. Those are bad facts. Other than her word, and I'm not saying it didn't happen, we don't have proof beyond a reasonable doubt that he raped that woman. We don't know, because, and you know what's worse, inconclusive doesn't mean it didn't happen, but it does certainly create reasonable doubt if he's saying, I didn't do it. Did she said she was asleep. At least if there was DNA under her nails, if she had, a lot of physical damage to her body from a fight. She did outcry to her friend immediately, and she did go to seek medical attention, but the fact that his DNA was not found on her conclusively creates reasonable doubt enough that it might be hung again. Because I'm trying to listen to it from a woman's point of view with empathy for her. But still, with the reasonable doubt burden being so high, I don't see how the DA is going to prove that he absolutely is the one who did it beyond a reasonable doubt. Not with these facts. Maybe there's more coming out, but I'm looking at, mistrial again, in my opinion.
Yeah, we'll have to see what happens. Definitely an uphill battle for the prosecution on this one, Marie. Okay, thank you so much. We do need to take a break. When we return, we will have that verdict. This is in the case that we have been watching out of Wisconsin called the Caught in the Crossfire murder trial. Keep it here on Court TV Live. We're coming right back. And welcome back to Court TV Live. I'm Kelly Craft in this evening from Michael Ayala. Thank you for being with us. We do have some breaking news that's taking place out of Wisconsin. The verdict has been reached. This is in the caught in the crossfire murder trial of Paris Larry. Let's get you inside that courtroom now.
Please. Right, a couple of preliminary things before I call back in our jury. It's my understanding they have reached a verdict. I know we've got a number of folks in the gallery, some of whom have been here throughout the duration of this 2 weeks, some perhaps more recently. There are rules of decorum that I've touched on at many points in time. I understand that emotions may run high on both sides of the gallery here. There are a lot of significant issues tied to what this verdict is, and I understand that. But recognize that your behavior here in the courtroom, as well as outside of this courtroom, may have consequences that extend beyond what we're here to do today. Our jurors have spent the last 2 weeks with us. They have invested their time, their effort to make a decision according to the law that I have given them. So you will be respectful. This is a public courtroom. I would like to have everyone remain in the courtroom, but that means that you need to control those emotions. You need to respect the time that the jurors have put in and allow the court to get through that verdict, and be respectful of everyone else here in the courtroom as well, okay? And also, as a reminder, there are to be no cell phones. They are to be turned off, not silenced, not on vibrate, off and put away. Attorney Tony, anything before I call in the jury?
Your Honor, I would note we are in victim rights compliance and are prepared for the verdicts.
All right, thank you. Attorney Jensen?
Nothing further, thank you.
All right, let's bring in the jury, please. And I understand if we can't keep folks quiet, we do need to step out. Thank you, ma'am.
Yes, ma'am.
All right, we are waiting for the jurors to make their way back into that courtroom. You heard the judge really make it clear to everyone in there to respect the court's decorum. We had heard from our people on the ground there that there was a situation outside in the parking lot where a lot of people kind of got into a heated back and forth that was kind of in relation to this case. And you heard the judge talk about that emotions are high here. You're talking about a defendant who was 14 years old at the time, and then the victim in the case. You're taking a look at her there, 20-year-old Tatiana Zek. Let's go back in.
Welcome back to our jurors. Foreperson, has the jury reached a verdict?
Yes, we have.
All right, please hand the verdict and the jury instructions along with any exhibits that you've received back in the jury deliberation room to the bailiff, please. Marie, I want to bring you in here really quickly while the judge is taking a look and seeing exactly what's going to take place next before the verdict is read. Looking at the defendant there, he's a young man. He's 16 years old now, 14 years old at the time. Marie, just give me your thoughts as we await the verdict in this case.
It's a heartbreaking case all along, but the victim and her family deserve justice, healing, and peace, just like he deserves justice and a fair trial. They gave that to him. Let's see what the jury comes back with. But at the end of the day, I believe someone's going to have to pay for this death, and he may be found guilty. Despite of his young age at the time, life was lost.
Yeah. Yeah, I would assume that's going to be the situation. We'll have to see. I know the prosecutor in the closing mentioned the fact that he is young, that he was 14 years old at the time, 8th grade when the shooting took place, and he was attending special education classes at the time of the shooting. Went over to this apartment complex area. Tatiana was having a cookout. She had been living, she went to Chicago for a while. She went to Chicago and then ended up moving back to Wisconsin because she felt that it was getting a little bit too dicey in Chicago. Comes back to Wisconsin and then unfortunately has this situation happen. Let's go back in. We actually have a minute yet before that verdict is read, Marie. So, but yeah, I mean, to think about it, she was in Chicago and then feels like she wants to leave Chicago to go to Wisconsin because she wants to go back home where she felt the city of Chicago was too unsafe. Returns to Wisconsin, and this is what happens.
You would think that youth violence, gun access would be less in a rural place like Wisconsin, but apparently not. Violence is everywhere. It's access to guns that's the problem. I think there needs to be more legislation controlling who has access to these guns. He was in the 8th grade. Can you imagine?
Yeah.
An 8th grader being with a... It's terrible.
Let's go back in.
Right, I will now read the verdicts. We, the jury, find the defendant, Parise Larry, guilty of first-degree intentional homicide as a party to a crime as charged in count 9 of the information, dated the 17th day of October, 2025, and signed by the foreperson. If you find the defendant guilty, answer the following questions, yes or no. Did the defendant commit the crime of first-degree intentional homicide as a party to a crime while using a dangerous weapon? Yes. Did the defendant commit the crime of first-degree intentional homicide as a party to a crime in a school zone? Yes. As to count 10, we, the jury, find the defendant, Parise Larry, guilty of attempted first-degree intentional homicide as a party to a crime as charged in count 10 of the information, dated the 17th day of October, 2025, and signed by the foreperson. If you find the defendant guilty, answer the following questions, yes or no. Did the defendant commit the crime of attempted first-degree intentional homicide as a party to a crime while using a dangerous weapon? Yes. Did the defendant commit the crime of attempted first-degree intentional homicide as a party to a crime in a school zone? Yes. As to count 11, we, the jury, find the defendant, Parise Larry, guilty of first-degree reckless injury as a party to a crime as charged in count 11 of the information, dated the 17th day of October, 2025, and signed by the foreperson. If you find the defendant guilty, answer the following questions, yes or no. Did the defendant commit the crime of first-degree reckless injury as a party to a crime while using a dangerous weapon? Yes. Did the defendant commit the crime of first-degree reckless injury as a party to a crime in a school zone? Yes. As to count 12, we, the jury, find the defendant, Parise Larry, guilty of first-degree recklessly endangering safety as a party to a crime as charged in count 12 of the information, dated the 17th day of October, 2025, and signed by the foreperson. If you find the defendant guilty, answer the following questions, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety as a party to a crime while using a dangerous weapon? Yes. Did the defendant commit the crime of first-degree recklessly endangering safety as a party to a crime in a school zone? Yes. As to count 13, we, the jury, find the defendant, Parise Larry, not guilty of injury by negligent use of a dangerous weapon as a party to a crime as charged in count 13 of the information, dated the 17th day of October, 2025, and signed by the foreperson. As to count 14, We, the jury, find the defendant, Paris Larry, guilty of first-degree recklessly endangering safety as a party to a crime as charged in count 14 of the information, dated this 17th day of October, 2025, and signed by the foreperson. If you find the defendant guilty, answer the following questions, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety as a party to a crime while using a dangerous weapon? Yes. Did the defendant commit the crime of first-degree recklessly endangering safety as a party to a crime in a school zone? Yes. As to count 15, we, the jury, find the defendant, Paris Larry, guilty of first-degree recklessly endangering safety as a party to a crime as charged in count 15 of the information, dated this 17th day of October, 2025, and signed by the foreperson. If you find the defendant guilty, answer the following questions, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety as a party to a crime while using a dangerous weapon? Yes. Did the defendant commit the crime of first-degree recklessly endangering safety as a party to a crime in a school zone? Yes. As to count 16, we, the jury, find the defendant, Paris Larry, guilty of first-degree recklessly endangering safety as a party to a crime as charged in count 16 of the information, dated the 17th day of October, 2025, and signed by the foreperson. If you find the defendant guilty, answer the following questions, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety as a party to a crime while using a dangerous weapon? Yes. Did the defendant commit the crime of first-degree recklessly endangering safety as a party to a crime in a school zone? Yes. As to count 17, we, the jury, find the defendant, Paris Larry, guilty of possession of a dangerous weapon by a person under 18 as charged in count 17 of the information, dated the 17th day of October, 2025, and signed by the foreperson. I have unsigned versions of all alternative verdict forms for each of those counts. Madam Clerk, if you could publish these to the parties, please.
Well, we just heard the verdict. In this case, we've been following out of Wisconsin. Guilty, of course, on most every single count except for just one, but that first-degree intentional homicide, which carries with it a life sentence. We will get you back to more coverage of the verdict in that case, the Caught in the Crossfire murder trial, when Court TV Live returns.
Tonight on Closing Arguments, Family Matters star Darius McCrary makes a bizarre court appearance facing felony charges. We'll dive deeper as our experts weigh in.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Donna Edelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
A jury in Wisconsin just returned nearly all guilty verdicts in the caught in the crossfire murder trial for Paris Larry. And let's get you back into the courtroom.
Line count.
The court will enter judgment on the verdicts as it relates to count 9, 10, 11, 12, 14, 15, 16, and 17. The court will enter a judgment of acquittal as it relates to count 13. Given the convictions here today, the court is going to revoke bond. I would like to have a PSI ordered, and we can schedule sentencing. Attorney Tony, do you want to schedule that now?
I think while we have the parties here, that would be wise.
How much time are you anticipating? Do you know if you have a number of victims that would wish to be heard at sentencing?
Can I have a moment to check him back, Your Honor? Thank you. Thank you, Your Honor.
Your thoughts on timing?
I know we'll have some that will wish to speak at sentencing. I would say probably 2 hours at minimum to be on the safe side.
So probably looking at a full morning or afternoon to be safe?
Certainly that would, I think, easily fit within.
Attorney Jensen, and it's all right if you don't know, but are we anticipating a number of speakers on behalf of Mr. Larry that I should build in time for?
Yeah, I'm sure there will be people who want to speak on his behalf, but I personally like to keep it at no more than 2 or 3.
So the time frame suggested by Attorney Tony, does that work for the defense?
Yes.
All right, let me go off the record while I look at dates a moment.
All right, what we're hearing is that the sentencing date has been set for December 19th. You see that at the bottom of your screen. Why don't we go ahead and bring in Marie Pereira, former assistant district attorney, to talk about just, Marie, your reaction in general, looking at the defendant there. Obviously, we had a young woman. Her life was lost in this situation, so very tragic for her and her family. And then, and tragic on both sides, because what I've read about this case, the young man, his uncle had gotten him into mentorship programs to prevent something like this, to prevent him from getting involved in bad activity. And now here we are.
It's really sad to see him sit there. He looks like he's in shock. Like his hands were going like this. He's leaning back, almost like, why is this happening to me? He's 14 at the time when that happened. His brain was not even fully developed. His prefrontal cortex, responsible for judgment, impulse control, is not even still developed. He succumbed to peer pressure, and he ended up with a gang of people who were shooting at each other, and then this woman died. His age tells me that he did not intend to say, I'm shooting this woman, but the degree of recklessness that led up to this, the outcome is just for the victim's family, because at the end of the day, that 20-year-old girl is dead. And he was a part of the mechanism causing her death. They had photographs of him in that pink hoodie running around with the gang of boys the whole day from this place to that place. So he couldn't even say, I was there, and my mere presence is not enough to charge me with first-degree intentional reckless murder. He couldn't do it. The facts were there. He was a part of that gang. And at one point, I believe he even was seen with a weapon in his hand. And then afterwards, he showed up acting like he had nothing to do with it, and he was a part of the people looking at the crime scene, part of a crowd. All of that had to touch the jurors, and they had to say 14 years or not, old or not, poor impulse control, peer pressure, whatever, someone's dead and you're going to have to pay for it. I think all of what we discussed just now will come into play when it's time for sentencing as part of a mitigation package to maybe try to touch the judge's heart to say there's a chance for rehabilitation. Please don't make it be a situation where there's no parole. There is hope for him. A mitigation package is going to explain his age and everything else, all the issues.
Yeah, we heard defense counsel there say that he does anticipate maybe having 2 or 3 people speak on behalf of the defendant, and then obviously a number of people will be giving victim impact statements on behalf of Tatiana Zek. You know, one of the things, Marie, the prosecutor used was this live video that the defendant posted in which he was saying, I want to go pipe for pipe and gun for gun with this person. So there was this situation going on over a chain, and they kind of had a disagreement. Somebody was, I guess, making fun of the chain that he had been wearing, and then they go and he ends up shooting that gun into the air, and you use that phrase, degree of recklessness. You can't just go and just shoot up in the air, and then there were tons of people around, and someone lost their life.
And this is why the jurors have spoken. It should be a deterrence to people who think you could be part of a gang and then get away with it because it wasn't just one person who caused the death, because you were just a person who was just a part. If you're a part of a situation where there's violence, guns, knives, fists, and someone gets hurt, you will be charged equally as if you conspired with everyone else there to commit that crime. And that's the bottom line. It's a message. And the problem in this society is the access of these young people to guns. It's more like a systemic problem. Why does he even have a gun? Legal or illegal? We need to do better with that. And that's the problem. He was 14 years old, Kelly, like you said, in the 8th grade, with no common sense whatsoever, but he's being treated like an adult because you know what? A life was taken. I don't disagree with the jury. Sad for everyone, but justice served.
Yeah, justice served. Marie, thank you so much for your excellent insight tonight. We thank you for being with us. And coming up next, we review the 3 things that we have learned today in the cases we have been covering from coast to coast here at Court TV. three things that we have learned this Friday. First, a verdict has been reached in the caught in the crossfire murder trial for Paris Larry Jr. He was just 14 years old when prosecutors say that he was involved in the shooting that killed 20-year-old Tatiana Zek. After deliberating for 2.5 hours, the jury found Larry guilty on all but one count, including the most serious count of first-degree intentional homicide. He does face a mandatory life in prison at sentencing that will take place on December 19th. Second, lawyers for Luigi Mangione have asked a federal judge to either dismiss the indictment or take the death penalty off the table. Mangione is accused of killing United Healthcare CEO Brian Thompson in December of 2024. Mangione's defense team says the Trump administration is making him a, quote, pawn to further its political agenda and posting statements about him that are prejudicing his prospects at a fair trial. And third, Dan Markel's parents, they are firing back at what they called disrespectful and delusional statements made at Donna Adelson's sentencing. Adelson was sentenced on Monday to life in prison without parole after her conviction for masterminding the murder for hire that killed Dan Markel, her former son-in-law. In their statement, Markel's parents said, contrary to Donna's claims, she never mourned the loss of Danny's life or expressed concern for his sons losing their father. I'm Kelly Craft. It has been a pleasure being with you on this Friday evening. Up next, Melissa Dohm agreed to meet a former boyfriend for one last hug before they broke up, and it nearly cost her her life. 48 Hours investigates the growing dangers of dating and breakup violence. Then it's closing arguments with Vinnie Politan. That starts at 8 p.m. Eastern. Vinnie takes a deeper look into the court appearance for Family Matters actor Darius McCrary. And Vinnie takes a look at the alleged victim's testimony in the Irish firefighter rape trial. Keep it here on Court TV, your front row seat to justice.
Closing arguments, Family Matters star Darius McCrary makes a bizarre court appearance facing felony charges. We'll dive deeper as our experts weigh in.
Closing arguments tonight at 8, 7 Central, only on Court TV.
Tonight on Closing Arguments, Family Matters star Darius McCrary makes a bizarre court appearance facing felony charges. We'll dive deeper as our experts weigh in.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Arguments, Family Matters star Darius McCrary makes a bizarre court appearance facing felony charges. We'll dive deeper as our experts weigh in.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Star Darius McCrary makes a bizarre court appearance facing felony charges. We'll dive deeper as our experts weigh in.
Closing arguments tonight at 8, 7 Central, only on Court TV.
Terrence Crosby, a firefighter from Dublin, came to Boston to be part of the St. Patrick's Day parade, but now faces serious rape charges and is on trial on Court TV. During opening statements, prosecutors described surveillance and DNA evidence suggesting Crosby returned to the victim's hotel room and assaulted her while she was asleep. The defense counters that the accuser gave consent to another man and argues the DNA results are not conclusive. As witnesses take the stand and the courtroom pulses with tension, the accuser herself tells her story. Who was in that room and what really happened? Meanwhile, in Philadelphia, the search for 23-year-old Kata Scott has turned from desperate to chilling. The aspiring Miss USA hopeful vanished after her shift at a Philadelphia assisted living facility, leaving her car, phone, and belongings behind. Detectives say surveillance footage and phone data led them to 21-year-old Keon King, now charged with kidnapping. Police believe evidence found near an abandoned school may hold the key to finding Kata, but tonight her whereabouts remain a heartbreaking mystery. But first, he was once one of America's favorite sitcom sons, Darius McCrary, who played the wisecracking Eddie Winslow on the 90s hit series Family Matters. Fans remember his charm, his grin, and his chemistry with the ever-lovable Urkel. But this week, McCrary made headlines for a very different reason, appearing in a California courtroom, not as an actor, but as a defendant. He chose to represent himself, standing before the judge without an attorney by his side. The once beloved TV star seemed determined to take control of his own story. But what happened next in court surprised everyone. I'm Benny Politan. Thank you so much for joining us tonight here on Closing Arguments. We've got a big hour ahead of us. And I want to begin here talking about, something important. I think family matters to all of us, doesn't it? Right? Whether you're, you think about your parents, your siblings, and then when you get older, your spouse, your children, and then if you're fortunate enough, your grandchildren. At the end of the day, isn't that what is really important? And I think that was part of the draw of this iconic 1990s sitcom called Family Matters. You may remember Urkel as the star, but did you remember Eddie Winslow, who was played by Darius McCrary, who was the older brother and sort of, there was that tension, the back and forth between him and Urkel. And they became part of our lives. For those of us who were watching TV in the 90s, it was an iconic show. And a lot of lessons were learned by young people watching that show. But the theme was so important. Dad was a police officer, and everyone at the end would always come together. Now, here's what I'm wondering tonight. I wonder if family matters to Darius McCrary. Why? Because apparently there's a warrant out for him for unpaid support. Child support. You have a family, you take care of your family. That's your responsibility. You don't run away from it. And it seems that maybe the allegation here from prosecutors that he was running away from his obligations, because his obligations were in Michigan and he was on his way to Mexico south of the border, is now in custody in California. And it's this problem in Michigan, these family matters in Michigan, that have put him behind bars and in jail. That's where we are. He gets arrested, the warrant's out, he's in one jurisdiction, they want to get him extradited to another jurisdiction. So it's a hearing, and you've got to appear in front of the judge. And most people have counsel. But Darius McCrary wanted to represent himself. We are going to show you exactly what happened and how that went for the man who was in our living rooms for a decade as Eddie Winslow, now as Darius McCrary, defendant. Take a look.
as relates to the complaint, sir, are you prepared to go forward with your arraignment?
Yes, Your Honor.
Please do so.
I wanted to call attention to the emergency motion that I filed. Based on the fact that the 50th District has completely continued to violate all of my rights, my 4th, my 5th, my 14th Amendment, my right to due process is constantly trampled, and I've figured out why, because under due process clause of the 14th Amendment, personal judgment is void if rendered by the court, which has no jurisdiction over the defendant. That's Penmore versus Neff, 95 U.S. 714, 24L, ED 565, and Michigan has no jurisdiction. Before we proceed, we need to establish jurisdiction. It's imperative that we establish jurisdiction.
People.
Your Honor, the people would argue that this motion is not relevant to the proceedings before the court, that it is now time to either admit guilt or not guilt as to the fugitive complaint that the people have filed.
Okay, thank you. Sir, did you care to respond before the court rules on your motion?
There's no injured party, Your Honor. Oh, I'd like to also say I'm here in special appearance.
Special appearing for who?
I'm here on special appearance.
Sir, who are you specially appearing for?
I'm specially appearing for Darius McCrary. I'm here pro per special appearance.
And when you say you are here pro per and special appearance, who are you?
I'm an authorized signatory thereof of the estate, an executor of the estate.
Who's the estate?
The McCrary estate.
And your name is?
Darius. I'm the authorized signatory thereof, Darius McCrary.
And your name is?
Darius McCrary.
Okay, thank you. Anything else as it relates to your motion?
I would also like to add that there's been, as far as Corpus Deliceti is concerned, I wanted to know who's the injured party.
The court finds that the issue before this court is the issue of extradition. This court is not the demanding state where many of these issues raised by the defendant may be relevant. This court is tasked with ensuring that the defendant is returned to the demanding state. That will happen either one or two ways. He will waive extradition or he will plead not guilty to the complaint regarding extradition, at which time a governor's warrant will be provided to the court at a later date. Those are the things that this court is tasked with deciding at this point in time. If you have any issues regarding the charges pending against you in the demanding state, then you may raise those in the demanding state. The thing before the court today is the extradition and the extradition only. As it relates to the extradition, is there anything else?
Well, Your Honor, is it possible that we could discuss a bail?
Bail arguments are heard after the entering of a plea has taken place. Again, as it relates to the extradition, are you prepared to proceed?